Profound respect and under compulsion, my lord, may I
Yes.
mention three matters, my lord, of senior citizens.
Hand over. Please hand over this.
Lordship, may I be permitted to mention one matter? It is appearing as in monthly list item number 238. There is some urgency praying for upgradation.
Hand over the slip. Yes.
So for inclusion in the list.
My lord, for correction of my lord's order.
Lordship paying for upgradation. It's in monthly list.
Hand over.
May I, Your Lordship, find leave to mention item number 132 of the today's list. The matter relating to cotton property under Chotunaku Tenancy Act, order passed by the collector. Now, that suit is pending. I applied for the certified copy. But almost a year has been passed to not get the certified copy from the collector. We are only paying that the necessary direction from the collector so that I can get the certificate.
This will appear at the top tomorrow.
On 138 to 2 of
Give a write a slip.
My lord,
I
I
will
permitted to mention one upgradation, my lord.
Hand over the slips. All the slips. Yes. You also hand.
My lord, kindly, it's an urgency, my lord.
Hand over the slip.
My lord, today is the date of auction, my lord.
Nothing doing. Today nothing can do. Yes, call on the list.
Item number 1.
Yes. My lord, there is inadvertently at a cost. There is an error in cost title.
Yes.
One is
I-
respondent number 5 and 6. In case of 5, there is a written Shubhojit. It should be allied.
Cost title of the writ petition. It has been it has not been disposed of.
No, not be disclosed.
Oh,
It will be allied Shubhodip.
you want to rectify the cost title?
And another error is there.
In the cost title?
There only cost title.
On the prayer of learned counsel for the petitioner, leave is granted to the learned advocate and record for the petitioner to carry out the necessary amendments to the cost title of the writ petition during the course of the day. Push up, let the matter be listed in due course in the next monthly list.
I will oblige to that.
Item number 2. In this matter, I am petition. Well, it is a group 2 matter.
Learned counsel for the petitioner submits that the matter pertains to group 2, pushed up. Hence, due to lack of determination, let the matter stand released from my list with liberty to the parties to mention for inclusion before the appropriate bench having determination.
Item number 3. For the petitioner, my lord.
I am for the respondent, Lordship. I filed one application on 3 points. He is pray for
Application for what?
Lordship, that this court has
Application for what?
for further out, this court has no jurisdiction. First point, 3 preliminary objections I raised. In the writ, this court has no jurisdiction. Second point, that disputed affair cannot be decided in the writ jurisdiction. And third, the land is taken over by the government of India. Lordship fixed, Lordship, any day extension is I am no opposing of extension.
I understand.
I am no opposing extension.
30th of
I am
November,
not
my lord.
opposing extension.
The
Lordship,
entry model
but-
is
I'll on some date. He's right. Where is your application?
Lordship, file maybe another court, Lordship, page court number 2.
At the time of hearing the matter for extension of interim order, learned counsel for the you are for respondent number?
Respondent number 2, Lordship.
2.
2 to last lot, Eastern Coalfield Limited.
Learned counsel for the Eastern Coalfields Limited takes certain objections as to maintainability of the writ petition and jurisdiction. First up, the said points shall be adjudicated along with, at the time of final hearing of the writ petition. First up, the interim order granted earlier is extended till January 15, 2024 or until further order, whichever is earlier. First up, the matter be listed under the heading upgraded matters on December 18, 2023.
There is no, it is
Only one.
before 18 or after it, Lordship, after vacation, Lordship.
Before vacation.
No, after vacation, Lordship. 18 and 9 some. 18, okay, 18.
No, very after vacation, no difficulty. Then the interim order will be till disposal.
Lordship, no problem. I have no problem.
Very well.
But there is no direction for if Lordship. The problem is this.
I'll direct.
Lordship.
I cannot keep I cannot keep any grievance on your part.
Lordship.
তাহলে এই অর্ডারটা কেটে দাও
হ্যাঁ।
কেটে দিয়ে নতুন করে করো at the time when the matter is taken up for hearing
I know, Lordship.
for the purpose of extension of interim
If
order.
you lost before lost, I will certainly grateful, Lordship.
Thank you. Comma,
I know
learned
that.
counsel for the respondent numbers, learned counsel for the Eastern Coalfields Limited takes certain objections as to maintainability and jurisdiction. Pushed up, the said points shall be decided at the time of final hearing of the writ petition. Pushed up, let the interim order granted earlier stand extended till disposal of the writ petition. Pushed up, the matter be listed under the heading upgraded matters on January 9, 2024. 9th January 2024.
Lordship.
Not only one thing, they were supposed to bring the documents even to show that they are the.
আচ্ছা না affidavits এর direction টা রেখে দাও
Extend-
affidavit in
extend-
opposition affidavit in opposition shall be filed by December 15th
Lordship.
2023. Full stop, reply if any shall be filed on the next returnable date. Grateful, my lord.
Lordship. Grateful.
Whatever you have to annex the documents, please annex.
Lordship. Lordship.
Grateful.
Grateful.
Thank you. Next.
Upgraded.
My lord, I am for the petitioner.
When does it expire, Mr.?
1st of December, my lord.
I am for the state response on behalf of.
Very well. Interim order granted earlier is extended till disposal of the writ petition. Full stop. The matter shall be listed monthly list of January. Listed for hearing in the monthly list of January 2024.
My lord, in this matter, no directions for affidavits have been
Very
given.
well.
It was
Affidavit in
the
opposition.
bench.
Affidavit in opposition shall be filed by the respondents within December 15, 2023. Reply, if any, shall be filed on the next returnable date.
My lord. Deeply grateful.
My lord, I appear for the writ petitioner, my lord. Writ
Yes, sir.
petitioner, petition is directed against West Bengal State Electricity Distribution Company and its officers, my lord.
Right.
My lord, I have served everyone.
Yes.
My lord, my main grievance is, my lord,
Affidavit of service you have filed?
I filed.
Yes. Affidavit ta din.
Affidavit, everyone has been, I think my learned friend is appearing.
Yes. What is the matter, Mr. Mal?
My lord, it's my lord, simple, my lord, non-payment of electricity bill. My lord, disconnection has been effected. My lord, as per their bill, my lord, the due is to the tune of 6,79,323 at page 26. Page 26, my lord, this is their bill. My lord, next page 27, lordship sees, my lord, there is no meter reading. My lord, this is the board they maintain. This is the slip they maintain at the supply point. My lord, there has been no entry made by the reading officer who takes a reading of the meter.
This,
How-
Mr. Mal, you have to take. This is factual question is involved here.
No, my lord, I want to pay, I want restoration, my lord. I have addressed a letter which is at page 28.
You have a right under the law to do that. I mean, if you
Yes, they have refused. Page 28, my lord, I offered them the money, my lord, with a span, my lord, in 3 installments, which they refused, my lord. I want to pay, my lord. Let it be. It's a hatchery business, my lord. I have to run with generator. That's adding to the cost and also pollution.
this connection was under 56. Usual disconnection.
Yes, although it's a usual disconnection, but there is a suppression of material facts. Why I'm telling you? Kindly give me 5 minutes time, Lordship. May I hand over certain documents? I'm the checking. One who seeks security must come in the court with a clean hand. What happened, Your Lordship? There is a not only fraud upon the WBICDCL, but also on the court also.
Then you have to file affidavit in opposition.
Yes, sir, because what happened, but I am showing to Your Lordship. Lordship, kindly come to page 1 of the document which I have given to Your Lordship.
Yes.
Kindly see, this is the application.
Yes.
In the application, for the timing, kindly come to the Aadhaar card number for the timing. Kindly take a note on the Aadhaar card number.
Yes.
Lordship got that? Now, Lordship, kindly come to page 6. This is the Aadhaar card number. Page 6, where the father name appear. Page 6. I'm sorry, son.
Father name?
Father name is Topon Shah. Lordship, now, pausing here for a moment, I will show certain other document also. Kindly come to.
What is that? Documents are not telling.
Not only telling, Lordship, I will show why they have done so. There is
Tell me the nature of the grievance.
fact is that there is one hatchery business, mother hatchery business in the name of Gautam De. Now, there was a huge outstanding dues of almost at present 70 lakhs. Now, in order to evade that liability, there was a disconnection of that line. Now, this lady has come into picture with a leave and license agreement. Kindly come to page 9 of that document which I am showing to you, Lordship.
Formulate your question.
But in this leave and license agreement, where she has specified she will do only Garment business.
That's not
No, that's not my business. No.
Trade license is
Man,
hatchery,
kindly appreciate. Man, I will show that trade license also of the garment. But the thing is,
if the hatchery pays for the electricity, you
no, there was, in order to evade the, kindly appreciate it, there was a hatchery business, there was a 70 lakhs liability, that line was disconnected. Thereafter, these Gautam De, they are related to each other. This Gautam De is, I have been informed that is the father-in-law of this
lady.
This lady, and showing at the initial stage that she intends to do the garment business. She has made an application and we have given the connection.
So you say there's a collusion.
And we have given the nexus letter also to her, that this is the nexus letter also I have handed over to your lordship. In this nexus letter, it has been specified.
If they have a grievance, they have to go before the GRO.
Lordship, that can be done.
Somehow you have to go.
Lordship, one thing.
But there is a
Page
separation.
19. Page 19.
No, we cannot go into that dispute in writ court.
I am paying whatever is their
No,
claim against
payment is
me.
not.
Whatever is their claim against me,
19, you said page 19.
page 19, my lord.
Yes, Dr. Shah, have you made those extra claims? The 70 lakh.
Yes. I have given that letter.
Page 19.
Kindly
lordship
see this
says,
letter.
my lord,
The nexus
description of-
letter I have handed over to
You have served this on the
Yes.
No.
We have served a letter on
At order.
20th.
Learned counsel for the petitioner submits that the petitioner's electricity connection for running the petitioner's hatchery business has been disconnected, allegedly due to non-payment of electricity charges, which of the petitioner is willing to pay such amounts and have the connection restored. Which of, however, the petitioner has sought for certain installments. Which of next para, learned counsel appearing for the WBSCDCL places reliance on certain documents, copies of which are handed over in court today, to indicate that there are serious allegations of suppression of material fact against the petitioner, which it is submitted that the petitioner's father-in-law had kept certain huge dues, which are required to be paid by the petitioner for getting a restoration. That apart, the WBSCDCL has already intimated the petitioner to pay such dues for getting the reconnection. Learned counsel for the petitioner submits that he does not have instruction regarding such communication. Be that as it may, since serious allegations have been made regarding non-payment of huge dues by the petitioner, it is beyond the scope of the writ court to decide such factual questions which entail appreciation of evidence. In any event, since the regulations provide that the concerned grievance redressal officer is the appropriate forum to decide such disputes, WPA 26168 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned GRO to have the disputes resolved. If so approached, the GRO shall decide all issues in accordance with law independently without being influenced in any manner by any of the observations made herein, preferably within 8 weeks from such reference being made. No address to cause any.
Lord, only one thing, my lord. Even
Yes,
the
Mr.
communication they show, they are asking me to pay 5,41,000.
No,
And
see,
they are saying there is one mother hatchery. I am requested to pay that amount. My lord,
Nexus has to be seen, Mr. Mal. That is why he relegated to GRO. Nexus we cannot decide here unless it's obvious. They say there's a nexus, you say.
was there claim against me? I was ready to pay, my lord.
If there's a nexus, if somebody else also, that's the law, regulations provide that. Next one.
Item number 6.
Lordship, I am for the petitioner.
Yes, Mr. Paul.
My lord, I have instructions to appear for the respondent. My lord, may I have leave to appear virtually, my lord?
Yes, absolutely.
My lord, may I make a preliminary submission? My lord, I have been requested by the respondents to appear just 15 minutes ago. But what I have been instructed, the tender process which is under challenge in this writ petition, that has already been called off, my lord. And yes, my lord, that is what I have been instructed by the respondents, my lord.
Election process.
Election, if that has been called off in its entirety, then I can record that and dispose of the writ petition as infructuous.
My lord, what they have instructed is that they are going for a fresh tender. So, my lord, my request would be as this instruction is purely over phone. may I present before your lordship physically tomorrow? May I get a day's accommodation just to receive that instruction formally?
I'll record your submission. Learned counsel at the outset, comma, when the matter was going to be moved by learned counsel for the petitioner, comma, you are Mr. Srinjoy Das.
My lord, my lord.
Mr.
Yes.
Srinjoy Das, having instruction to appear for the respondent, submits that he has got verbal instructions that the tender stroke selection process which has been challenged in the writ petition has been called off and a fresh selection process shall be initiated. Full stop. However, comma, in order to enable said learned counsel to take positive instructions in writing on such count, comma, a day apostrophe s adjournment is sought, full stop. Keeping in view such submission, comma, the matter is adjourned till tomorrow when it will be listed at the top of the list. Thank you.
I'm
Please
grateful, my lord.
Task with written instructions.
My lord, my lord.
Email, whatever. I mean, yes. Next.
I'm grateful, my lord.
Yes.
Item number 7,
Yes.
my application.
Yes.
My lord, I appear for the development, the
But we've served upon the authority.
let him place it. I have just received it about 5 minutes back. This is the volume.
Yes, Mr. Banerjee, where is this affidavit, sir?
My lord,
Yes.
kindly have a look at the volume of the writ.
Yes, Mr.
It will
Banerjee.
be on a question of law. So,
Yes, yes.
Mr.
What is the
Bihani,
question?
that shouldn't be a problem. My lord, on the authority we've served
Yes.
and the association we've been able to serve. The others we've not served, my lord, we've not been able to. We've played for dispensation of Rule 26. The urgency I'll indicate the order under challenge is an order passed by the RERA authority, which is of 6th of November, which we've received thereafter. We've been given 7 days time to give a written response after the complaint has been formally admitted, which is the challenge that the RERA Act does not apply. So that's the scope of the challenge here.
Take that point before the RERA authorities.
But I was preparing on that point of
Yes,
maintainability.
yes.
But your lordship will just consider one section, and there are some judgments which say that clearly, and also their own notification which says that the RERA Act is inapplicable to these projects. So where the authority, the Act does not apply, the authority probably
Show me
does
that
not have.
section.
Yes, I'll
Yes.
just show that section.
Section
Where-
and then notice.
Yes, just 2 things that I'll indicate. Needn't be trouble with the papers. I'm the developer. There are approximately, let's say, 13 or 10 odd towers. Each tower gets developed phase-wise. Each tower gets a completion certificate also phase-wise. So towers that have received a completion certificate by dint of Section 3 of the RERA Act, these are not covered under the Act at all. There's a complaint that precedes the complaint made by the association to the authority. A letter is written to me where complaints range from 2013 onwards till the date of filing. Then this complaint is made before the RERA authority, which is composite complaint in respect of all the towers. 2 things I'll just indicate, facts, all that these I'll indicate. Kindly have a look at Section 3. It to Judge Sahib ke din na, please.
কোন সেকশনটা রে বাবা?
হ্যাঁ
কি করছে? Section 3, Mr. Banerjee.
Yes, my lord, 3.
বাবু আসুন, আসুন এখানে। এবার আপনি আসুন। হ্যাঁ।
Registration of real estate project and registration of real estate agents. Prior registration of real estate projects with real estate regulatory authority. No promoter shall advertise, market, book, sell, or offer for sale or invite persons to purchase in any manner any plot, apartment or building, as the case may be, in any real estate project or part of it, in any planning area without registering the real estate project with the real estate regulatory authority established under this Act. First proviso. Provided that projects that are ongoing on the date of commencement of this Act and for which, this is important, my lord, for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this Act. Disregards the rest of it. Kindly have a look at 2. Yes. Notwithstanding anything contained under subsection 1, no registration of the real estate project shall be required. B, your lordship will have a look at, where the promoter has received completion certificate for real estate project prior to commencement of this act.
So Banerjee, is it the case that your property is a composite property? Some are completed, some are not.
Yes.
So there you will want to draw a distinction between that?
Yes, the explanation.
Yes. For the purpose?
For the purpose of this section, where the real estate project is to be developed in phases, every such phase shall be considered a standalone real estate project, and the promoter shall obtain registration under this act for each phase separately. So now this is covered by judgments across the country. I'm carrying most of them.
Section is clear.
Section is clear that
Yes.
where that explanation clarifies this query that fell from your lordship.
Yes.
The explanation, in my understanding, clarifies
The
it.
notice given to you pertains to completion certificate, completed towers.
Yes. Clearly.
All the
towers. So that's the aspect of jurisdiction. Now the Supreme Court has held, several high courts have held, and if I may just add, we're slightly buoyed by the fact that a similar matter was taken up before your lordship. Mr. Kishore Datta was arguing. I had looked at the draft because I had drafted it. Later I got removed. But then, well, there also your lordship has granted a stay because this question of law has come up.
Yes, Mr. Bihane, what do you say?
What I tell you, Lordship? Whatever little I could have catch.
Well, one before your lordship will call him up because he's got it 5 minutes back. I also should be fair to him. Lord, kindly have a look at this one notification. এটা পড়ে আপনাকে দিয়ে দিই আচ্ছা চলে আছে
কোনটা
এই
3rd February যেটা জানুয়ারি 31 থেকে হবে আমি আবার
নিয়ে নাও তো
থ্যাংক ইউ
Well, this is 3rd February 2023, whereas the website of West Bengal Real Estate Regulatory Authority has been launched on 31st January 23 and subsequently registration of projects is commenced thereunder. Now in exercise of powers conferred under so and so, kindly have a look at the body of the notification. Projects in the state of West Bengal. This is important, Lord, that are ongoing on the date of commencement of the website of RERA, that is on 31st January 2023, and for which the completion certificate or occupancy certificate, as the case may be, has not been issued, the promoter shall make an application to the RERA authority for registration of the said project within a period of 3 months from the date. Lord, I'll indicate one thing. When I drafted the writ petition, I did not have this notification. So I prepared it on the basis that there are X number of towers, let's say 10, out of the 7 have received completion certificate, 3 have not received. So we prayed for a declaration that with regard to 7, RERA doesn't apply. But now with this notification, prior to 31st January 2023, all towers had received completion certificates before that. So the project as a whole, now the explanation also the court doesn't have to be troubled by. The project as a whole, by dint of this notification, stands outside the purview of the act. And as how I have understood the law, and your lordship will test that by dint of 2 Supreme Court judgments, that one in respect of RERA, that this adjudicating authority will have no authority or jurisdiction to receive a complaint in respect of projects which have received completion certificate. Because of the section, it's a creature of the act. If the act doesn't apply, now it's my legal submission that the act doesn't apply, then I should not be compelled to go to the authority under the act to espouse this cause. To buttress this, there's another judgment which says when a question of law, apropos jurisdiction and applicability of act is brought in, then the High Courts under 226 will adjudicate that issue. So two-pronged submission, my lord. If the act doesn't apply, a creature under the act can't determine it. And this complaint, this 6th November, he's admitted the complaint straight away, without even adverting to the question whether by dint of this notification it at all has jurisdiction to receive, far less try.
Yes, what do you say? If it's an arguable question, I'll direct affidavit.
Yes, but Lordship will kindly take whatever little I can. Kindly take section 31 first.
That is correct. That is the one under the complaint has been made.
Yes. Well, kindly take section 31.
31.
My lord, any aggrieved person may file a complaint with the authority or the adjudicator. So there are 2. It has been filed before the authority, as the case may be, for any violation or contravention of the provisions of the act or rules or regulations made thereunder against any promoter or authority. So, my lord, my first submission is, and this complaint has been made under section 31. So, under section 31, any complaint can be made before the authority. It does not per se limit it. The section does not limit it to the registration and or violation. It can be pertain to anything, any complaint against the promoter. Lordship has seen that. Now, my lord, kindly take section 3. My learned friend was placing section 3. Lordship, is that section?
No, this is section 31 is for any violation or contravention.
For any violation.
Violation or contravention of the provisions of this act or the rules.
Yes.
So if this act does not apply, then how can that come in?
I'll come to that.
Yes.
So, my lord, firstly, a complaint under section 31, my lord, in my actual submission can be made by any aggrieved person against any violation. Of course, if the act does not apply, the violation of the act cannot come. But if there is a violation of the act, any violation, it can be made. Now, my lord, kindly take section 3, which my learned friend has placed. Section 3, my lord, in my actual submission kindly sees only relates to the registration of a project before the radar. No promoter shall advertise, market, book, sell, or offer for sale or invite persons to purchase in any manner any plot, apartment, or building, as the case may be, in any real estate project part of it, in any planning area, without registering the real estate project with the real estate authority established under the act. Let us, if you continue further, provided that projects that are ongoing on the date of commencement of this act, for which the completion certificate has not been issued, the promoter shall make an application. So the completion certificate only pertains for a project to be registered under section 3, thereby drawing a distinction between section 3 and section 31. Even if a project has received it or a project has not received it, does not denude a person or any aggrieved person to file a complaint under section 31. I'll come to the aspect later whether he says in his writ petition occupancy certificate has been received by him. If whatever I've been able to go through in this short time, he says not completion certificate. I may be wrong. He may have averted in some paragraphs.
No, he's right.
I'm right.
But it's the same. This is the act
There is a
that
stark, huge difference between occupation certificate and
Send it to the RERA authority for.
And one more thing.
let him just finish. I'll
Only
indicate
one
this.
more thing.
As this argument was advanced, this is
But
covered by
I
that.
did not disturb Mr. Bennett.
No.
I sought his dissent.
Well, now kindly takes the impugned order once at page 59.
58?
59. Well, in my petition, it's 59, 6th of November, 2023.
Yes.
My lord, I'll be short. I'll not place everything.
No, do it.
Kindly sees, my lord, Mr. Such and Such being the authorized representative of the respondent company is present. Then, my lord, an adjournment was sought for on behalf of the petitioners hearing. Adjournment was rejected because kindly sees what the authority holds. Kindly takes, my lord, the first page, the fourth paragraph, possibly considered and rejected the prayer of the respondent. Lordship has got it. On the ground that today the matter is fixed for admission hearing only, and which can be done as complainant is present, respondent will get time to give the reply and affidavit, and there is no need for adjournment. Now, my lord, kindly see, these are the complaints, whatever they have said, kindly skips over. Then they kindly comes to page 61 at the bottom. These were the complaints they have several heads. Kindly see page 61 what the authority decides. The complainant stated at the time of hearing that an interim relief is urgently needed from the authority, that a direction required is to be given to the Asansol Municipal Corporation, that no disconnection of water should be done. These are beyond our scope. I do not do it. Kindly see what do we do at page 62. After hearing both the parties, the authority is pleased to admit the matter for further hearing as per section 31 and rule 36. The complainant is directed to submit his total submissions regarding his complaint petition on a notarized affidavit, such and such. Within 7 days, the respondent is hereby directed to submit his written response within such and such for 7th December. My respectful submission in placing is that I have not decided any right title, anything for which he will be aggrieved to come before your lordship. Well, his point is now kindly takes one paragraph only of the writ petition, paragraph 27 at page 13. Now, this is, in my respectful submission, the crux of his argument. Paragraph 27 at page 13.
Yes.
From the said complaint in Form AM, along with the detailed complaint filed, it transpires that the alleged grievances of the respondent number 2 association pertains to all the towers in the real estate project. The grievances are baseless, fictitious, illusory, and such and such. There is no cause of action in the complaint disclosed to approach the respondent number 1. However, in the instant application, the petitioners are aggrieved by the admission of the complaint by the order dated such and such by the respondent number 1, whereby a composite complaint in respect of all the towers in the real estate project has been admitted by the respondent number 1 without taking into consideration. So, my lord, his grievance, subject to correction, is that I have developed this project phase-wise. I have got documents for certain phases, certain not. But it cannot be his case, subject to correction, your lordship, that the real estate authority does not have jurisdiction to go into any aspect. His crux of the argument in the writ petition is that the projects, the phases which has been developed already, you do not have a jurisdiction. Well, it may be correct, may not be correct. What I have held by this impugned order is that you filed composite things, we will look into it. But in my residual submission, that does not give him firstly a cause of action at all to approach your lordship. I have not decided anything against him. He can take this point before. If he is aggrieved, I hold him. If he feels that I am holding it against law, he will approach your lordship. I have not held anything against him. And there is a difference between section 3 and section 8, section 31.
Could I just respond to this?
Yes.
Look, possibly this argument cannot be held to be valid argument in law. Your lordship will just have a look at section 34. Unless I am registered under the act, the provisions of this act don't apply to me. I have to be registered to have my obligations or duties enforced under the act against me apropos any complaints. This argument was advanced. Your lordship will have a look at this particular Supreme Court judgment, my lord. Because registration is the cusp. That is the most important thing. If I'm not required to be registered, the act itself will not apply. So your lordship has rightly pointed out, under section 31, it has complaints under the act for violations of the act. By registration, I subscribe myself to the provisions of the act, and then the act applies to me. Just one paragraph note of the Supreme Court judgment, paragraph 54. Copy আছে দিয়ে দিচ্ছি। এটা New Tech Promoters and Developers। এটা copy দাও না। 54. এটা আছে? এটা নিয়ে নাও।
Yes.
54. From the scheme of the Act of 2016, its application is retroactive in character, and it can be safely observed that the projects already completed or to which the completion certificate has been granted are not under its fold, and therefore vested or accrued rights, if any, in no manner are affected.
Direct affidavits. Yes.
Lordship will stay this order. One more.
Sorry.
No, nothing.
Well, Lord, kindly allows me one thing. Because
petitioner
your
has
lordship is
raised-
minded to stay it, my lord, I have to make a submission.
No, you have made your submissions, Mr. Bean. I have heard you.
No, only one allows me.
No reply to reply.
No.
Sorry.
One section
The
from the
petitioner
statute.
has made out an arguable case as to whether the assumption of jurisdiction by the respondent authority under section 31 of the Real Estate within bracket Regulation and Development bracket close Act, 2016 was erroneous, in view of the provisions of section 3 within bracket 1, first proviso and explanation to the said section, which exclude the operation of the Act to real estate which has already been completed. Next para. In the present case, learned counsel for the petitioner submits that all the towers in question have already been completed and completion certificate has been issued, and as such, the provisions of this 2016 Act are not applicable. Next para. Learned counsel appearing for the respondent authorities contends that the provisions of section 31 are independent and irrespective of section 33, the latter applying only to registration. Next para. It is further contended that the petitioners have only obtained occupancy certificates which do not tantamount to completion of the projects. Next para. Learned counsel for the petitioner also relies on a judgment of the Supreme Court in the matter of Messrs. New Tech Promoters, where it was observed by the Supreme Court, inter alia, that from the scheme of the Act of 2016, its application is retroactive in character, and it can safely be observed that the projects already completed or to which the completion certificate has been granted are not under its fold, and therefore vested or accrued rights, if any, in no manner are affected. Next para. In view of an arguable question having been raised by the parties as indicated above, the writ petition is required to be heard on its merits. Accordingly, the respondents are directed to file their affidavit in opposition within 3 weeks from date. Reply, if any, shall be filed within 1 working week thereafter. The matter shall be listed on January 9, 2024 for hearing. First up, there shall be stay of operation of the impugned order dated November 6, 2023, passed by the West Bengal Real Estate Regulatory Authority in complaint number WBRERA stroke cap COM 000542 till January 31, 2024 or until further order, comma, whichever is earlier.
Look, your lordship will just consider staying the proceedings. The RERA authority are very belligerent. They'll go ahead and do with the
Very
proceedings.
well. The all further proceedings of the above complaint case shall also remain stayed till January 31, 2024 or until further order, comma, whichever is earlier.
Very great.
Belligerent is possibly not a correct word.
No, belligerent is not the correct word.
Next.
Not the correct. Very great.
I'm deep.
হ্যাঁ, তুমি ওরকম চলে যাবে না ম্যাটারের মাঝখানে, যখন একটা ম্যাটার শুনছি তখন চলে is given. Colin.
Upgraded matter item 8.
8, yes.
I am for the petition, my lord.
What about service, Mr. Ghosh?
My lord, it's been served when the writ petition was filed. This is the affidavit of service.
Yes. What is that? You have checked up good service on all?
Yes, my lord. That's been served.
What is that?
This is in 2022. That's been served.
Oh. What is the urgency?
But there's no urgency. I'll only have to seek affidavit directions, my lord. It's a money claim arising out of, my lord, a scheme which was propagated by me under the Mahatma Gandhi National Rural Employment Guarantee Act, my lord. The guidelines.
Not a prima facie case, Mr. Ghosh?
Yes, my lord.
Yes.
My lord, if your lordship sees page 82, my lord, that's the earlier writ petition where, my lord, there was a finding by the court at page 84. If I may place the same at page 84, the authority will coordinate with the district magistrates of the different districts for which the petitioners have worked and ensure that the admitted dues of the petitioner by way of final payment will be made to the petitioners within the aforesaid period. Now, my lord, since they failed to make that payment, we preferred a contempt petition, which is at page, my lord, 88, the order of the order passed in contempt. At page 89, my lord.
Entitled to challenge the order, you are challenging?
Yes, I'm challenging that order as well as, my lord, I'm seeking release of the funds, which is admittedly due to me.
Very well. The petitioner, one or several?
My lord, one.
The petitioner has made out a strong prima facie case as to the respondents having apparently unlawfully, comma, withheld the due amounts to the petitioner under the MGNREGA scheme. First up, accordingly, the writ petition shall be heard on its merits on the above question. First up, the respondents shall file their affidavits in opposition within 3 weeks from date. First up, reply, if any, shall be filed on the next returnable date. The matter shall be listed on January 8, 2024 for hearing.
Great.
Affidavit of service filed today be kept on record. Thank you.
Great.
Next.
Item 9.
You are for the respondent.
Nine, my lord, I am for the writ petitioner.
Yes.
My lord, it has come at their instance.
Oh, what?
This is a peculiar case.
Yes.
My lord, we are the midday meal cooks.
They will cooks.
Cooks.
Right.
We are getting remuneration.
Yes.
At one stage, it was stopped. My lord, then new provisions have come that it should be given directly in the bank accounts. My lord, we moved this writ petition. Your lordship was pleased to allow the writ petition.
Ms. Hasin, you are appearing for the...
I have filed an application for addition of party lordship. I am the sufferer lordship.
Yes.
We are the sufferer.
Addition of party application ta kothay?
I am coming.
Yes. What is that?
Now, your lordship,
Yes.
your lordship was pleased to pass an order directing that the as the petitioner should be paid directly through their bank accounts. It was started to pay.
Yes.
Initially, it was not complied with. A complaint application was filed. As soon as the notice of contempt got, they started to distribute. Then, my lord, they started to distribute. We are getting.
So let her move her application for addition of party. How they are
No, coming. Now, my lord, from the records, it would appear that they were not in the picture. In 2015, my lord, the notice it has been given by the headmaster of the school that our list has been given.
Who are they? Who are they claiming?
They are
to
the
be?
cooks.
Who are they claiming?
They
to
are
be?
saying there are 39 persons. They are saying that they are also the cooks. And
So they have an interest. Let them be added as
no,
party.
no. They filed a
Yeah.
writ petition.
Yes.
That is pending. My lord, kindly from their application, it would appear.
No, no,
page-
let her move her
Lord.
application. Yes, move your application. Yes,
Lordship.
please take your seat. I'll just come.
Lordship,
Copy to the-
the petition,
They obtained an order from this court. The writ petition was decided.
Lordship, the writ petition was decided and your Lordship was pleased to pass an order, Lordship, that
They will
the
be paid their amount.
remuneration will directly go to the cook.
Right.
Go to the cook. Lordship, in that writ application, they claimed that they are only the cook come helper.
All right.
It was averred in their writ application, they are only the cook come helper.
Have you annexed
But-
that order? Have you annexed
Yes,
that order?
Lordship, I have annexed the order.
Because I have to see how that affects you.
Yes, Lordship.
You say you are the other cooks.
No, Lordship, it is annexed in their writ application. The order, your Lordship's order.
No, here also there, in your application,
Mm.
page 33.
Yes, Lordship, may I submit my entire case? Then your Lordship.
No, no, page 33.
Yes, Lordship. Thereafter, Lordship, before filing the writ application, Lordship, it is the procedure, Lordship, which followed by all the schools that the cook will come from the self-help group. Self-help group took resolution and sent the name to the headmaster, and headmaster sent this name to the BDO for sending their remuneration. It was initially come to the account, midday meal account of the headmaster, and headmaster will distribute the amount to the cook, Lordship. But subsequently, Lordship, the petitioner's Lordship convinced the other cook come helper, Lordship, that if we get the remuneration, we will distribute amongst us.
The writ petitioners are also they also belong to the self-help group.
Yes, Lordship. There are 5 self-help group, Lordship, and we are the member. They are 5 self-help group. The Asharalo, there is different name, Lordship. 5 self-help group, and the members of the 5 self-help group took a resolution that the names of these petitioners will go to the BDO, Lordship. I have annexed that list
For what?
for getting the remuneration directly to their account. And that petitioners also signed on the resolution that we will not break we will also distribute the amount amongst the others.
So they will get only their own remuneration.
No, not that, Lordship. Lordship, the one person from one group, and the Lordship, when the resolution is that, Lordship, that all the below poverty line on the very poor person, they cook jointly, Lordship. But remuneration comes and they distribute the money amongst themselves, Lordship.
I have to see my order, how it affects you. In your addition of party application, you must have annexed it. That is,
yes, Lordship.
That is at page 29.
Yes, Lordship. Yes, Lordship.
Let us see that. Please read out that order first.
Yes, Lordship.
Read out that order. How does it affect you?
The entire order, Lordship.
Entire order.
Page 33.
No, in my copy 29. Yes.
Yes,
Please read
Lord.
out wherever.
The grievance of the present petitioner is that although the petitioners are working as temporary workers associated with cooked midday meal program under the respondent number 6, the remuneration of the petitioners are being credited by the state respondent directly to the account of the school instead of to the account of the petitioners themselves. Contrary to the previously prevalent system of direct payment of the petitioner's bank account, it is argued that it is not for the school to distribute the remuneration to the petitioners, but they are entitled to get such remuneration directly from the state, and as such, the action complaint violates the rights of the petitioners, both legal and fundamental. Learned Counsel, appearing for the state respondent by filing a parawise report, submits that admittedly there were quarrels amongst the midday meal workers themselves, including the petitioners, due to which service of midday meal itself was being affected. In order to avoid such anarchy, the respondent started crediting remuneration of the petitioners directly to the account of the school, so the school has a scope of mitigate the quarrel amongst the midday meal workers. However, justified the argument of the state respondent may be as regards the midday meal itself suffering, thereby causing suffering to the student.
Yes, I've seen the order, Ms. Hasin. So there were allegations of dereliction of duty against them and others also.
Lordship, but it is not only the case, Lordship.
School was given the liberty, the respondents were given the liberty to take steps.
What has been bring in that writ application, it is not the entire scenario, Lordship.
What is the present writ petition for?
It is for.
Why have they filed the present writ petition?
Yes, Lordship, I am saying, Lordship, that thereafter, Lordship, once your Lordship.
Tell me, Ms. Hasin, why have they preferred the present writ petition?
Lordship, for that reason, Lordship, the other cook, Lordship, I have annexed. Lordship, kindly come to page P1, page 28, Lordship.
Of what?
Of my application.
Your application. Yes.
It is, Lordship, in the bottom, headmaster's signature, Lordship. It is the list of the cook cum helpers, Lordship. These cook cum helpers, Lordship, rotationally goes for cooking the midday meal program, cooking the midday meal of the Dullabirpara school, Lordship. It is not that one particular candidate will go and take their remuneration.
No.
It is not. Rotationally, they will come and they will take. But what happened in particular that writ application, after getting your Lordship order, they said that they are getting the permanent job. They will not distribute the amounts in between and they will continuously performing their duties. And thereafter, the other cook cum helper, Lordship, went to participate in the midday meal program when there was a quarrel and the authority, Lordship, school authority suspend all the persons.
There was nothing of that sort in my order.
No, nothing. Lordship.
So how are you a necessary party?
I am the necessary
party. The respondents were directed to pay their remuneration directly to them, whatever is due to them. And whatever irregularities they're performing, for that, respondents were given liberty to take steps against them.
No, yes, Lordship, takes against them, Lordship.
How does it affect you?
They were getting the remuneration, only they're getting the remuneration, but we are performing our...
That's a separate cause of action.
No, Lordship.
If you are not getting your remuneration, you are equally entitled as them.
Yes, Lordship.
The order said that the school cannot be a middleman. The remuneration has to be paid directly to these cooks.
But when, Lordship, when the school when the self-help group sending the names, changing the persons, send their name, Lordship.
For that grievance, you have to take out an independent challenge.
Lordship, kindly see, Lordship.
Filed a writ petition, they have not taken a step.
Please don't interject, I'll come to you. Yes.
Lordship, I have filed a writ application, Lordship. Lordship, in that writ application, they appeared, took time, Lordship, and thereafter suppressing all the materials fact that there is another writ application. They have filed this writ application, and after this writ application,
your writ petition is also pending.
Yes, Lordship.
Before this court. Before this court.
No, it is not in the list, Lordship. Nobody.
I have determination or somebody.
No, you, Lordship, don't have.
Do not have determination.
No. But I have.
You have filed in the group 9.
Lordship, kindly.
This is also group 9.
After.
No, this is also group 9.
Anyhow, my lord, it was.
Lordship, direct, my lord. Then tag.
Why should I direct?
Lordship, kindly. Then my writ application. And Lordship, your Lordship. No.
Up to now, Ms. Hasin, I don't find any reason why you should be added.
Lordship,
I'm being very candid. You have a separate cause of action, they have a separate.
Lordship, kindly allow me to say, Lordship, it is not that I have not, I have been suffering, Lordship. And now the status is that, Lordship, these writ petitioners.
Have you seen the prayers made in their writ petition? Please read out that for me.
Lordship.
Please come to the writ petition prayers. Read out. Read out what they have sought.
Read in the nature of mandamus.
Commanding respondents, especially respondent numbers 5 and 6, to give effect to the order contained in some memo issued by the respondent number 5 and thereby pay and clear the honorarium / remuneration of the petitioners, arrears and regular, whatever. So they want their remuneration to be paid. If you are entitled to remuneration, you have got a separate cause of action.
Lordship.
Take
But
recourse
the
to that.
school authority, what they are doing, Lordship, after, Lordship, kindly see the last.
Why are you a necessary party in this writ petition?
Because
You are in no way involved.
yes,
Their
Lordship,
payment is to be paid to them.
no, Lordship, they are
What? No. Oh.
Lordship, their payment, Lordship, they are getting our payment, Lordship. We have, Lordship, kindly once see, Lordship, once, Lordship. Once see, Lordship, my annexures.
Which annexure? Tell me.
Lordship. Annexure P3, Lordship, page 30.
The remuneration is not allocated. Remuneration is not allocated for individuals. What is the remuneration which you are entitled to? Each of you? What is the amount?
Lordship, I think it is 1500 or more than that.
1500 or more for each person.
Not for each person, not account has been given each person after taking our consent. That account has been given for that reason that the amount will come on that account and it will be distributed amongst the other cook cum helper, Lordship. Lordship, once, Lordship, kindly see the Krishna Haldar is the petitioner, Lordship. Lordship, kindly see, Lordship.
Krishna Haldar is a petitioner. You?
No, I am the
Writ petitioner.
petitioner, Lordship.
Very
Kindly see.
Amra Krishna Saha.
Krishna Saha, Lordship.
Krishna, yes. Page P3, yes.
Yes, Lordship. অধ্যকার সভার স্থায়ী সভানেত্রী কৃষ্ণা হালদার।
What is the page number of P3? অধ্যকার সভা, I've got it.
30.
No, it's 27 in my. Anyway, অধ্যকার সভা, yes.
অধ্যকার সভায় স্থায়ী সভানেত্রী কৃষ্ণা হালদারকে সভানেত্রীর আসনে বসিয়ে
No, this is some other অধ্যকার সভা. Sorry. Yes, Krishna Haldar.
সভার কাজ শুরু করা হলো। আজকে সবার আলোচ্য সূচি মিড ডে মিলের ভাউচারের বিল 10 জনের মধ্যে ভাগ করে নেওয়া হবে। আমরা আলোচ্য সভায় সিদ্ধান্ত নেওয়া হলো যে সভানেত্রী কৃষ্ণা হালদারের অ্যাকাউন্ট নাম্বার দেওয়া হলো। কৃষ্ণা হালদার সকল সদস্যদের সামনে প্রতিশ্রুতিবদ্ধ হয়ে কথা দিলেন 10 জন যে সিদ্ধান্ত নেবে সেটাই মেনে নেব এবং ইচ্ছা করলে 10 জনই ভাউচার দেবে এবং মনে করলে রান্নার কাজে 10 জনই যোগ করতে পারবে। Lordship, signature of the Krishna Haldar, Lordship.
This is not, I am not Krishna Haldar.
Krishna Haldar bracket in the bracket.
Within bracket Saha. Yes.
Lordship.
You are now Saha. You have forgotten that you are Haldar once.
Lordship.
Or the other way around.
Lordship, by this resolution, Lordship, we give consent, Lordship, to get the remuneration directly to the account. It is our money also, Lordship.
Is the scheme in writing somewhere? The mid-day meal scheme?
Yes, it is writing.
Show me that scheme.
Yes. My lord, a page in writ petition.
Instead of the food, you are trying to cook up the scheme itself.
Page,
all
my
of
lord,
you, both
in
of you.
writ petition, page 21.
And Lordship,
Earlier, এক second, ভাই একটু দাঁড়াতে বলতে দাও। Earlier there was this.
Lordship,
Of.
Lordship,
Acha, you complete the submission.
Yes.
Lordship, on the
I won't ask any question, you complete.
no, Lordship, not that. Then I'm
Oh, very well. I will ask question. Please complete the submission. Yes.
Lordship, now the situation is this, Lordship.
Yes.
The lastly, this petitioner.
Apparently, some people are taking the remuneration on behalf of others.
Yes, Lord.
And they're not disbursing that.
Yes, Lord.
Now, in my order, the previous order, which I passed, in that order, there was a specific direction that each person's remuneration has to be given directly to that person's account.
Yes.
So that solves the problem rather than making it a problem. Your problem is also if their amount is paid directly to their account and your amount to your account, then the problem is solved.
Yes, that is our prayer, Lordship. That
So you have no grievance with that order, the previous order.
Yes. I don't have any objection in that order.
Now let us see what they have sought in the present writ petition.
Present writ petition.
Let us see that they have asked for a memo being implemented. Where is that memo? Please come to the writ petition. It's a memo dated 29th of August 2022. Let us come to that once. Where have you annexed that memo, Mr.
My lord, that is in the last page 28, page 28 onwards.
28 on. Well, let us see that. Yes. Ms. Hassin, please come to that page, page 28 of the writ petition.
On
So
the basis
some
of-
particular number of cooks have been named.
Yes.
They have been engaged as cooks come helpers for the midday meal program
Lordship,
by name.
Lordship, the memo is P6, Lordship, in the writ application.
Page 28, the last annexure in the writ petition.
On the basis of the increased enrollment of the following 18 numbers of schools, the following cook-cum helpers are hereby engaged as additional.
She can read for herself, Mr.
Lordship, in this writ
Yes.
application, I didn't find Lordship any my school's name.
This memo has been sought to be implemented by them.
Where is my school's name, Lordship? There is in the
If,
increased.
if your school's name is not there,
there.
you are not affected even. Your school, you are engaged in a different school. For that, if you have any grievance, you have taken out a writ petition.
They are in my school, Lordship. They are cook of my school.
Is your school in this list?
No, my learned
It's a different grievance then. You are not a necessary party here.
no, Lordship. My learned senior will explain why this annexure has been annexed, Lordship. My learned senior will explain. I may not.
This is the order of the block development officer. This specifies certain names and says these people are engaged as midday meal cooks for these schools.
For these schools, where is my school? It is not my school, and their name also not there. Their names also not there, Lord.
Their name is not here.
No.
Because I'm explaining. Because, my lord, we are all called. They decided that we have taken the steps. Now you'll get in either inadvertent.
If your name is not there, how can you even ask for implementation of this?
No, because this is the system.
What is the system?
We asked that why our name is not there. They said that either in a hurry or, my lord, mistakenly, the name was not there. But
your name is not there. You are wanting an implementation of this.
No, this is the, my lord, this is the memo by which they are now paying.
I'll not add them, but reject your writ petition.
No.
That will solve the issue for both of you.
No, my lord, now what
if your name is not there, then you don't have any locus standi. She's right on that.
No, that is there. But we, pursuant to your lordship order, we were getting the remuneration. There was no problem. Initially, we were not getting. A contempt application was filed.
Ultimately getting.
They started. My lord, then contempt application was disposed of.
Obviously.
Then, my lord, they stopped. Now, after filing this application, they have now paying. So we have presently we have no grievance.
So you are not pressing this writ petition?
Maybe, my lord. Now they are getting no problem.
Lord.
After filing this, that's why I did not take any interest in this writ petition. It is pending and pending. Because now they are paying.
But I should dismiss your writ petition on merits also.
Lordship.
No, on merits, your lordship, because, my lord, here I have given the reference, though subsequently our name is in the subsequent memo, in similar manner. That I have stated. That I have stated also. That I have stated. That the block diameter has settled the issue with the.
Your grievance is your school's name is not there and your name is not here.
It is not my writ application, Lordship. I have.
Why are you asking for being added here?
Because Lordship, after Lordship, once Lordship kindly see the last annexure
Of your application?
of my application.
Yes. Yes.
After filing this writ application, Lordship, they have filed.
8, page 35.
Yes, Lordship.
Yes.
They have filed the writ application, Lordship. After filing this writ application, Lordship, BDO immediately, there is no order, nothing. Only copy has been served, I think. And thereafter, they have sent this letter to the headmaster, Lordship, and headmaster stop entering of our school, Lordship. We have not been allowed to enter into the.
You have preferred a writ petition for that?
Previously, I have preferred the writ application. I have preferred the writ application, Lordship, challenging the suspension of all cook-cum helpers. They have also suspended, Lordship. They are also, their suspension has not been withdrawn. Subsequently, my suspension has been withdrawn, but their suspension has not been withdrawn, Lordship. Suppressing all this fact, they have filed this writ application, and Lordship, and claim that their remuneration should pay following your Lordship's order.
They are asking for their remuneration in this writ petition?
And we are.
They are asking for their remuneration in the writ petition?
When they are suspended.
Are they?
They are, yes, Lordship.
If they are asking for their remuneration and you are asking for your remuneration, which is for a different school, how are you?
Not different. Lordship, the same school. They have annexed the wrong annexed, Lordship. It is not
I should not be
relevant.
advised by her. This type of suppression, wrong, everything. My lord, it's unexpected.
I'm
I filed a writ petition. No, please.
She is entitled to argue.
No.
You need not be advised by her,
no,
but
my
even
lord-
though she is a
my lord-
junior, she can argue them.
No, she is
Definitely.
saying that
She has an equal right with you.
but
So she is arguing her matter.
suppression.
She is not being able to express probably, but she has a right to argue.
She has filed a writ petition. They are saying that we have suppressed that.
Lordship, I have filed the writ application, Lordship, challenging the.
Give me one ground why you should be a necessary party in this writ petition. Give me one ground for that.
Because Lordship, they have filed the writ application and filed the copy to the BDO, and BDO sent a letter without any order. They have sent the letter to the headmaster, and headmaster stopped our entering into the school, Lordship. And Lordship, we have Lordship filed a writ application challenging our suspension, wherein Lordship subsequent after filing the writ application, the school authority withdraw our suspension, but the writ petitioners of this writ application was not agreed to give a undertaking that they will not create any mismanagement or anything, Lordship. And as that, Lordship, the suspension was not withdrawn.
Well, let me hear them now. Take a seat. Yes, Mr. Hossain.
Now, our writ petition was, my lord, very simple. Pursuant to your lordships, as I said, my lord.
You're not getting the money, now you're getting the money.
No, getting the money.
So you're not pressing the writ petition?
Not, my lord, then, my lord, I have not taken instruction for few days.
No, I'll say that your writ petition has become infructuous then. If you don't have a cause of action for the writ
if I will take just instruction where they are getting, then I will say that it has become.
after making the submission, you will take the instruction.
No, because
you thrice had submitted that you are now getting the money.
Then, my lord, you will make observation, it has become infructuous.
Learned counsel for the petitioner, for the applicant in the addition of party application submits that taking undue advantage of the present writ petition, comma, the applicant's rights are being curtailed, full stop. It is submitted that the writ petitioners have been suspended along with the present applicants, full stop. However, comma, subsequently the suspension of the present proposed added parties was lifted, whereas that of the writ petitioners were not.
No,
Full
that I
stop.
do not know, my lord.
Hence, comma,
Hence, that I do not.
please take your seats. And please, Ms. Hassan. Hence, comma, it is submitted that the relief sought by the writ petitioners would affect the rights of the proposed added parties. Full stop. Next para, such contention is controverted by learned counsel for the writ petitioners, who submits that the proposed added parties have preferred their own writ petition regarding their own grievances and do not have any axe to grind in the present writ petition. Full stop. Next para, it transpires that the primary grievance of the proposed added parties is that their own rights to get proper remuneration as midday meal cooks are not being honored by the respondent authorities. Full stop. Next para. However, comma, I do not find that the proposed applicants have any interest in the present writ petition. Full stop. The limited grievance sought to be vindicated in the present writ petition is that the writ petitioners are allegedly not getting their remuneration, comma, with which the proposed added parties do not have anything to do, comma, since the limited context of the present writ petition is whether the petitioners are individually entitled to remuneration for services rendered by each of them as midday meal cooks, comma, which has nothing to do with the other rights of the proposed added parties. Full stop. Next para. In the event the proposed added parties have a grievance regarding the writ petitioners eating into the remuneration of the proposed added parties, comma, since the proposed added parties and the writ petitioners apparently have certain schools in common where they work in such capacity, comma, it is open for the proposed added parties to ventilate such grievance in their own writ petition or otherwise. Full stop. However, comma, I do not find that the proposed added parties are either necessary or proper parties to the writ petition. Full stop. Accordingly, Can 1 of 2023 is dismissed. Full stop. Next para. Insofar as the writ petition is concerned, comma, learned counsel for the petitioner submits that although initially the petitioners were not getting due remuneration, comma, now they are getting such remuneration. Full stop. As such, comma, the writ petition has become infructuous in any event. Full stop. The grievance, the relief sought in the writ petition was that an order passed by the block development officer, comma, Jolongi, comma, Murshidabad, dated July 29, 2022, should be adhered to while disbursing remunerations to the petitioners. Full stop. Next para. From the first relief sought in the writ petition, comma, however, comma, it is found that the petitioners seek implementation of an order contained in memo number 2323/1 within bracket 54 dated August 29, 2022. Full stop. Next para. That memo has not been annexed here.
Perhaps, my lord, there.
Full stop. However, comma, I do not find that even a copy of such memorandum has been annexed to the present writ petition. Full stop. Next para. Thus, comma, the relief sought by the writ petitioners cannot be granted in any event. Full stop. Even otherwise, comma, since the petitioners submit that they are now getting their remuneration pursuant to a previous order passed in a writ petition, comma, no cause of action subsists for the present writ petition. Full stop. In the absence of the relevant memo having been annexed to the writ petition, comma, the writ petition is even otherwise not maintainable in law and in its present form. Full stop. In such view of the matter, comma, WPA 3336 of 2023 is dismissed without any order as to cause. Full stop. However, comma, nothing in this order shall prevent either the applicants in Can 1 of 2023 or the writ petitioners from preferring any challenge to any illegal or unlawful action undertaken by the respondent authorities insofar as the entitlements of the proposed added parties and the writ petitioners regarding their services rendered as midday meal cooks is concerned. No address to cause, Sergeant Secretary.
I'm grateful, man.
Grateful.
This will do. Well, perhaps they are getting, otherwise they are not making contact. Yes. No, I am because when I am aggrieved, suppression, misleading. These what documents are there? I have annexed. Yes. Now, what they are preparing in the office, they are annexed.
Now,
So I have
my
to
lord,
know.
I
No,
didn't say that misleading. I never say that misleading.
Did I say so?
No, misleading. My lord is in I
Follow the next matter.
I am great.
Item 10. Yes.
In this matter, I am appearing on behalf of the
My lord, Mrs. Chandri Alam is appearing on behalf of the
Who is appearing?
Union. Mrs. Chandri Alam, right? Union of India.
Yes.
But I am praying for not to do.
Why? You are there. You are there. You are sufficiently competent. Please, I'll take it. Yes, what is
happened? Well, I am filing the evidence service.
Actually, my lord, affidavit in opposition has affirmed affidavit in opposition come from the Delhi, my lord.
No, it was extended several times.
Erroneously, my lord.
No, it was extended several times. If you cannot file the application,
No,
today,
my lord, erroneously, my lord, it is annexed guideline. My lord, the scheme, necessary scheme is with me. My lord, leave may be granted to supplementary affidavit annexing the scheme, my lord.
you have not yet filed your opposition.
It has. They have served.
Sir, I am sir, not filed.
You have not filed, I'm saying.
Filed. Affidavit in with me.
Why file a supplementary affidavit? Correct your affidavit in opposition. I'll give you 7 days more.
7 days.
On the prayer of learned counsel for the respondent stroke Union of India, comma, the time for filing affidavit in opposition is extended for 7 days from today. Accordingly, the time for filing reply is extended for a week thereafter.
We have already filed.
Full stop. Next para. The matter shall next be listed on December 13, 2023 under the same heading.
December 13.
Mr. Manna, if an opposition is not filed, the court cannot take on record the reply to that.
Well, they have
If the mother is not born, the child cannot be taken on leave.
They have sworn.
Next matter.
Now, within time, we have replied.
Very well.
Item 11.
13th of December.
Yes.
My lord,
Item
my lord,
11.
I am praying only not today, my lord, in this matter, because I cannot reach before lordship. I want to do it physically, my lord. But there is a great rush in the train, my lord.
All wishes are not fulfilled, Mr. Shamantu. Since you are
My
there,
lord,
I'll hear you
my
on.
lord, kind, because my lord, I want to sworn judgment to your lordship, my lord. Kindly make it not today, my lord. I just pray, my lord. My lord, kindly, because I want to do it physically before lordship, my lord. Kindly, my lord.
Mr. Dotto, what is that?
Yes. My lord, here the
Yes.
question is, the point involved is,
Mr. Dotto, you drafted the writ petition. You settled the writ petition. Paragraph 2 you have settled.
no. কি বলেছিস?
Yes. Anyway.
If I had it, this wouldn't have been there.
No, but well drafted. Yes.
No, my lord, here, my lord, the point involved is, my lord, if a person is elected in the general election, assembly election, and subsequently it is found that he had made a misdeclaration as regards his educational qualification, then what is the remedy? One remedy is that one of the contesting candidates or some other, they may file an election petition. This has happened over here. The losing candidate had filed an election petition challenging the success of this candidate.
Do I have determination, Mr. Dotto?
Because, my lord, in a residuary, except police matters,
there is no other
rest are before your lordship.
Yes.
Now, my lord, the defeated candidate had filed an election petition before this court, which was ultimately dismissed because it was found that the defeated candidate was a voter in Bangladesh. Therefore, she could
did not have a locus standi.
She could not maintain the election petition.
Right.
Now, my lord, someone else has come challenging that. Now, the points which are involved, number one is, my lord, if I make a misdeclaration, whether I suffer a disqualification. This is what first thing that I need to satisfy your lordship.
So whether educational qualification is such a mandatory condition that very.
Second is, my lord, even if it is a sort of a disqualification, whether it vitiates the election or not.
Yes.
These are the two things. And the third is, once he is elected, and if there is no election petition, what is the remedy? For
Here
that,
there is an election petition.
There was an election petition which has gone. This is a writ petition.
Achha, yes. No, you said a second person has challenged.
Who is before your lordship? Not by of an election petition in this writ petition.
Oh, you are that second person who
I
is
am that
challenging.
Yes.
Achha.
Now, these are, my lord, the 3 points involved, my lord. Just 2 documents, my lord, for your lordship's consideration. Then, my lord, I'll go to the other things. Please take page 35. My lord, it starts from page. This is the nomination paper which he had filed, the private respondent, which starts from page 19.
Yes.
But this is in form 26, my lord, the statutory form, my lord. And, my lord, the relevant portion.
This was an election to what?
In the State Assembly.
State Assembly. Good.
Yes. My lord, please take, my lord, page 35.
Yes.
5th line from the top. 6th line. My education qualification is under 8 passed from so-and-so school, 1995-96. Now, my lord, kindly see, my lord, what the school says. In a reply to RTI, my lord, this, my lord, will find that at page 39. Well, no, not very legible, but.
Yes. My copy is legible.
I want to draw your attention to the fact that there is no records, information about Shopon Mujumdar in the admission register of this school. As per the application of RTI, the present age of Sri Mujumdar is 39. So his date of birth should be in the year 1982 and the expected year for admission in class 5 should be 1990 or 91 or 92. Or so-and-so Mujumdar might be admitted in class 6 in so-and-so years. Kindly skip over the ors. Then in this regard, I have checked and cross-checked the admission register of the pupils of this school from the academic year of 1989-90 to 1995-96 to collect information about so-and-so. but there is no record of his studentship of in any kind of registers which are preserved in the school custody. These are the Millard documents. Then Millard complaints Millard were lodged with the ECI, Election Commission of India, pages 40, 42, and 43. Millard, Lordships need not be troubled, but this is what Millard we have said in the applications or Millard.
The Election Commission of India has jurisdiction in this.
Yes. According to me, Millard.
The assembly elections, right? Up to the assembly elections, probably.
Yes.
Madam, that is my submission.
That is what Millard I need to Millard.
That is my submission because they have submitted when the election started, and election commissioner does not have any jurisdiction regarding this, my lord. Once the election starts.
Mr. Samant, I'll definitely hear you on that. Yes.
Now, if your Lordship may kindly have a look to Millard, the Representation of People's Act. Copies of? Thank you. Your Lordship may kindly first take Millard Section 7 of the 1951 Act.
Section
7.
Yes.
Definition clause. In this chapter, kindly take B.
B, yes.
Disqualified means disqualification for being chosen as and for being a member of either House of the Parliament of the Legislative Assembly or Legislative Council of a state under the provisions of this chapter. Read with this, kindly now take Millard Section 100.
Yes, 100.
Grounds for declaring election to be void, subject to the provisions of subsection 2, if the High Court is of the opinion, please take Millard D thereunder, that the result of the election insofar as it concerns a returned candidate may be materially affected, by improper acceptance of any nomination. So this is a ground for declaring an election void. Now, why improper acceptance of nomination paper? Your Lordship may kindly take note, Section 36 now.
Yes.
Scrutiny of nominations.
Yes.
First, Millard, the date to be fixed, etc. Please take subsection 2. The returning officer shall then examine the nomination paper and shall decide all objections which may be made to any nomination and may either on such objection or on his own motion. After summary inquiry, if any as he thinks necessary, reject any nomination paper on any of the grounds that the date of scrutiny, etc. ABC kindly skip over, then take 4. The returning officer shall not reject any nomination paper on the ground of any defect which is not of substantial character.
So you have to overcome this hurdle.
This part. Therefore, the question arises is that whether a false declaration as regard educational qualification is a declaration or has the effect of substantial character.
Right.
He cannot reject if not, but he can if. Now, how this section is being Millard interpreted, Millard, I'll demonstrate before your Lordship by the Supreme Court, and then Millard, I come to the Constitution.
If that's a defect of substantial character, Mr. Datta, then half the people would be leaderless, half the country would be leaderless.
But Millard,
it will be a very risky ground you're trading.
Millard, in fact, the Supreme Court, Millard, taking note of this kind of a false declaration,
yes,
says that this kind of provisions, that is section 11(1)(d) is not to be strictly construed, and whether this is of a substantial character is immaterial. This provision has been read down, even in my very humble submission. Please have a look to this, then I'll come to what is the remedy.
Yes. No, we'll come to that later. You're citing the judgment first.
Yes.
Yes.
But this judgment, Millard, takes care of a lot of points, Millard. That's why, Millard, I rely on only this judgment.
Yes.
Millard, the first, this is reported in 2017, Volume 2, Supreme Court Cases, 487. First is, my lord, paragraph 13. But as to the paragraph 13, my lord, I think your lordship may skip over because it's Winston.
Para 13 has been quoted first.
Yes. Then, my lord, your lordship may kindly take note, paragraph 17. It speaks of right of a voter.
Right.
Paragraph 70, it's clear from the law laid down by this court and stated above that every voter has a fundamental right to know about the education qualification of a candidate. It is also clear, etc. My lord. Next, my lord, I don't trouble. Then, my lord, your lordship may come to, my lord, 19. Paragraph 19.
Yes.
The contention of the appellant, the appellant was the successful candidate, my lord, who had ultimately lost.
Right.
That the declaration relating to his educational qualification in the affidavit is a clerical error and cannot be accepted. This is not an error committed once. Since 2008, the appellant was making the statement that he has an MBA degree. The information provided by him in the affidavit filed in Form 26 would amount to a false declaration. The said false declaration cannot be said to be a defect which is not substantial. He was given an opportunity by the returning officer to produce the relevant document in support of his declaration. At least at that point of time, he should have informed the returning officer that an error crept into the declaration. He did not do so. The false declaration relating to his educational qualification cannot be stated to be not of a substantial character. It is no more res integra that every candidate has to disclose his educational qualification to subserve the right to information of the voter. Having made a false declaration relating to his educational qualification, the appellant cannot be permitted to contend that the declaration is not of a substantial character. For the reasons stated supra, we uphold the findings recorded by the High Court that the false declaration relating to education qualification made by the appellant is substantial in nature. Having answered the first question against the appellant, we now proceed to deal with the next part. Section 101A to C deal with disqualification, corrupt practice, and improper rejection of nominations, respectively, which are grounds for setting aside the election. The sine qua non for setting aside an election under Section 101D is that the result of the election, insofar as it concerns a returned candidate, has been materially affected. Now, the Supreme Court notes, my lord, the words of Section 101D. Now, kindly take, my lord, paragraph 23. Well, Durai Swami's judgment was considered by the Honorable Supreme Court. Now, please take, my lord, between placitum B and C, where the sentence starting with on the other hand.
On the other, right.
On the other hand, if the improper acceptance of nomination paper is of the returned candidate, there is no necessity of proof that the election has been materially affected, as the returned candidate would not have been able to contest the election if his nomination was not accepted. It is not necessary for the respondent to prove that the result of the election, insofar as it concerns the returned candidate, has been materially affected by improper acceptance of his nomination paper, as there were only two candidates contesting the election, and if the appellant's nomination is declared to have been improperly accepted, his election would have been set aside without further inquiry, and the only candidate left is so and so. That is in the facts of that case. Now, please take, my lord, paragraph 25.
Yes.
Well, we can skip over paragraph 21. Please take note, paragraph 26. Again, my lord, Supreme Court is considering section 101D. Mere finding that there has been an improper acceptance of the nomination paper is not sufficient for a declaration that the election is void under section 101D. There has to be further pleading and proof that the result of the election of the candidate, of the returned candidate, was materially affected. But there would be no necessity of any proof in the event of nomination of a nominated candidate being declared as having been improperly accepted, especially in a case where there were only two candidates in the fray. If the returned candidate's nomination is declared to have been improperly accepted, it would mean that he could not have contested the election, and that the result of the election of the returned candidate was materially affected need not be proved further. We do not find substance in the submission of Mr. Giri that the judgment in Durai Muthuswamy is not applicable in the facts of the case. The submission that in Durai Muthuswamy is a case of disqualification under section 9A of the Act and so it is not applicable to the facts of the case is also not correct. As stated supra, election petition in that case was rejected on the ground of non-compliance of section 101D. The said judgment squarely applies to this case on all fours. We also do not find force in the submission that the act has to be strictly construed and that the election cannot be declared to be void under section 101D without pleading and prove that the election was materially affected. There is no requirement to prove that the result of the election of the returned candidate is materially affected once his nomination is declared to have been improperly accessed. So the fundamental query should be whether the nomination paper was or ought to have been rejected or not. If the nomination paper deserved to be rejected, and if it is not rejected, then the further material affectation, this part is not required to be proved. This I don't think that I need to trouble your lordship with the other parts of the judgment. Therefore, section 101D need not be strictly construed. Number two is, if a nomination paper was required to be rejected, then the election becomes void. Why? Because the person concerned did not have any right to even contest. Now, please take me to the provisions of the Constitution, only 2 articles.
Educational qualification is required under 100, section 100D.
This is required under Form 26.
Under Form 26.
Right? Yes, which is which arises from Rule 4 of the conduct of election rules. I think it's Rule 4A. I'm sorry, may I check once?
Yes.
Conduct of election rules. Yes, 4 and 4A, both.
What is the year of the rules, Mr. Datta?
Conduct of election rules 1961.
Right. To consider whether that is a substantial defect, Mr. Datta, we have to see the context also. Yes. Now, educational qualification in our country, particularly, I mean, wouldn't it be very elitist for us to proceed on a premise that educational qualification, misinformation or wrong information or lack of information regarding educational qualification would be a determinant in the election? Because in a country where most of the people are uneducated or cannot afford an education also. Now, in such a country, Mr. Datta, can we say that educational qualification is of such an impact that it would affect the election substantially? Because most of the franchise, I mean, the people who are electing, they are not educated, so they choose their own leaders. Whatever we may feel, I mean, we cannot be elitist on that. So educational qualification, is that so substantial? I mean, ultimately boils down to Form 26.
Yes.
I mean, whether that is so substantial, educational qualification in election. I mean, suppose I say I'm a class 8 pass or somebody is an MBA. I mean, I'm not an MBA, but does that, I mean, is it so germane?
We have to look at it backwards, or in the reverse manner. Starting with that, there is no bar for even an illiterate person to contest an election.
Yes.
Now, if there is no bar, then if somebody requires to qualify by reason of a particular standard of education to be achieved,
yes,
there may or may not be some misdeclaration depending upon various circumstances. I'll give you a very crude example. In our High Court, for Group D post, if advertisements are invited,
yes,
PhD holders, they suppress their PhD and
True.
So therefore,
that's an understatement.
There's an understatement.
Yes.
That can be understood, considering the socio-economic condition of a person.
Yes.
But where there is no educational qualification required, prescribed, there is no educational standards prescribed, there, any person need not misdeclare his educational qualification because it does not.
Ideally, you need not declare his educational qualification.
Even also,
Ideally.
yes. Only because of section Article 19(1)(a), now Supreme Court has said that
Yes.
a voter has a right to know the criminal antecedents, then educational qualifications and other things, because he must know the person whom he is voting.
Definitely.
Yes. These again, Milord, I borrow your lordship's words, Milord, elitist concept. How
It is
many of
elitist,
us, Milord, have that
Our sense of, I mean, socialism is very elitist.
Yes.
It's
At least
confined to our AC rooms.
At least, Milord, in a third world, overpopulated, poor country, Milord, I think,
Yes.
Milord, some means
Democracy has to reflect the masses. I mean, not some of us.
Yes, yes. Not the persons who have Mercedes and Porsches.
Or not the persons who decide.
Yes.
So I'll come back in 10 minutes and complete the year. Thank you. থ্যাংক ইউ। এটা ধরে ওনাকে ফেরত দিয়ে দিও। আচ্ছা ঠিক আছে। Yes.
But apropos the last query of the court, please have a look toward section 125A of the RP Act.
125A, yes.
So this is also an offense.
False affidavit. Right, right.
So he can be punished as well as election can be declared void.
Fair.
Now we kindly now have a look to the constitution.
Yes.
Please have a look to Article 191 first. Disqualifications from membership.
Yes.
A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state. Please take E if he is so disqualified by or under any law made by the Parliament. Now, what is to be done? Kindly take 192.
Yes.
If any question arises as to whether a member of a house of the legislature of a state has become subject to any disqualification mentioned in clause 1 of Article 191, the question shall be referred for decision of the governor and his decision shall be final. Before giving any decision on any question, the governor shall obtain the opinion of the election commission and shall act according to such opinion. Now, the procedure of giving opinion under 192 is provided in 146 of RP Act.
Yes.
Where in connection with the tendering of any opinion to the President under Article 103 or as the case may be under subsection 4 of Section 14 of the Government of United Territories Act or to the Governor under Article 192, the Election Commission considers it necessary or proper to make any inquiry. And the Commission is satisfied that on the basis of affidavits filed and the documents produced in such inquiry by the parties concerned of their own accord, it cannot come to a decisive opinion on the matter which is being inquired into. The Commission shall have, for the purposes of such inquiry, the powers of a civil court while trying a suit under the Code of Civil Procedure in respect of the following matters, so and so. Then subsection 2, the Commission shall also have the power to require any person subject to any privilege which may be claimed by that person under any law for the time.
Somewhat like a civil court.
Yes, somewhat like a civil,
yes.
Civil court. So this is the procedure which the Election Commission has to adopt. Then kindly take note Article 190, Sub-Article 3.
Yes.
If a member of a house of the legislature of a state has become subject to any of the disqualifications mentioned in clause 1 or clause 2 of Article 191 or resigns from his seat by writing in his hand, etc., his seat shall thereupon become vacant. So this is the last effect. So, my lord, there are three things which can happen. One is in an election petition, the election can be declared void. Simultaneously, my lord, there can be an offense under 125A. If the first one is not done, then the other two is 191, 192 read with 190 and 125A. But this is the scheme as I could understand. But I will point out that I need to cross one hurdle, that is 192. Because 192 is couched in words which may have a feeling that the disqualification should arise after elected. May I read that?
Yes.
If any question arises as to whether a member of a house of the legislature of a state has become subject to so and so.
Apparently so, because the scheme of things is such.
Yes.
that if you challenge the election at the time of election, that point of time, then it would
Yes.
not be covered by it.
Yes. So the 192, my lord, these words, my lord, are to be, my lord, considered by your lordship, my lord.
Yes.
But, my lord, why I say, my lord, I can overcome this because 192 refers to 191. 191 applies both before and after.
He has already become a member.
So for being chosen as is
So
also
before after.
Already a member.
Then if you go backwards, 191 3D, I'm sorry, 190 sub-article 3 becomes subject to any disqualification under clause 1 or 2 of 191. Therefore, being chosen is incorporated in 190 sub-article 3 also. Therefore, my lord, my respectful submission is, my lord, the election commission has some function over here. But I may ultimately not succeed, or the person concerned may ultimately come out clean. But it cannot be so because the drastic consequences, even if his election is not under challenge, the seat becomes vacant. Therefore, my only prayer is, let this scheme of the things take its course. Then whatever is the result has to be accepted.
No, scheme of things, what is your prayer? I mean, what do you want?
Prayer is kindly have a look to my prayers. Well, prayers are not, my lord, happily couched. I'll be very candid to you.
What is it that you want actually?
But I actually want, my lord, that in view of section Article 191, my lord, the matter should go before the governor. Then if the honorable governor feels that there is required to be looked into, or the opinion is to be obtained, then the governor will obtain. And with the sub-article 2 of 192 is very important because the ECI role is very important. Because if ECI gives an opinion in one fashion, the governor has to act in that fashion under 192(2). Yes, with 146, the procedure is mentioned in 146.
And shall act according to such opinion.
If the election commission says no, governor has to say no. It appears to be so. If says yes, yes.
Right.
No, these are my submissions.
Yes. Yes, Mr. Shamanta first. You are supporting him.
Yes, my lord, it is a commission-centric, my lord, petition.
Yes.
Either state election commission or EC.
You are for the state.
I am for the state, not commission.
Not the state election commission.
No, they have a separate set of laws.
Right, right. Yes, Mr. Shamanta. What do you say?
But must I beg about that I can appear physically and I cannot show any judgment to
If
your
you
lordship.
want to cite any judgment, definitely you cite your judgment. No difficulty on
All
that.
right. Well, but first submission is that there is no prayer against ECI, my lord. There is no such prayer against ECI. Now, second, whether the learned senior has shown many judgments, whether they are all for return candidates, my lord. Whether these return candidates, my lord.
Achha.
Whether this Gopal said, the petitioner hearing, is a return candidate or not, my lord. He is not a return candidate, as per my knowledge. Now, my lord, if your lordship kindly come to page 78, my lord. My first, thereafter, my lord, they have come before lordship.
What do you mean?
Return candidates means he has not challenged in the election, my lord. If your lordship kindly come to page 78, my lord, you can see Alorani Sarkar. That means that person has contested the election, my lord.
No, this person,
Not contested.
Who did not contest?
This petitioner, my lord.
Achha, achha.
He had challenged the education qualification of Saud Mujumdar, but he had not contested that election, if I am not wrong, my lord.
Very
so whatever judgment that has been shown to your lordship is all for return candidates. He is not a return candidate, my lord.
Very, very.
Now, my lord, if your lordship kindly come to page 78, I have very short submission before lordship, my lord, because our election commission role is very limited here. If your lordship kindly come to page 78.
78 I don't find here. I mean, it's not paginated after page.
It is the order of my lord, Honorable Justice Vivek Chaudhary, my lord.
After page 39, there is no pagination actually. This is Vivek Chaudhary. Let me find it out. Yes, Justice Chaudhary, yes.
Yes, my lord. If your lordship kindly come to second page, my lord. Order dated, my lord, 13th August 2021.
The order dated 20th of May.
I am opening 30th August 2021, my lord.
I'm so sorry, my lord.
No, these are
With the order.
not certified copies, so could have been paginated.
Yes, it should have been. Should have been. my lord. 13th August 2021, my lord.
13th August, let me find that out.
অর্ডার গুলো তো chronologically দেয়া নেই।
I find a judgment of 20th of May 2022. That is P4 in my copy.
Thirteenth of May.
No, 13th of May was a hearing conclusion date.
Yes.
Judgment on 20th of May. GA4 of 2022 along with EP2 of 2021.
Yes.
That is what I'm finding here. I don't find anything else. Another order of Justice Chaudhary dated 11th of March 2022. Let me find out. I must find out 13th of August somewhere. 13th of May also I find. I can't find out. Unmarked and I can't find out the order at 13th of August. I don't find any order.
But the problem is that the orders are not in the sequence.
Not in sequence also. This order, this is 20th of May 2022 order.
No, 13th August. My learned friend is referring to
Yes,
13th August.
he's referring to 13th August. This is a different order.
No,
that my lord, it is paginated আছে।
No, this is not 13th August order.
Brief is not marked. May I hand over this brief, lordship?
No, my brief also contains the orders without marking, without pagination rather.
No, my learned
You have got
friend
a
has not walked it up.
78.
13th August order you have got.
Yes, there is.
No, I must have it somewhere here. Let me take up just.
It
13th August, yes, it has been located.
Look at it.
Yes, sorry, Miss.
My lord, kindly come to the second page, my lord. Page 2. The next page, my lord.
Page 2, yes.
My lord, if your lordship kindly come to the second line. 1, 2, and 3, there are, my lord, from the starting, it is to be remembered at the outset that the petitioner has challenged the election of the return candidate on the following grounds, my lord.
Yes.
The return candidate made wrong statement in the affidavit filed along with the nomination paper.
This was a challenge between the same parties or different matter?
Different matter, my lord. In respect of his academic qualification. My lord, my submission.
The same private respondent's academic qualification.
Yes.
This
Yes,
was
my
the
lord.
first round. Very well, yes.
My lord, this is the election petition filed by Alorani Sarkar, who contested the election.
Right.
He was the return candidate. She had challenged this point, my lord, in respect of his academic qualification. So this is the procedure that has to be taken care of right now, my lord.
Right.
Once the election, what I want to submit before lordship, this Alorani Sarkar thereafter lost his case, my lord.
Yes.
Now this petitioner waited for 2 years to see the outcome of this petition, this election petition. They could have challenged, if election commission has done any wrong, they could have appeared before lordship 2 years ago, my lord. But after this appeal has been preferred, this Alorani Sarkar lost in appeal also. Because this point was not considered there, the main point was consideration was that she was a Bangladeshi woman.
Right.
And hence he had lost his case, my lord. Now, after 2 years, when they saw that she didn't get any relief, they came to this with this petition, my lord. Now, my lord, if your lordship kindly come to page 40 and 41, my lord. Their complaint, my lord. If anyone has any problem with regard to the nomination or anything, my lord, they have to appeal before the concerned department, not to the election commission directly, my lord, in this way. This is not the procedure, my lord. There are various forms and there are other circulars and whatever they have to do, that is before the election starts, my lord. Anyway, if I consider, my lord, anyway, if this election commissioner in India takes up this representation and takes it granted that yes, he has committed some wrong, my lord. The election cannot be challenged in this way, my lord. It has to be challenged by the election petition, my lord. My lord, if your lordship kindly come to page 41, my lord. What?
41, yes, yes.
But yeah, because that is their complaint to the election commission, my lord.
Right.
These 41, my lord, there is no receipt. They talk with the officials over there. They have not got any such copy like this because they cannot also show any that it has been issued by the department. Now, my lord, if you kindly come to my lord, page 42, my lord. That is the complaint they are stating, my lord, to the election commission India. With regard to the disqualification of his candidature from his right to contest in the election 2021. My lord, there are also my lord, the page 43, my lord, thereafter page 43. That is their complaint.
No, page 42 and 43 are your thanksgiving to Gopal. You have thanked him for complaining.
Hello. Yes, sir.
Yes.
Yes.
Hi.
My lord, I just missed my camera, so my lord, anyway. My lord, I'm really sorry, my lord.
Mr. Samanto, these are you have thanked Mr. the petition.
No, my lord. Now, what I want to show, my lord,
yes.
In page 43, my lord, you kindly read the note, my lord. The issue of BJP candidate Mr. Habun Mojumdar from 96 Bonga South AC and Mr. Subroto Thakur from 97 Gaihata AC may right.
I'm not finding this at page 42 or 43. Oh, the caption. Yes, yes.
Caption, my lord, caption.
Yes, yes, sorry.
My lord, these captions with regard to the disqualification of the candidature, only regard to the education qualification. Now, my point is that, my lord, the date they have submitted, my lord, 18th April 2021. Now, election started on 27/3/2021 and it concluded on 29/4/2021. The assembly election was at that time, my lord. The election started on 27/3/2021 and it ended on 29/4/2021. Now, whatever they have to do, my lord, if any complaint or anything like that, I will show you judgment with regard to that, my lord.
Yes.
They have to make it before the election starts. Because once the election starts, my lord, election commission do not have any role to take out any representation or anything. Because that means once they take up, that is challenging the election, my lord.
All right. All right.
That has to be done before, because there are certain procedure, my lord, they can take an RTA, they can take out anything, they can approach before the electoral returning officer, but anybody, my lord. That is the process. Because once election starts, my lord, they have to have, because once, if my lord, now, anyway, if this representation is considered and he's fine disqualified, my lord. Right now, if election commission takes it, then what will be the stand, my lord? Then he has to, then that seat has to be vacant. Then it is same as challenging the election again. This cannot be done, my lord, because once the election comes, my lord, I will show you judgment, my lord. With regard to this is the only judgment that is being followed from throughout the years, my lord. NP Ponnu Swami, my lord, versus returning officer, Namkal constituency.
Do you have the citation?
Yes, my lord. 1952 SCC, volume 1, my lord.
Page?
My lord, there are certain paragraphs, my lord, which are
what is the page number? 1952, volume 1 SCC, page?
94, my lord. 94, my lord.
1952, volume 1 SCC, 94, page 94.
Yes, my lord.
Yes.
My lord, I'll be referring there are very, my lord, you say 10 to 15 page judgment, my lord. I'll read 1 or 2 paragraphs for your.
Give me the paragraph numbers, Mr. Samanto.
My lord, paragraph 7, 9, 15.
Yes.
20, 22, and my lord, the last paragraph, that is 39 and 40.
All right. Yes. Please read.
Lord, I am just reading one paragraph 15, my lord.
Right.
The question now arises whether the law of election in this country contemplates that there should be 2 attacks on matters connected to the election proceedings. One, while they are going on by invoking the extraordinary jurisdiction of the High Court under Article 226 of the Constitution, the ordinary jurisdiction of the courts having been expressly excluded, and another after they have been completed by means of an election petition. In my opinion, to affirm such a position would be contrary to the scheme of Part 15 of the Constitution and the Representation of People Act, which, as I shall point out later, seems to be that any matter which the effect of vitiating an election should be brought up only at the appropriate stage in an appropriate manner before a special tribunal and should not be brought up at an intermediate stage before any court. It seems to be that under the election law, the only significance which the rejection of a nomination paper has consisted in the fact it can be used as a ground to call in the election in question. Article 329B was apparently enacted to prescribe the manner in which and the stage at which this ground and other grounds which may be raised under the law to call the election in question could be urged. I think it follows by necessary implication from the language of this provision that those grounds cannot be urged in any other manner at any other stage and before any other court. If the grounds on which an election can be called in question would be raised at an earlier stage and errors, if any, are rectified, there shall be no meaning of enacting a provision like Article 329B and in setting up a special tribunal. Any other meaning ascribed to the words used in the article would lead to anomalies, which the Constitution could not have contemplated. One of them being that conflicting views may be expressed by the High Courts at the pre-polling stage and by the election tribunal, which is to be an independent body at the stage when the matter is brought up before it, my lord. But if I point out the last para, my lord, because there are various paragraphs I will not disable lordship, my lord. Only the last para I am reading, that is page 39, para 39, my lord. Will I read it, my lord?
Yes. Yes.
This argument displays great electrical ingenuity, but it has no bearing on the result of this appeal, and I think it can be very shortly answered. Under Section 36 of the Representation of People Act 1951, it is the duty of the returning officer to scrutinize the nomination papers to ensure that they comply with the requirements of the Act and decide all objections which may be made by any nomination. It is clear that unless the duty is discharged properly, any number of candidates may stand for election without complying with the provisions of the Act, and a great deal of confusion may ensue. In discharging the statutory duty imposed on him, the returning officer does not call in question any election. Scrutiny of nomination papers is only a stage, though an important stage, in the election process. It is one of the essential duties to be performed before the election can be completed, and anything done toward the completion of the election proceedings can by no stretch of reasoning be described as questioning the election. The fallacy of the argument lies in treating in a single step taken in the furtherance of the election as an equivalent to election. The decision of this appeal, however, turns not on the constitution of the single word election, but on the constitution of the compendious expression, no election shall be called in question. In this context and setting, with due regard to the scheme of Part 15 of the Constitution and the Representation of People Act 1951. Evidently, the argument has no bearing in this regard to approach to the question posed in this appeal, which appears to be the only correct method. We are informed that besides the Madras High Court, 7 other states' high courts have held that they have no jurisdiction under Article 226 of the Constitution to entertain petitions regarding improper rejection of nomination papers. This view is, of my opinion, correct and must be affirmed. But my only submission is that if they have any complaint or anything with regard to that, now election commission hands are tied, my lord. Once the election starts, they cannot do nothing, my lord. That is the only submission. Because this judgment is a leading judgment which is being carried out and it has not been challenged anywhere, my lord. Now, whatever judgments my learned senior friend is saying, my lord, these are all for return candidates. This governor and all these, my lord. Overall, there is no prayer against election commission in India, my lord. Like election commission in India can only do before election, my lord. That is the only submission, my lord. Once election starts, we have no role, my lord.
Right. Very good. Thank you, Mr.
That is the only submission, my lord.
Right. Let me hear Mr. Datto's answer. Yes.
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 My lord, may I start with the last point?
Yes.
My lord, Punuswami's judgment is a judgment under Article 329B of the Constitution, which says that once the election process starts, the courts cannot interfere.
Hands off policy.
And there is, in fact, my lord, there is one phrase which encompasses everything, that any matter which has the effect of vitiating an election cannot be looked into at the stage when the election process starts. Or this is a constitutional bar on the court. Article 329B, if your lordship may kindly have a look, my lord, it is a bar on the court.
Yes.
This is my respectful, my lord, answer to my lord Punuswami's judgment. Now, my lord, the other aspect of the matter, which my learned friend says that it is directly or indirectly calling in question an election. But please look into at 191, whether, my lord, this can at all be called or branded as a challenge to the election. But here, my lord, the question is whether someone is disqualified. Challenging an election means what is the remedy I am seeking? I am seeking that the election be declared void. That the person concerned, as for X, Y, Z reasons, his election gets vitiated.
So you're not challenging the election process.
Yes.
You say this person was not qualified. So it's not a challenge to the election process as a whole.
Yes. I'll give an answer from Article 191 itself. Please take me at one of the grounds of disqualification, say B. Unsound mind and stands so declared by the competent court. There may be the question of those that person's.
It's a personal disqualification of a particular candidate, not the entire election process.
Yes.
Right.
In fact, to put it in my words, here, the entire electorate is not before the court. As your lordships know, in an election petition, the entire electorate is before the court. There, the challenge, like Alorani had the challenge, on the same point, where Alorani had challenged on the same point, the electorate was before the court.
What is your locus standi as a citizen?
As a voter.
This person has been elected, my lord. My lord, a big apology to say, my lord, this person elected, my lord.
Please don't disturb Mr. Samanto. Yes.
I'm extremely sorry, my lord, extremely sorry.
Yes.
My lord, I will tell your lordship, my lord, I am not a voter of that constituency. Please have a look to, my lord, section 7 of, no, I'm sorry, section 5. I'll put it in a roundabout fashion.
5 of the RP Act.
Yes, RP Act.
Yes, section 5.
Number, this is the qualification of a member to be for membership. It says, my lord, a person shall not be qualified to be chosen to fill up a seat in the legislative assembly of a state unless, please take C. In the case of any other seat, he is an elector of any assembly constituency in that state. Therefore, my lord, I put it in a reverse fashion. That's why I say that if I can be a person of Calcutta and contest in Midnapur, any voter, my lord, can challenge.
Mr. Dattu, what did Justice Chaudhary hold? Why was he turned down?
Because the lady was ultimately found not to be an Indian national.
Right.
Her name was appearing in the voters list in Bangladesh. This issue was raised, no doubt about that.
But if it was ultimately dismissed on the ground of locus standi, you may have a point there that this was
Point not decided.
Good.
With the other point which my learned friend has urged. Fence sitter. But your lordship has found, my lord, that while the election process was on, my lord, the application was made. ECI wrote that please wait for our response on your letter, and thereafter has done nothing. Therefore, ECI should.
It was raised before the ECI itself, much after, even after Alorani's appeal.
My lord, this is, my lord, I'm sorry, my lord, your lordship.
ECI, as a matter of course, replied to you, yes, we are thanking you for the complaint and we'll revert back.
Yes, that is 18th of April 21.
Yes, but your complaint itself was in March 23 probably. So which was after Alorani's appeal. When did you first complain before the...
On 15th of April.
Before the election commission?
Yes.
15th of April 21?
Yes.
Oh, achha.
15th April, my lord, I'm sorry, my lord, your lordship's the petition before my lord is not paginated.
Hmm.
I'll give you the sequence, my lord. 15th of April, I record my objection.
That was during the election.
Yes.
Yes, my lord.
I give you a lordship the date. The RTI information was received by me on 14th of April 21, page 39. My complaint to ECI was on the next day, that is 15th of April 21,
All right.
at page 40. Then, my lord, there is another complaint which may be skipped over. Then 3rd of May, Election Commission writes to me, that is at page 42, that we have received a complaint through so-and-so portal, and we are personally forwarding this email to the concerned officer for his response.
After that, nothing happened.
After that,
Yes.
is page 20. No, after that, nothing has happened, but in between there is a letter which is at page 43, 18th of April 2021.
Yes.
Which says, kindly take note of the 3rd paragraph. We would request you to wait for the officer's reply or
Yes, yes.
or complaint revert, whatever.
Right. So it was contemporaneous with the
Yes,
election.
it was contemporaneous.
Very.
Therefore, my lord, the ECI should act upon it. That is my very respectful submission, and this is a constitutional provision, my lord, which does not call for any challenge to the election.
Good. I'll close argument, sir.
I'm grateful.
Heard learned counsel for the parties. Judgment is reserved in the matter.
Lord, what the lawsuit showing page 43 or like that, these are all separate issues that is on attack on something else, not on education qualification, my lord.
Achha, very.
Page 43 and page 44 is on different issue, my lord.
What was the issue which they raised?
My lord, they have said that action taken report was TMC candidate but beaten or like that, because in the next 44 page there was a report, my lord. Action taken report was sought from the
The
deputy
ground of challenge then? What was the ground of challenge by the petitioner then?
Then, my lord, on page 42, my lord, that is the education qualification. But 43 and 44 is something else, my lord.
Achha. Good.
But my only submission is that if they succeed anyway, my lord, if I take it in another way, my lord, I'm not saying so. No, my lord, all will come after the election. They will make a representation. After making an RTA, they will make a representation to the ECI and will say that, my lord, this has to be done, that has to be done. But that is not the procedure, my lord. They has to appear before the election. And before
Address the writ court can forward it to the governor, suppose, with an order that the governor will consult you and come to a conclusion on that. That is one of the options which Mr. Dotto is apparently arguing.
But as such, there is no prayer against us. That is my also instruction. There is no prayer against direct against ECI before lordship, my lord.
So relief has been sought against the governor.
Yes, my lord.
That's why.
Now, my lord,
Code under 226, they are saying that this is the problem. Anyway, we'll decide on that.
my lord, whatever my lord is saying that he just a general.
Let us not ponder over it. I'll
No, I have just one submission, my lord. He's a common man. He's a general public, not that, my lord. He's challenging an election, my lord, because he has been elected. That person has been elected overall, my lord. Now, not doing anything against him, man.
He's not a common man. Who? The petitioner or the elected person?
The petitioner, my lord. Because as he is saying, my lord, a senior citizen, he's a common man. He has applied, my lord. But my person concern has been elected, my lord. Now, whatever has to be done, then that seat has to be vacant, my lord. Then overall challenging the whole election process, my lord. Then again,
Right.
that is my submission, my lord.
Very. Yes.
That is remedy is only election petition, my lord.
Item 12. Yes.
I'm grateful, my lord. I'm grateful.
12. Yes. Yes, Mr. Math. What is that? বইটা ওর সঙ্গে যাবে, হ্যাঁ ওইটার সঙ্গে।
Actually, Mr. Devanjan Mukherjee is appearing virtually.
Virtually, very well. Yes. Yes, Mr. Mukherjee. Unmute yourself. আমরা ওকে মিউট করে রেখেছি নাকি? উনি করে রেখেছেন। You have muted yourself, Mr. Mukherjee. Yes. What is the matter, Mr. Mahato?
It is for new metered connection. In the first round, my lord, my application.
Affidavit of service you have filed?
Yes, please.
Right. The private respondent has been served, Mr. Mahato?
Initially, it was served the copy, and subsequently, when it has been upgraded, I sent a notice, my lord, that has been received. Delivery report
By
is
the
there.
private respondent?
Yes.
Very.
I have annexed the delivery report.
Great. Due to their resistance, it is not being given to you?
Yes, yes.
What was the previous order, Mr. Mahato?
Previous order was that since it is a new connection, therefore already there is a meter, therefore it cannot be given. It was rejected, my earlier petition. I filed a review application when my lord it has come that a meter connection can be given. Service connection cannot be given, but meter connection can be given.
So that was directed to be given.
Yes. That
Yes,
is- that
yes,
was-
Mr. Mukherjee, what do you say?
My lord, the compliances are made, my lord, they have paid the bill also. But in respect of the objection by the private respondent, my lord, we could not effect that.
Very good. The grievance affidavit of service filed today in court be kept on record. Push up. Initially, the petitioner's application for electricity service connection was refused. Push up. The matter came up before this court twice, and ultimately it was directed that a metered connection be given to the petitioner. Push up next para. However, due to resistance by the private respondent, the said connection cannot be given by the CSC Limited as per the version of the petitioner as well as CSC Limited. Push up next para.
The existing meter board connection.
Despite service, none appears for the private respondent. Pushed up. Accordingly, keeping in view the above factual circumstances of the case, WPA 18273 of 2023 is allowed, directing the CSC Limited to give a new electricity metered connection to the petitioner at the existing meter board position of the premises in question within a fortnight from date. Push up next para. In the event any obstruction is raised by the private respondent number 5 and or his men and agents in doing so, the CSC Limited personnel shall be at liberty to approach respondent number 6, respondent number 4, the officer in charge of the Chatterjee Hut police station for adequate police assistance, which, upon such approach being made, shall be given by the respondent number 4 at the cost of the petitioner by acting upon a server copy of this order without insisting upon prior production of a certified copy. Pushed up. In the event any padlock or other hindrance is put up by the respondent number 5 to resist the CSC, it will be open to the police to break open such padlock or remove such hindrance for the limited purpose as indicated above. No arrest to cause certain setback. Thank you.
13.
Your Lordship, I appear for the petitioner, Your Lordship. This is with regarding to appointment of a special public prosecutor, Your Lordship. In a case, Sessions Trial Case number 5, it is under, Your Lordship, Section 304, 341, 326, and 34. My father is the victim. He was murdered. He was attacked with a Nepala. Now, currently, the trial is being conducted in a very bad manner. Initially, the public prosecutor who was appointed, now he's defending the accused persons. A new public prosecutor has been appointed. This public prosecutor has been charge-sheeted witnesses. Key eyewitnesses have not been made charge-sheeted witnesses. 300, they have not prayed for adding of 302, but 304 has been added in the charge sheet. Subsequently, this public prosecutor has done anything of that sort. Witnesses have turned hostile at Your Lordship at page 23.
No, the public prosecutor has nothing to do with the witnesses turning hostile.
Your Lordship, the trial is not being conducted properly. That is why they have turned hostile. Key eyewitnesses have also not been called. Family members and 302, they could have made a prayer for adding 302, where my father has died and he was attacked with a Nepala, Your Lordship. That has not also been done. Previous public prosecutor is now defending the accused. The present public prosecutor has not done anything in that
You have a
regard.
right under the law to approach the concerned magistrate by making an application for clubbing.
I have made, Your Lordship, I need to be defended by a public prosecutor. I had made an application before the respondent number 2, the legal remembers cell, for appointment of one Potim Shingoda as special public prosecutor. I have that right also. That may be considered.
You have chosen a particular public prosecutor?
Yes. Special as a special public prosecutor. At page 28, my representation is there, Your Lordship. The name would appear at page 29, the second paragraph from the top. Third line, Your Lordship. 29, second paragraph, third line. The ending of the third line. Shri Potim Shingo Roy Mohashayke ei mamlaye Sakari Hishabe special public prosecutor nijukto kora hoja.
Do you have that right, Mr. Chattopadhyay?
Your Lordship, if that could be allowed, because the trial is not being conducted, Your Lordship sees the conduct. One public prosecutor who was appointed, he is now defending the, Your Lordship, the accused persons, firstly. Secondly, Your Lordship, I know that we could make how would I make an application by a person? The public prosecutor has to make the application to add 302. That has not been done. Secondly, Your Lordship, out of 11 charge-sheeted witnesses, only 5 charge-sheeted witnesses have been called, and 3 additional witnesses have been called. None of the key eyewitnesses, family members who have seen him being attacked, have been called. The witnesses that have been called, Your Lordship, they are saying we do not know anything. They are turning hostile. So these kind of witnesses are being called, although there are people who have seen. So in that way, the way the manner is being conducted.
Mr. Chaudhary, let us hear the other side. Yes, what do you say?
I beg to appeal for the state lordship without entering into the details. These are all allegations. We're really not aware.
Anyway, we'll not go into those.
Yes, Your Lordship.
Let this person be.
Yes, purely on the case of equity. Because on the
Right, only
that is, I'm not going to object
Thank
to
you
this
so much.
because that
Yes.
is
Should I record that
Your Lordship, please do
you
not
are
record that.
asked it? Learned counsel for the petitioner, who is the de facto complainant, alleges that the trial regarding the demise of the petitioner's father is not being conducted properly. The first public prosecutor who was appointed has subsequently been defending the accused persons. In the realm of the second public prosecutor, Section 302 of the Indian Penal Code has not been clubbed, although there are sufficient indicators to the effect that the victim was murdered. That apart, it is alleged that out of 3 key eyewitnesses, none have been made as charge sheet witnesses, thereby adversely affecting the trial. That apart, several witnesses have been unnecessarily called and are turning hostile. Next para, learned counsel appealing for the state controverts the allegations made against the concerned public prosecutors. However, upon hearing learned counsel for the parties, keeping in view the principle that justice must not only be done but ought to be seen to be done, it would be appropriate to appoint Sri Pratim Singhorai, who has been named in the representation of the de facto complainant stroke petitioner, to conduct the trial in question. Accordingly, WPA 19660 of 2023 is allowed, thereby directing the respondent authorities to appoint Sri Pratim Singhorai, additional, Pratim Singhorai as a special senior public prosecutor in the trial with regard to the demise of the petitioner's father. Next para. No address to cause urgent certificate.
Grateful, Your Lordship.
Thank you, Mr. Next.
14. Lord, I appear for the Regulatory Commission.
Right.
Item number 14.
I am for the WBSCT.
Appearing on behalf of the petitioner.
Please take the microphone closer.
The learned advocate appearing on behalf of the petitioner. He was present virtually yesterday, but my lord, he's not keeping well today. Kindly fix this matter day after tomorrow on Friday or Monday.
Then it goes down in the normal course. What is the urgency in the matter?
The urgency.
Well, there is no urgency at all because as per tariff determined by the Regulatory Commission, bill has been raised.
Yes, my lord.
An adjournment is sought by the petitioner. I do not find any urgency in the matter. Accordingly, let the matter stand adjourned till December 1, 2023, when it will be listed under the regular heading. Great. That is Friday.
List, December 1.
Friday.
Friday. Oh, fine.
What?
No, I was thinking whether it was monthly list or not.
Yes.
15.
Yes, Mr. Bhattacharya, what is the matter?
I am for the petitioner, my lord.
Service.
Service.
Good service has been effected, Mr. Bhattacharya. Have you checked up?
Yes.
Good service has been effected?
Yes.
Well, what is the matter?
And this is after mentioning before your lordship, after the matter was upgraded.
You have also given a notice. Yes. Right. What is the matter, please?
My lord, it's a registration of deed.
Please take the microphone a bit closer. Yes. Registration of deed, yes.
My lord, the petitioner number 3 executed 2 gift deeds. The petition number 3, who executed the gift deed, is octogenarian, now bedridden person. Anytime, anything may happen.
It was executed in favor of petition numbers 1 and 2.
Yes.
Right. Why refused now?
No. Now, recently it has been, the petitioners come to know that in the schedule of the deeds, the moja has been written wrongly. Everything is correct. In body of the deed also, everything is right. But in schedule of the gift deed, there is mistake. By mistake, this, my lord, I am placing that page 11. If you also kindly come to page 11.
Yes.
Page 11, left-hand side, my lord. Fourth line, Mouja Mihitikari. As your lordship.
Mouja Mihitikari, yes.
Mihitikari.
That is the correct, that is the wrong Mouja.
That is correct.
Right. In the schedule, it has been mentioned wrongly.
Yes. Page 12.
Pulshita.
Yes, in schedule of the property. In page 12 also, my lord, rightly mentioned.
Only page 15, Pulshita.
Pulshita. This schedule.
So what do you want now?
Now, my lord, for rectification of the deed, the petition number 3 wanted to execute another deed, deed of correction. It is annexed at page 40.
How would the deed of correction be classified as?
Ghoshana Patra.
Declaration. Deed of
declaration.
Right.
This was placed before the registering authority.
Yes.
Now, my lord, registering authority, without endorsing anything, without mentioning that they refused, simply returned. Now, I don't have any avenue.
Mr. Bhattacharya, under which provision can it be, can it be classified? Just tell me. Under the Stamp Act?
Section 71, my lord, I shall place before lordship. My lord, I am extremely sorry.
Yes, no difficulty.
I have bad habits of.
No difficulty, yes. Section 71, right. Oh, yes, 71 is there.
Yes.
No, you want a reasoned order to be passed by the registrar so that you can take steps.
Yes.
I'll direct that.
My lord, my lord, either he should accept, he should get record it, because that is his duty. If at his whim he feels that no, I shall refuse it, he must.
Who has to be directed? Who is respondent? 2 or 3?
6.
3.
6. 5. 6.
6. Very well. Despite service, none appears for the respondents. Push up the affidavit of service and the receipt of service of notice of mentioning be kept on record. Push up the petitioner number 3, who is an octogenarian, executed a gift deed in favor of petitioner numbers 1 and 2, in which, in the schedule portion, there was a minor error regarding the mouza, although the mouza was correctly mentioned in the other portions of the gift deed. Push up accordingly, a deed of correction in the form of a deed of declaration was presented for registration before the respondent number 6 authority. However, the said authority, without recording any cogent reason whatsoever, has returned the document and is not accepting the same for the purpose of registration. Learned counsel for the petitioner relies on Section 71 of the Registration Act 1908, which stipulates that every sub-registrar refusing to register a document except on the ground that the property to which it relates is not situate within his sub-district, shall make an order of refusal and record his reasons for such order in his book number 2 and endorse the words within single inverted registration refused on the document. Next para, it is further submitted that in the present context, there cannot be any conceivable reason of the registrar refusing to so register the deed of declaration. Next para, there is substance in such contention. Accordingly, WPA 21958 of 2023 is allowed, thereby directing the respondent number 6 to accept the deed of declaration presented for registration by the petitioners before the said authority within bracket annexure P3 at page 35 of the writ petition, bracket close, full stop. Upon such acceptance, comma, in the event the respondent number 6 is of the opinion that registration is required to be refused on some cogent legal ground, comma, the respondent number 6 shall comply with section 71 of the Registration Act and give proper reasons for such rejection, full stop. In the event there is no such reason, comma, the respondent number 6 shall proceed in accordance with law to register the said document, comma, subject to compliance of all formalities by the petitioners. Full stop. Such exercise shall be concluded by the respondent number 6 within 3 weeks from the date of communication of this order to the respondent number 6 by acting on a server copy of this order without insisting upon prior production of a certificate.
Deeply well.
এটা ফেরত দিন। No order as to cause certain certificate copies.
16.
May it please your lordship,
Yes, Suzanne.
This matter, my lord, had once been taken up earlier. There have been directions for affidavits. A limited interim order refused by the Honorable First Court. Matter carried in appeal. Interim order granted for a limited period. The matter went up before the Honorable Supreme Court. The Honorable Supreme Court has left us free to raise all points, including asking of further interim relief before your lordships. The point, my lord, is very simple.
No, as of today, there is no interim order.
As of today, there is no interim order. There was an interim order, my lord, granted by the Honorable Court of Appeal for a limited period, leaving us free, my lord, to approach the Land Reforms and Tenancy Tribunal for the purpose of filing an application in connection with a pending proceeding there. My lord, I shall explain, my lord, what has happened here. The point in issue is very simple. Pursuant to a CIRP process under the IBC, Ram Swarup Industries Limited, my lord, its debts were resolved. In that approved resolution plan, a particular land in Durgapur, that particular land was the land in which the plant of the RIL was situated. In the approved resolution plan, that particular land, which originally belonged to Vanguard, which was a company which was held by one of the promoters of the RIL. Now, Lord, that particular land, my lord, was held to be land belonging to RIL. In the approved resolution plan itself, therefore, this land now belongs to RIL. After this is done and over, and RIL takes over, when it is in the process, my lord, of trying to start its business activities, the land reforms authorities issue in the year 2022 notices pursuant to certain proceedings. They allege that these proceedings are in connection with the Land Reforms Act. And they say that under these proceedings, the family members of Ashish Jhunjhunwala, who was the original promoter, they are required to give certain information to them. Ashish Jhunjhunwala's family members, my lord, informed that in the meantime, this particular land belongs to RIL, that is the petition number 1 by virtue of the corporate insolvency process. And they tell the land authorities not to take any further steps in connection with this. But they go right ahead, the land authorities go right ahead, and then they purport to make an order of vesting under the West Bengal Land Reforms Act pursuant to a proceeding initiated in 2022 in respect of a
vesting
land.
on the premise that it belongs to that director, that promoter.
The vesting on the premise that it belongs to certain family members of
although in the approved resolution plan, it has been held to be the property of the company.
In the approved resolution plan, it vests in the company.
Yes. After that, this vesting is sought to be done.
After that, this vesting is sought to be done in 2022.
So you have challenged that.
So we challenged that. When we went forward there, Lord, we received only a notice of.
So you have to go before the Land Reforms and Tenancy Tribunal.
Yeah, Lord, that question came up.
Rightly.
Question came up. Point was
ultimately you are challenging an action of those authorities under the specified act.
Yes, but then when this question came up before the Honorable Single Judge, my lord, this point was taken, my lord, by the land authorities, and interim order, my lord, was not granted by the Honorable First Court. In the appeal, the Honorable Court of Appeal has been pleased to hold that this point will be decided in the writ petition.
I am deciding it goes to the tribunal. Obviously, it has to be your CIRP approved plan is a ground of defense. Yes, Mr. Banerjee, why not? Mr. Senior Mr. Banerjee, why not?
Without jurisdiction. No opportunity given to us without jurisdiction. Totally without jurisdiction. Malad, land and Malad, we went up Malad, on this question as Malad, Mr. Ornament said, and Malad, the Honorable.
You can take all the points before the tribunal because
Malad, the Honorable Supreme Court has said Malad, that this will be Malad, really before the.
Please show me the Supreme
Malad,
Court.
there are two.
Show me the order which goes in your favor regarding time, regarding maintainability. No, so that I can, if I.
Malad, this issue Malad, perhaps Malad has to be decided Malad by this court because it is such a Malad, on the face of it, Malad, such a stark fact with regard to Malad, the land. Malad, they started vesting proceeding 2022.
What is the date of the approval of the resolution plan?
Malad, resolution plan Malad was approved Malad, on 4th September 2019. The CIP process was started 8 January 2018. Approval was Malad 4th September 2019. Affirmed Malad by the NCLAT on 4th March 2021. Then Malad by the Supreme Court on 4th May 2021.
And this vesting is proposed
Malad,
to be done.
it started Malad by notice by Malad revenue officer Malad was to Vanguard Malad to the previous company on Malad 25th August 2022.
By that time, they were no longer any.
And by that time, Malad, they were no longer Malad also with the resolution plan. It's Malad transferred to me under the resolution plan.
You were never given any notice.
No. Malad, only the last one, Vanguard has sent us Malad when we Malad.
Nobody pointed out to the revenue officer that this has happened.
Yes, yes.
Who pointed out? Vanguard.
Vanguard pointed out. And we also did.
What is the impugned order?
Malad,
what are you challenging? The notice itself or?
Yes, Malad. Notice Malad of possession Malad, that's 17th March. Right?
An order was passed apparently.
It's
no, this is regarding the
2023.
7th September 23.
The communication that 8 September 315, page 350.
What are you challenging here? Please place that once.
Malad, kindly look at Malad, page 315.
Yes. What is 3?
And then kindly see Malad 316. This is one of the communication which forwarded.
316 is not a correct translation. He is not a correct translation.
No, you have not challenged the vesting. Because this is a notice that it has been vested and
we have challenged this because otherwise we are not aware what is the.
No, you have to challenge the vesting also because it says that আপনার such and such একর জমি সরকার কর্তৃক vest করা হইয়াছে. If the vesting
to Vanguard.
To whoever, if it has been vested in the government.
Yes.
I mean, the vesting has to be challenged also. You can they prefer this challenge before the tribunal. I mean, the vesting itself.
The facts
why
are
skip a forum?
Facts are so stark. I think
No, difficulty is, Mr. Banerjee, if suppose an order is passed by the LRTT, it has to go before the division bench probably against that.
Yes.
So ultimately, there are two forums lost. One, secondly, the writ court sitting singly. For propriety's sake, I mean, it should ultimately, if the appeal goes to the division bench of this court, should I take up the, main matter? Because the tribunal
is to this entire jurisdiction being exercised. Where is the question?
What have you challenged? The vesting has not been challenged by you.
Lord, we have challenged, Lord.
Vesting order you have annexed.
Page 33, Lord, of the purported notices, Lord, all these notices, Lord, which were later purported order of vesting. That is also, Lord, P13. Because this is all, Lord, we have got.
No.
That's one of the very peculiar facts. As to how did they proceed? After 30 years, all of a sudden, notice given to the ex company and saying.
I'm granting, I'm entertaining it. Learned Senior Counsel for the petitioner points out that initially interim order was refused by a coordinate bench, which was challenged in appeal, which of the appellate court granted a limited stay. The matter was taken to the Supreme Court. The Supreme Court finally granted liberty to the petitioners to raise all pleas and contentions before the single judge in accordance with law. and kept it open for the petitioners to file an application for interim relief in case they are threatened by way of disposition from the plot in question. You have preferred a separate application, interim
No, my lord,
application?
still we have.
Full stop.
Because they have,
Next
my lord,
para,
not-
learned senior counsel points out that since the writ petition itself contains prayers for interim relief, comma, no separate application has been taken out, push up, there is substance in such contention, and it is deemed that the interim relief, that the application for interim relief contemplated in the order of the Supreme Court be deemed to be the interim relief sought in the writ petition itself. Push up. Next para. A strong prima facie case has been made out to the effect as to whether the respondent authorities were justified in vesting a property which was the subject matter of a corporate insolvency resolution process within bracket CIRP, which culminated in the approval of a resolution plan which reflected that the property sought to be vested, vested in the petitioner company. Full stop. Next para. The question which is required to be gone into is whether, in view of the contemplation of the Insolvency and Bankruptcy Code, comma, the resolution plan, comma, once approved, comma, attains finality notwithstanding the operation of any other law, comma, including the West Bengal Land Reforms Act, comma, which vitiates the act of vesting itself and all consequential notices. Push up. Next para. Accordingly, the writ petition is required to be heard on merits on the questions as formulated above. Push up. The respondent shall file their affidavits in opposition within 3 weeks from date. Push up. Reply, if any, shall be filed by January 5, 2024. Full stop. The matter shall be listed for hearing on January 10, 2024. Full stop. The respondents shall remain restrained till February 15, 2024 or until further order from acting pursuant to the impugned vesting and all consequential notices and action taken pursuant thereto, and or from ousting the petitioners or disturbing the petitioner's possession in any manner with regard to the property in dispute.
Grateful, my lord, because they have, my lord, now, my lord, taken consequent action, my lord, that is also, my lord, then, my lord has already.
All consequential action, including
Yes,
notices, pursuant to that vesting.
Yes, grateful, my lord. I'm extremely grateful.
My lord, under compelling circumstances, my lord, I want to, my lord, mention one matter, my lord.
Yes.
The wife of my client is a cancer patient, my lord. Son is also undergoing a very serious thrombosis in the leg problem, my lord.
Why didn't you mention in the morning?
My lord, he came from Bangalore, my lord. I came from Burdwan, my lord. In the way I got stuck.
What do you want now?
My lord, if the matter could be upgraded any day, my lord. Tomorrow.
Hand over. কালকে দিয়ে দিও উপরে।
Much obliged.
It is appearing in the list.
Yes, ma'am. 130.
Item number?
I've written, my lord. 130.
Right. কালকে upgrade tomorrow.
My lord, I'm great.
Part heard matter fixed at 2 p.m. Item 35.
Your Lordship, I'm led by
Please, Your Lordship.
Mr. Vipul Kundalia. Your Lordship, he did not come to court today, so I am kindly praying.
He was to submit.
I'm in the middle of submissions.
He'll complete the arguments. Let Mr. Kundalia come on the next day, take notes. Yes, Mr. Bag.
My lord.
I'll request you to file short notes of arguments tomorrow. Not tomorrow, I mean whenever you can.
But I'll do so.
Just conclude your arguments today.
I will conclude.
In a nutshell, just conclude. Yes.
I will, my lord. Only 2 documents, my lord. I'll request your lordship, my lord. I'll take some time to go through those 2 documents. Rest of, my lord, the submissions, I'll conclude very briefly.
Very well. Yes.
My lord, I had submitted and I was in the middle of submitting the reply given by the petitioner. My lord, may I start with that? It's our reply. This is volume 6, page 1124, my lord. Volume 6, page 1124.
Yes.
The time frame, my lord, was that the show cause notice was given on 2 dates for 37 properties, 28th of March 2022 and 29th of March 2022. And I had taken your lordship through those details, my lord, as to what they have alleged in the show cause notice. And then this reply is very important. Kindly allow me, my lord, to quickly place the reply. It's dated 27th of May 2022. Paragraph 1 onwards, I'll only read the relevant parts. Most of it is relevant, my lord. Our company was totally surprised to receive for the first time summons under section 19 of the Act, requiring us to attend the office either personally or through AR on 27th December 2021 for recording the statement on oath on a subject not divulged to us in the summons, with a caution that in case of failure.
Mr. Bag, if this is your arguments, basically, why read the entire thing? I mean,
my lord,
why are you reading the entire reply of yours?
Because the reply, my lord, records certain facts which are to be noted, because the main reason is, my lord, how this reply has been dealt with through their letter.
All right.
These are the 2 documents, my lord, I'll trouble your lordship with.
No, very well.
Mainly because, my lord, their reply hinges on
but
what
this
we
reply
have.
will take a lot of time, Mr.
I'll quickly, I'll not take more than...
No, I cannot permit you to read the entire reply. I'm sorry. Because
But I'll not read the entire reply because they have set out.
It continues for 17 pages. It's a wastage of time to read.
No, my lord.
And in any way, I cannot retain in my memory the 17 pages.
But it will not be 17 pages.
There's no use reading the entire thing and then saying.
This is
highlight the points, say that these were not
I'll
dealt with, put it in your written notes department, come back with that.
I'll indicate the points, my lord. Here, most of it is, I'll not read out because it is, my lord, the sections have been quoted. So that part will go.
Yes, exactly. What
First, they have indicated, my lord, in the reply.
Yes.
That summons was not with the details as to what was required to be disclosed by us. So summons was vague. That was the first point taken. The second point, my lord, I'm not troubling your lordship with paragraph 2. This is, my lord, on the legal point as to while trying a suit and interpretation thereof. I'm not troubling your lordship with that. That is one point which has been taken, but that is not of relevance. Paragraph 3 is important, my lord. This goes into the facts.
Place it.
Without prejudice to the legal deficiencies of the summons in the Act, and even though a question of the specific purpose for which has been asked, to attend barehanded before you for recording our statement on oath has been kept totally secret as noticed from the summons we had filed before you voluntarily. This is important, my lord. Voluntarily a letter dated 5th January 2022, filed on 12th January 2022, and also submitted by email on 10th January 2022, along with an annexed tabular statement giving a short summary of the details of 37 landed properties purchased, owned, and held by the company. This is important, my lord. The reason this is important is, my lord, the show cause notice was dated March 2022. And this is in January. That all these details were given. And the details are enumerated, my lord, what all details were given, and this is also an enclosure to this letter. So I'm not troubling your lordship with these details. Everything
What is the
was given.
occasion of giving the letter?
Because these were pursuant to the summons. Summons was in December, my lord. This is in January.
Very good.
Summons was on 20th of December, 2021. Then paragraph 4, they say I file a second compliance letter of 20th January, which was filed on the next day, 21st January. Identical tabular statement. I'm not troubling your lordship with this also. Paragraph 5. Section 19, they have explained. I'm not troubling your lordship with that. That's on the point of summons, how they can't issue it.
Legal points in any event you will argue.
Yes.
I mean,
My lord, I will indicate that. So I'm not placing this.
Please.
Paragraph 6 is relevant, my lord. Unfortunately, your initiating officer has hurriedly passed behind our back without prior knowledge, communication, a separate order under 24(3) of the Act, making provisional attachment of each of 37 landed properties registered under different deed numbers, treating our company as Benamidar of the properties, which shall continue to remain in force for 90 days. And then these orders have been passed merely by forming an opinion, last 3 lines, my lord, of the paragraph, merely by forming an opinion without any basis. That is what was noted by, my lord, this honorable court in the impugned, in the, my lord, order granting us injunction. Because there was no reason given, nothing. Next paragraph, my lord, simultaneously, show cause notice was issued, and this is in reply to the show cause notice. This last line is very important in paragraph 7, page number 4. Simultaneously, order under 24(3) show cause notice has been issued on the same date for these properties, 15 days of receipt, to attend your office, showing cause as to why the said landed property should not be treated as Benami properties of our company within the meaning of 2(8), read with 29A, 210. This is important. These are the provisions they want to invoke. 2(8), 29A, and 210. And thereafter, my lord, I will not trouble your lordship with paragraph 8, 9, 10, my lord. Second line is important. They only take a point that reasons should be recorded in writing, which with the prior knowledge, they will indicate that it's there in the file. I'm not troubling your lordship with that also. Paragraph 11 is relevant. It is not known from what external sources have you collected the said information. Paragraph 11. With pains, without ever considering the said information is already on the records of the Income Tax Department, fully disclosed in our annual audited accounts and the income tax returns for the years. These are the period in issue, my lord. Corresponding to the 3 years of investment, a little effort from your end could have eased the situation. The said landed properties purchased by our company and the source of purchase has been fully and truly disclosed in our annual audited accounts vis-a-vis the income tax returns of those years. A summarized statement has been furnished before you in a comprehensive tabular chart filed by this letter. So it is given, it is disclosed in the audited accounts. That's also disclosed. We got paragraph 12, the third line, fourth line, my lord. Show cause notices under section 24(1). Who is the real or are real beneficiaries of the landed properties, and our company Benamidar is the Benamidar of all those 37 landed properties. Observations made by you appears to be a mere hearsay. In your show cause notice, you have made certain oblique baseless references to a sufficiently old financial is indicated. This is relevant. Financial year 2011-12. Kindly note this, my lord, because this is where, my lord, I'll place the judgment, and that's very, very relevant. My lord, there's a judgment of Supreme Court Ganpati Dealcom. But it's otherwise not very relevant. It's only relevant if the point of retrospective operation is brought in. 2016 amendment, if there's a retrospective operation, then it will not apply. Supreme Court has held that now. It traveled from Calcutta High Court, my lord, and there was a stay, which was noted by them in their reply. That is the reason, my lord, I have to read out this reply, because in their reply, they admit that yes, there is a stay of the Supreme Court, issue is pending. If we go ahead with it, and thereafter Supreme Court decides that it will not have retrospective application, then we'll have to abide by the Supreme Court's decision. So Supreme Court has now decided it, that it does not have retrospective application. This assessment year is important. The financial year is 2011-12. 6 years preceding the first, because their allegation is on the share transfer, my lord. That happened in 2011-12, not after that. First year of purchase of the properties is 2019-20, which is as such totally irrelevant. A complete failure on your part to affirmatively ascertain the name of the real beneficiary owners, and that our company is an ostensible owner branded as Benamidar totally demolishes your presumptive and illusory theory, invoking 28, 29, 210 of the Act. No evidence what the name has been placed on record on the basis of which your honor has framed such belief. There is nothing on record to prove that the apparent was not real. Now, the next paragraph, I'll skip that paragraph. That's only, my lord, the 143(3) order of the Income Tax Act saying that I've disclosed everything. It has attained finality. There's an assessment order. So that has not been reopened. Now, my lord, kindly take up the next page, paragraph 14. Comprehensive chart, tabular statement given. And then the facts are, my lord, given here. Show cause notice, may I quickly indicate this, my lord, 14.1. Show cause notice dated this. You have conveyed information that you believe 37 immovable properties within the district of this is Benami property within the meaning of 2.8 of the Act. Our company is Benamidar. You have further stated that 2.9D, this is very important, 2.9D of the Act, the transactions appear to be in the nature of Benami transactions, as the persons including the consideration are basically from non-traceable fictitious shell entities. Next, my lord. While allegation, second line, this is, my lord, 14.2. Without providing us any evidence or document which can firmly establish the truth behind this, having performed Benami transactions on immovable properties, abrupt belief. So we disregard that, my lord. Next, subpara 3, we again reiterate by saying 2829D is not applicable. And 4, our company was incorporated in 2012 as a going concern. It has remained as a going concern. Our company, through its directors, purchased 37 properties in these financial years, my lord, through registered conveyance deed. Subpara 5, the amount is indicated, my lord, that this is the total amount that's coming to. Subpara 6, the chart is again indicated and the audited balance sheet of the company is indicated, and it's indicated that how the funds, my lord, were transferred. That's what, my lord, the chart I had indicated on the last day. That's also an annexure here. Now 7, the next page, my lord, subpara 7. But as apparent from your show cause notice, you have completely, kindly underlined this, my lord. You have completely ignored the submissions made by us regarding the source of funds for purchase of properties. You formed your own opinion that the source for purchase of the properties is share capital received from shell companies, because we have disclosed, my lord, and they have not taken that into consideration. In this regard, it is reiterated that not a single farthing of the purchase consideration for the property was provided or paid by another person. The source of funds utilized for the said purchase are explainable from our regularly prepared annual audited accounts. So we've explained that, and we've taken this point that you have disregarded all the explanations that we have given. That's disregarded by them. Now, the next subpara, again, it's a reiteration, my lord, of 20, how this is not, my lord, applicable in the case because of 143(3), which has concluded. Subpara 9, the first 2 lines are very relevant, my lord. The share capital raised during financial year 2011-12 was duly accepted by the department in its assessment order under 143(3) dated 2014. So this is also, my lord, 2014, before the amendment of 2016. And the next 3 lines are important, because during this period, kindly see, it is indicated that notices were issued under 133(6) under the Income Tax Act. That's compelling them to come and give their statement. And they have given that statement. And the second last line of the page, assessing officer has accepted the share capital issued during the year as genuine and has also accepted the identity, creditworthiness, and shareholders as true. That's where, my lord, the case of 68 comes in, which I was referring to on the last day, because these are the 3 ingredients, my lord, for section 68, which has been complied with, and that has attained finality. They can't reopen it now. We are then 10, subpara 10. For instance, if the case is so wrongly presumed that the source of purchase of the properties is from share capital, then in the case of our company, so far as the share capital is concerned, the Amendment Act of 2016 shall not apply, and the old Act of 1988 shall be applicable, as because the Benami Act has been amended by the Parliament in 2016, which does not apply to transactions entered into before 2016 and is not retrospective in operation. The large number of, I'll not trouble your lordship with the rest of the part. It's basically, my lord, that point which we have taken, retrospective operation point we have taken. Thereafter, subpara 11, we indicate that ROC, we have complied with the formalities which are required to be complied with before the ROC and the income tax authorities. and we have enclosed everything for their perusal. You know, a query had fallen from your lordship on the last day, whether it's an advance or a loan. But from this reply, the next subpara, the next page, the second line, refund of loan. It's not an advance, my lord. Rest of it, my lord, I'll not trouble your lordship because that's the provision. Now the reasons why it cannot
Refund
be
of loan given by you.
Lord, loan given by RIMJIM to us, which we are required to refund, my lord. We are required to give back. So it's not an advance, mere
Investment
advance.
was made out of our own funds.
Out of the own funds.
Stroke refund of loan.
My lord, because
that means investment made out of refund of loan.
Yes, my lord.
That
So
could only
loan
be
was
your,
given, my lord, own
you gave
funds.
loan and, yes.
Own funds, because my lord, out of the 37.
Own funds, I get it, yes.
My lord, these own funds are out of the loans which we have given to different companies, and from the refund of those loans,
they have refunded to you.
They have refunded to us.
Exactly.
And that's only for 2 or 3, my lord, of the transactions.
So that cannot cover RIMJIM.
So that's
RIMJIM did not refund any loan.
No, my lord, that's indicated as
that's
our own
different.
accounts. Our own accounts. My lord, paragraph 16, this is, my lord, page 1135. The reasons.
Bag, according to you, what is the difference between a property being purchased by funds provided by somebody else, Benami, and from your own funds given by somebody else? The proximity in time, what is according to you the determinant?
The moment the funds come into our account and we make the payment, it no longer remains Benami. It no longer remains Benami. It would be Benami, my lord, if RIMJIM would have...
Because it's channelized through your funds.
Yes, my lord, because that then it would show that it is us who have purchased the property with our funds, because that becomes our funds. The color of the money, my lord, then changes. It becomes our funds.
No,
it is no longer there.
So Benami, that happens. That is only
No,
what
my lord,
happens.
Benami, the ingredient, I'll indicate that from judgments. My lord, Benami,
if
the
I purchase
ingredient.
in your Benami, I hand over the money to you and you purchase.
No, my lord. Then they have to make that payment. It is not that I will make that payment.
If they purchase directly, then there would not be any question of Benami, Mr. Babak. If they purchase with their own funds directly, it was not channelized through your accounts, then there would be no question of Benami. Then it's a direct purchase.
In my respectful submission, if they purchase it, my lord, by their funds, and if the properties are registered in my name, I become the beneficial owner.
Yes.
Hence, it's a Benami transaction.
Right.
But today, if, my lord, I take a loan from a company, as a company, and I invest it and buy it in my name.
You are purchasing through your funds, but the money is provided by them.
No, my lord. I am purchasing from my funds a part of it. The rest of it.
Your funds means the money which was given by them to you.
No, my lord. Our funds means the money, not that's shown as loan. Advance from
whatever you show it as. Whatever you show it as.
My lord.
Money was given by somebody else.
Out of the 37 properties, I'll indicate that from the chart, my lord, which is just the next page. My lord, out of all these properties, only a few properties it is indicated as out of own funds. These funds, because they are in the business of giving loans and, my lord, taking back the money with interest. So the surplus.
You give loans.
We give loans. We give loans and take back the money.
But RIMJIM provided the funds directly. It was
here
not
2 crores. 2 crores was provided by RIMJIM, out of which we utilized 98 lakhs in purchasing these properties. We have refunded the rest, or in the process of, my lord, refunding the rest. Allegation. Here, my lord, if RIMJIM was not known, we have always disclosed that it is RIMJIM. RIMJIM as a company, we have taken loan from RIMJIM. They say we don't know whom you have taken the loan from. We have given all the documents to show.
The properties in your name, right?
In our name.
In your name. RIMJIM parked the money with you. With that, you purchased the property in your name. So why is it not a Benami?
If their case was that it is through RIMJIM, I would have to answer that.
RIMJIM is never
in the picture.
You're right.
And that's always our explanation.
There is no allegation of
no allegation of RIMJIM.
You're right.
No allegation of RIMJIM at all. And that's the way we explain that we have taken the loan, we have purchased it. The moment we purchase it, it is registered in our name, in the name of the petitioner. The moment that happens, the characteristic of Benami transaction goes, because then it is for the department to show prima facie that it is for the benefit of RIMJIM. I am in possession of the property. The title deeds are with me. It is for the company's future interest. It is not for RIMJIM at all. It's a way of, my lord, investing for the company.
Very good.
But why it is not a Benami transaction is paragraph 16.
For all practical purposes, it was your property purchased in your name and you are the utilizer of that.
And we are in possession. We are in possession of the property, of the title deeds.
You are utilizing the property.
We are utilizing the property.
Very good.
And they have not investigated Rimjim even after we have indicated this is how the money has come in. No allegation, my lord.
Right.
Paragraph 16, my lord, this is at 1135. These are the reasons given by us as to why this transaction is not a Benami transaction, hence important, my lord. It is clearly evident from the records lying even before the two authorities, that is, these are the authorities, ROC, that our company is the absolute owner as well as the beneficial owner of the said immovable property with all its rights and privileges under the laws of the land, including the law of registration covered by the Transfer of Property Act. The real ownership of the company, of our company, in the said immovable property with all its inherent rights and privileges is therefore an unquestionable fact and is beyond the third party's right to make any actionable claim over the property. There is no question of treating the said transaction as Benami investments in terms of the Act. Next, my lord, clause B, it's on point of law. I'm not indicating that. Thereafter, my lord, 3.
Same thing in different forms.
Same thing in different forms, my lord.
All the paragraphs, yes.
The 3 is important.
Like the answers to questions when you're not, aware of the exact answer,
we try and find
yes, the same thing put in different form. Anyway, but the arguments, these are legal arguments.
These are legal arguments, my lord. I'll not trouble your lordship with
basically
this.
9-2.
Basically 9-2, my lord.
Right.
Thereafter, my lord, paragraph 17, I'll not trouble your lordship. 18, these are all judgments.
Right, definitely.
19, I'll place before your lordship. Then 20. Burden of proof, the point is taken. I'm not troubling your lordship with the entirety of the paragraph. It is only that burden of proof is on them. They have to first discharge that first primary owners.
Right.
21, my lord. Again on point of law. 22. This is at page 1139.
Right.
It's saying rule 5 was not followed. Hence 24.3, 24.1 is also bad in law. I am on a more fundamental point here of jurisdictional fact. If they don't have it, they can't assume right. Because the moment they show jurisdictional fact and the fact that they can assume right, but my remedy will not lie before this honorable court. Then I'll have to go before the suit court. But here I am only on the point that jurisdictional fact they cannot satisfy, and I indicate why. The rest of it is, my lord, reiteration of the submissions. Essentially, the encapsulation of these paragraphs are, my lord, that this was purchased by the company. The company knows how the funds have come in. The department has been made aware of it. The department chose to shut its eyes and take cognizance of the various submissions made by the company.
And all the compliances were made regarding the 6-year back transaction.
Everything. And there is no allegation with respect to the share dealing. In fact, that is the reason, my lord, since they cannot open it through the section 68 angle, they chose to do it through this line, but they can't. That's my case, my lord. Now, very important, one, my lord, document which I had placed on the last day, I'll only indicate that, page 1141. This is the chart I was referring to, my lord.
Because it's spread over so many places, Mr. Bag, you personally settle your written note of arguments, because that has to be very succinct.
I'll do that.
Just the points.
Only the points and the relevant pages.
There are several relevant points you are arguing, so those have to be in one place.
I will do so. I'll do so, my lord.
It cannot be a replica of this.
No, my lord. Definitely. Definitely, my lord. But the reply is extremely relevant. This was dated, lord, at page 1141. Kindly see, my lord, the tabular chart, extreme right hand column. Lord, you will find most of it is loan receipt from Rimjim Construction.
Rimjim is not under the scanner even by claim.
Scanner, and this is where the amount comes in. In fact, that is there. That is how we explain that this is the source of the funds. If the source of the funds is not known, if the beneficial owner, if we have disclosed that Rimjim has given this money, then either the beneficial owner has to be me or Rimjim.
One of the fundamental facts which you are arguing, which you argued right now, is that you are not using it as for the benefit of somebody else. You are utilizing.
I bow down, my lord.
Have you produced anything to show that your assertion of rights regarding that property possession is there?
Possession is there. Title deeds is there.
No,
so my
assertion is obviously there.
Possession is there, my lord. Usually, title deeds are kept with the end beneficial owner. That's also, my lord,
custody of the title deeds.
Custody of the title deeds. We have
possession is also there.
Possession is there. It's for the future use of the company. There is nothing, my lord, which shows that it is not for the future use of the company.
And you have the burden of proof point already.
Burden of proof point we have already. Yes, my lord.
Very well, yes.
And also the fact that when the share transaction actually happened in 2011, there was no, my lord, no doubt was raised. Nothing was cast on us. Now the reply, my lord.
Hmm.
This is 10th June 2022, volume 7, page 1202. Page 1202, my lord. 10th June 2022.
Yes.
First part, my lord, I will not trouble your lordship. They've set out section 9. Then while trying the suit, that allegation has been dealt with, that I'm not troubling your lordship with. And he has negated why in law this is not right. One line of paragraph 4, my lord, this is at page 1204. 1204, paragraph 4.
They give a further reply to you.
They gave a further reply, my lord.
Why?
To explain.
Why should they? I mean,
They
should take a-
need not, my lord, and there they made a fundamental error. That's what I'm going to indicate now. They've tried to deal with all the allegations, and there, my lord, this is my case now. In the reply, we had also again indicated money came from Rimjim. They choose to disbelieve.
They gave a show cause to you.
They show cause.
You replied.
My lord, they show caused us in March.
You gave a reply.
We gave a reply.
Which you placed. Right.
Which I placed, my lord.
They give a further reply
They
to
gave
that.
a further reply to that. And in this reply, they
had your man there. You must have had somebody there.
I don't think so, my lord. I do not know.
I mean, this is unheard of.
This is unheard of. It is usually they don't. This they did, and they dug their grave. I'll indicate why. This is perhaps, my lord, something that is an insuperable, my lord, act which they have to come out of. I do not know how they will. My lord, kindly see paragraph 4, the last line.
They can sack this person.
They can, my lord.
I
But then
they have not.
This document remains. It's an official document, it remains.
Very
But kindly see paragraph 4, the last line. Thus, the contentions of Benamidar are false and denied. So they have already treated me as Benamidar, the petitioner before your lordship. That's paragraph 4, my lord, page 1204, the last line. And there, my lord, here they are explaining 24.3, 24.1. I'm not, my lord, troubling your lordship at all with this. Kindly see paragraph 7.
What is the contentions of Benamidar are false and denied means? Your contentions are false and denied. What is?
Our contentions are, my lord, denied.
Yes.
Our contentions are denied. Paragraph 7, my lord.
7, yes.
Contents of paragraphs this and this are mere allegations by the Benamidar on the IO and the procedure of passing SCN. It was after the complete investigation and gathering of various relevant evidences from the bank's register office, revenue authorities, private agencies, and internal sources of the department, such as ITBA, e-filing portal, etc. Statements of various alleged persons under section 132(4), 131 of the Income Tax Act, and 19(1) of the Benami Act. And after due approval of the approving authority. This is relevant, my lord, because your lordship, my lord, it fell from your lordship on the last day that 68 is through the income tax authorities. I also show from the act that, my lord, the authorities are the same, the officers are the same. So, my lord, here they invoked Income Tax Act 132(4) and 131. And after this, they come to, my lord, very interesting reasoning. Kindly see paragraph 8. This is page 1204, the last 2 lines, my lord. That to the contents of paragraph 12, it is submitted that the IO of the present case has very clearly in the provisional attachment order has established the role of each and every Benamidars and how the unaccounted money has routed through the dummy accounts for the beneficial use of the Benamidars or beneficial owner. Hence needs no specific reply. Look, beneficial owner, he's there, they indicate it's for the end use of the beneficial owner. I'll now read on and I'll indicate, my lord, how they have said there is no beneficial owner. Beneficial owner cannot be traced. According to them, beneficial owner cannot be traced. And hence, my lord,
show me that.
I'll come to that, my lord. But before that, may I only indicate, because otherwise, my lord, I'll just lose out here, paragraph 11 once.
Yes.
This is how they deal with, my lord, the retrospective application. I'll not trouble your lordship.
It's a legal argument.
Legal argument, only last 2 lines, my lord. Only the last 2 lines here. Needless to say that in case the final order which is being passed shall always be subject to the decision of the Honorable Supreme Court.
For this year.
Only this, my lord, because that decision has now come. It's in our favor. Thereafter, my lord, I'm not troubling your lordship with the judgments which they have referred to. May I request your lordship to take up page 1212. The second paragraph.
Yes.
Now, this is also a legal argument under Article 21. I'm sorry, my lord, this is also not relevant. Sets out the. Kindly take up, my lord, page 1213, the last paragraph.
Yes.
In 2016, the act was not repealed, revoked, cancelled, or abolished. So this is the last part of page 1213. Abolished, but several sections were incorporated to remove the aforementioned inadequacies. There is no question of the act being only prospective with effect from 2016. Next page, issue of adjudication on the Income Tax Act. They say, I'm not troubling your lordship with this. They say the Income Tax Act is not relevant here. It's a separate proceeding. Issue of burden of proof. Lord, in this paragraph, paragraph 13, the first paragraph, from the middle, Lord, at the end, per contra, it is submitted that the initiating officer of the case has successfully discharged the burden of proof casted upon him by highlighting that there is a prima facie case of a Benami transaction where consideration was paid or provided by the unidentified beneficial owner and not the transferee. But what I just submitted. At one place they say it's for the beneficial owner. We have understood who the beneficial owner is. Now they say unidentified beneficial owner. We do not know who the beneficial owner is. And not by the transferee. The burden lies on the Benamida to prove its case. Here, my lord, I'll refer to judgments which say otherwise. Initial burden is always on them. They have to show, they have to discharge that burden.
So you also have to prove the beneficial owner.
I also have to prove the beneficial owner. I've indicated that I am the beneficial owner. But they say you have to indicate who the beneficial owner is. We will not take into consideration your reply. But thereafter, they have set out the provisions of law. Kindly take up, my lord, page 1216.
All these are also legal arguments, Mr.
One paragraph, my lord.
Their admission on that they will abide by the Supreme Court result is immaterial. Even if they don't say that they are bound by the Supreme Court.
Indeed, my lord.
Even we are bound. I mean, actually, we are bound. Obviously, we are bound.
Lordship. 1216.
1216, yes.
Second paragraph, my lord. The above provision again clearly establishes that for initiating the proceedings under the Act, it is not mandatory that the beneficial owner shall be traced. It only states that a notice under the Act shall be sent to the beneficial owner if his identity is known. And then they refer to the judgments. I'm not troubling your lordship with that. Kindly take up, my lord, page 1217.
So?
No, they don't, my lord. In fact, these judgments, I'll refer to these judgments, my lord. Jaidalal Podar is the first judgment that I'll start with. It lays down those 6 ingredients, my lord.
This is the judgments are there in total, you will cite. You start with means that's very ominous.
My lord, there are 4 different propositions which I'll place. My lord, first proposition, there are a lot of judgments.
One judgment for each of the propositions.
My lord,
one judgment for each
yes,
of the landmark judgments.
My lord,
4 propositions, 4 judgments.
My lord, in fact, for the others, I have 1 judgment each on the other propositions. The first one, kindly allow me to only indicate the paragraph for 3 judgments, nothing else. But the first one and the most latest.
If there are 3 aspects to it, they definitely.
Same aspect. I'll indicate the first one, my lord, and the last one. 2 of them. There are many in between. I'll only indicate 2, my lord.
Yes.
And the rest, my lord, only 1 judgments each. They refer to these judgments, and my lord, paragraph 14 is relevant. This is page 1217.
Their admission is important to the extent that they admit that they don't know who is the beneficial owner.
They don't know.
That is there.
Also, the fact that, my lord, in the reply also, they have not taken into cognizance the entire statements given by us in our reply with regard to...
That is a different aspect.
That's also not
they
taken.
Need not. This is not an order.
Not an order.
Reply is redundant.
It is, but my lord, to that effect. They did not know who the beneficial owner is. They don't know. They have admitted that.
Right.
Paragraph 14, contents of this. 37 properties in the... This is important, my lord. Paragraph 14. 37 landed properties were purchased in the name of this petitioner, whereas the consideration has been provided by some other person and getting the benefit from these properties. Thus, transactions are covered by 29A. We have indicated where it comes from, who is the owner, not considered, my lord. Next, it is submitted that the facts and finding of material available on record and the beneficial owner or the person who provided the consideration is not traceable. Thus, the transactions in respect of the properties are also covered by 29C and 29D. Now, they say it is not traceable. Next, my lord. it is to mention that this case, the consideration of the subject properties was provided by some other person for his or her immediate future benefit, and properties were purchased in the name of Krishna Sudama Marketing Private Limited, the petitioner, my lord, and does not fall under the exception of 29A 1, 2, 3, 4 of the Act. Therefore, the properties are Benami properties. Not considered any of, my lord. Paragraph 15. This is with regard to, my lord, the law. I'm not going to indicate that. And share transfer, only one paragraph, the next page, paragraph 16. Income tax proceedings are completely different. Assessment under the income tax proceedings are concerned with the tax implication arising out of the income generated. Earned proceedings under this act are subject to the issue of Benami nature of ownership. Therefore, outcome of income tax assessment has nothing to do with the Benami nature of any asset. This is their
Naturally,
reply.
you're spending so much time on their reply. I would have done the same thing if I were you.
This is where
they've done half your.
They have. That is the reason this is important. They were not required to, but they have done this. And my lord, I feel this is an insuperable, my lord, facts stated by them. They have to come out of this. My lord, my points are, may I quickly indicate the only point in their affidavit in opposition. Only paragraph, my lord. Affidavit in opposition.
How many volumes are there to the affidavit in opposition?
Only one volume.
Yes. They get a brownie point for that. Because you have 7 volumes.
We do, my lord. How many volumes in the opposition? One volume. One volume.
No help there.
My lord, paragraph 7. At page 3.
Oh. Thank you. Yes.
Paragraph 7, my lord. This is the case that they are making out.
Yes.
7A is with regards to the Act 2.8, not troubling your lordship. 7B is provisional attachment order. 7C is, my lord, 24.4, no order passed under 26.3. Here, my lord, they have indicated a document. I'll indicate that. That is 26.1. That's the show cause notice for the proceeding, which is now stayed because of the injunction order, my lord. That's 26.1. So no order is passed under 26.3. That's an important point, my lord, because kindly see page 4, 7D, the last 4 lines. This is their case. Thus, the proper course ought to be to relegate the petitioner back to the adjudicating authority because the 26.1 is issued. I'll show from the Act, I can go to the next stage in appeal only if there's an order under 26.3. That order is not passed. I'm challenging the show cause notice. I'm challenging their jurisdiction to initiate the proceeding. So this is really not, this is not something which is an impediment to the present proceedings. Then 7E, adjudicating authority gives an opportunity of being heard. This is also, my lord, only if there is a jurisdiction. My point is on jurisdiction. I'm not traveling your lordship with the rest of it, my lord. They've referred to a judgment and judgments here in the affidavit, so I'm not reading that, my lord.
So you say that they have not even made out a prima facie case of Benami under the Act. So they cannot assume jurisdiction under the Act.
I bow down.
Basically, that's why they have no
in a
jurisdiction.
nutshell, my lord, that's my case. Now, my lord, in our reply,
you have
affidavit
explained
in
your
reply-
sources of purchase, sources of income for the purchase, own funds or whatever.
Lordship.
One. Secondly, the 6-year-old back transactions, you have produced all documents
Everything.
before the appropriate authority.
My lord.
And they have failed to indicate who is the beneficial owner at all.
My lord.
Let alone the property being used for such beneficial owner.
My lord. That's
so
my
there is
case.
no indication.
No indication.
None of the criteria.
None of the criteria, the jurisdictional fact does not exist, my lord, for
Even
them
as
to
per
assume
their
the
notice, as per their pleadings, none of the fact.
None of
Even if it is taken to their fullest value, fullest extent,
my lord,
they have not established a case under this.
Nothing.
That is your.
That's my case. And also they have not taken into cognizance any of the replies which I have
Yes,
given, and
that
I've
too.
explained my case.
That too.
That our affidavit in reply,
Yes.
paragraph 6 is where, my lord, we have dealt with this paragraph, paragraph 7, affidavit in reply.
এরম জুড়ে দেবে না গো খুলেই দাও আমার খুব অসুবিধা এই দুটো তো জোড়ার কিছু নেই এই দুটো আলাদা আলাদা জিনিস yes affidavit reply
but affidavit in reply, my lord, page 6, paragraph 6. Lord, we reiterate our case here, and this is the only paragraph, my lord, which is where, my lord, we were required to deal with the allegations in the affidavit in opposition. Page 8, the first line, your lordship will find. In fact, page 7, the last 2 lines. We have again indicated it's rimjim. That's a reiteration, my lord, of the case.
Right.
And we have also stated that, my lord, jurisdictional fact does not exist. That's my case in the reply. Only one paragraph.
What's your usual business? Your company's
usual business is, my lord, providing loan, my lord, against interest. The moment the amount comes, we invest in properties.
So that is also a part of your affairs.
That's a part of
investing in
affairs.
properties and all.
Yes, my lord. It's a part of the affairs. Now, my lord, these are my submissions. I'll quickly indicate, my lord, the propositions and the judgments and the relevant paragraphs. I'll not trouble your lordship for more than 10 minutes. My lord, the first proposition is the 6 ingredients which are required.
Mr. Bagh, I'll not take specific notes on this. You put it in.
I will put, my lord.
They are being put on notice, actually. Yes.
May I hand over, my lord,
heads of their arguments?
The copies. Why are these different? Achha. My lord, the first judgment, my lord,
yes,
is a 1974 judgment, Jaidalal Poddar versus BB Hajra. Is 1974.
Did not repeat. I have a copy of this previously heard cited, probably.
My lord. 1974, 1 SCC.
Yes, I
3.
have a copy. Yes.
Only 3 paragraphs, my lord. Paragraphs 6, 7, and 8. 6, 7, and 23, my lord.
6,
7,
and 8.
23, my lord. Not 8. I stand corrected. Paragraph 6 and 7 mainly.
Yes.
It is well settled, my lord. This is paragraph 6.
Right.
It is well settled that the burden of proving that a particular sale is Benami and the apparent purchaser is not the real owner always rests on the person asserting it to be so. This burden has to be strictly discharged by adducing legal evidence of a definite character which would either directly prove the fact of Benami or establish circumstances unerringly and reasonably raising an inference of that fact. The essence of a Benami is the intention. The next page is the intention of the party or parties concerned, and not unoften, such intention is shrouded in a thick veil which cannot be easily pierced through.
Justice Krishna.
My lord, I thought so, my lord. It's not penned by Justice Krishna.
Sakarya.
My lord, it's not penned. It's a part of the bench. It's penned by
that was an induced effect. Unoften, yes.
But such difficulties do not relieve the person asserting the transaction to be a Benami of any part of the serious owners that rests on him, nor justify the acceptance of mere conjectures or surmises as a substitute for proof. The reason is that a deed is a solemn document prepared and executed after considerable deliberation, and the person expressly shown as the purchaser or transferee in the deed starts with the initial presumption in his favor that the apparent state of affairs is real state of affairs, though the question whether a particular sale is Benami or not is largely one of fact, and for determining this question, no absolute formula or acid test uniformly applicable in all situations can be laid down. Yet in weighing the probabilities and for gathering the relevant indicia, the courts are usually guided by these circumstances. And then the 6 ingredients are set out, my lord. The source from where the purchase money came. Here we have explained it's from Rimjim. The nature and possession of the property after the purchase. My lord, nature and possession is with us. The motive, if any, for giving the transaction a Benami color. There's no motive, my lord. It's a part of the business. The position of the parties and the relationship, if any, between the claimant and the alleged Benamidar. Here, my lord, they say we don't know. The custody of the title deeds after the sale. Here, this is important, my lord, because that's why my submission.
Have you annexed any of the title deeds here?
We have, my lord, all the title deeds. And that's why, my lord, the volume, everything. And the conduct of the parties concerned in dealing with the property after the sale. It is with us, my lord. There is nothing, there is no conduct, my lord.
And one of the important factors is also probably that you deal with this landed property.
We do, my lord. And that's also disclosed.
That is your main motive.
That's the main motive. The above indicia are not exhaustive and are and their efficacy varies according to the facts of each case. Nevertheless, number 1, that is the source whence the purchase money came, is by far the most important test for determining whether the sale standing in the name of one person is in reality for the benefit of another. And this, my lord, paragraph 23 is only the fact that in the facts of the case, this is the, my lord, the other judgment which may I refer to, my lord, 2020. This is my lord Mangathai Ammal. Mangathai Ammal, why with Mangathai Ammal versus Rajeshwari and Sons, 2020, 17 SCC 496. I'll hand over a copy. Why are you giving me this academic copy? You don't have a fair copy?
What is the difficulty?
I'm embarrassed. It's written here as academic copy. Milord.
Yes. Discussion is also academic mostly. Yes.
Only the fact, Milord, that this judgment, the reason is, Milord, there are two 2020 judgments. One is, Milord, P. Leelavati. I'm not referring to that. This one, because, Milord, this encapsulates all the other judgments in the meantime. Milord, paragraph 7.1 onwards. Internal page 10, it's 505, Milord. Paragraph 7.1. Jaidalal Poddar is, Milord, quoted there. Milord, the next paragraph 7.2, Bhim Singh is quoted. 7.3, Milord, Leelavati, that's, Milord, the judgment of 2020, the other 2020 judgment, where, Milord, the 6 ingredients have been indicated there, Milord. This is paragraph 7.3. 7.4 and 7.5. In essence, it has been reiterated time and again, Milord.
Difficulty, Mr. Bag, is if you multiply judgments on the same point, it's like a memory game.
Indeed, Milord.
You in the first judgment, it's only the first judgment, the ratio there.
Sure.
Second judgment contains the first and itself, and so on and so forth.
Indeed, Milord.
Third contains 1, 2, and 3,
and
not... so on and so forth. It's like a memory game. So that's the reason why I encourage you not to multiply too many judgments.
No,
I mean,
Milord, it's not
unless there
required.
is something tempting in it, or the language, or something, some landmark.
Gotcha.
I mean, ratio has been laid down. Otherwise, it's a, I mean, wastage of time.
My lord. This, Milord, only encapsulates the other judgments.
Yes,
That's the. But this is on this proposition. The next proposition is, Milord, that admission on law, which they say, if the Supreme Court decides otherwise. Ganpati Dealcom is the judgment, Milord. May I hand over a copy of Ganpati Dealcom? This is 2023 3 SCC 315.
That is on the retrospective.
On the retrospective applicability, saying, Milord, that this will not have retrospective application. Only one paragraph I'll indicate, Milord, that's the concluding paragraph, paragraph 130.
Yes.
The last paragraph, Milord. It has several sub-paragraphs in conclusion.
Right.
In view of the discussion, we hold Section 3(2) of the Act is declared as unconstitutional. That's not our case, Milord. From the third, 2016 amendment was not merely procedural, rather prescribed substantive provisions. Thereafter, Milord, in rem, prospective, that's, Milord, the next, applied prospectively and not retroactively.
Yes.
That's the proposition, Milord. Continue criminal prosecution, court is not. So this is what is held in essence, Milord, that this has prospective application, not retrospective or retroactive application of the law.
Right.
Thereafter, Milord, this is, Milord, I don't know whether I should even submit and, Milord, this before your lordship. Bachayev Gozdar, 1955, Milord, on the point that shareholder of a company cannot be the owner of a company. But that's their allegation.
How is that relevant? I mean,
their allegation is that the original two shareholders, Milord, they walked out and the other shareholders came in through the money, Milord, that they have invested. So they are not taking into cognizance the amount which has flown from RIMJIM. They say the change in the shareholding pattern. The change in the shareholding pattern does not mean, Milord, ownership of the property of the company. There, Milord, I seek to place reliance on Bachayev Gozdar, 1955-27 ITR 1, paragraph 7 to 9, Milord. I'm not placing this judgment. It's, Milord, only a shareholder of a company cannot be the owner of a company. Paragraph 7 to 9, Milord. Then there's a very tempting judgment, Milord. It's also passed in a writ petition. This is my last, Milord, submission and judgment that I'll refer to.
Acha, you cited Justice Pratibha Singh's judgment. This is not relevant.
My lord, that's one of the many judgments, my lord, which I've skipped.
Thank you. Yes. So I'll put it on the back burner.
My lord.
Yes. Yes, cited.
Kalyan Bildmart versus Deputy Commissioner of Income Tax. This is reported in 2021, 131 taxman.com 99. The reason I'm placing reliance on this, my lord, is on a very similar fact situation. It's in a writ proceeding. I'm not reiterating, my lord. It's on the same points, and it's a very short judgment, so I'm not troubling your lordship with the entirety of the judgment, but the relevant parts, facts start from, my lord, paragraph 3, very similar. And at the end, in a writ proceeding, my lord, it was held that this is not a Benami transaction, not a transaction where the provision of the Benami Act could be attracted. It also refers to, my lord, paragraph 30, Ganpati Dealcom and Mangathai Ammal, the other judgments, my lord, on the same point, and comes to a conclusion. In paragraph 47, saying, my lord, the provisional attachment orders are bad in law.
39 is also probably important.
39 is also important, my lord. Very short judgment, only on the reason I'm placing reliance on this is, my lord, the department thereafter did not prefer an appeal. In a writ proceeding, this was decided, my lord, based on jurisdictional facts. And the relevant provisions of the law, may I quickly indicate, my lord, and then I'll rest my submissions. My lord, the Act, if your lordship is pleased to take up once, only the relevant portions, I'll indicate the sections which are relevant. Hand over a copy. May I hand over a copy?
Please do. Yes. Yes.
That section 2 is a definition clause. Administrator.
Give me half a minute. Yes.
My lord, section 2, administrator is an officer under the Income Tax Act. Only for this reason, my lord. Approving authority, again, Income Tax Act. My lord, Benami property, 2.8, means a property which is the subject matter for Benami transaction. So for that, Benami transaction becomes relevant. My lord, that's 2.9a, because they, my lord, initiated it under 2.9a. Benami transaction means a transaction or an arrangement where a property is transferred or is held by a person and the consideration for such property has been provided or paid by another person. Here, my lord, we have paid it. The money has flown from our account. The property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration, except where the property is held by 1, 2, 3, 4. But I'm not troubling your lordship with that. Then B. C. D is again what they...
There's an and between A and B. So even if they establish that you purchase it...
It has to be conjoined, my lord. Both they have to prove.
So even if they say that you have purchased it from the money provided by somebody else,
my lord,
B has to come in.
B has to come in.
Obviously, unless it's a Benami...
Lordship.
Yes.
Then D. Transaction or an arrangement in respect of a property where the person providing the consideration is not traceable or is fictitious. That's what they are, my lord, trying to rely on. That they are not traceable. The beneficial owner is not traceable. But that's on a different fact situation. And this is not applicable in our humble submission, my lord. Then 210, Benamidar, means a person, fictitious person whose name the property is transferred or held, and beneficial owner thereafter, that's 212, my lord. A person, whether his identity is known or not, for whose benefit the Benami property is held by the Benamidar. So they need to indicate that for someone's interest we are holding, they have indicated it. Had they kept it blank, my lord, it would be different. They indicate saying it's in the nature of a beneficial transaction for the shareholders who have come in. That's their allegation. Hence, Bachayev Gozdar, that they can never be the owner of the property. It's the company. The company is a legal entity. You can't allege that because there's a shareholding pattern which has changed of the company, these shareholders become the owner in future. That can't be the allegation because the company remains. As on date, it is the company for future purpose and use of the company. The company is the beneficial owner.
How many shareholders were there initially?
2 shareholders, my lord.
And 2 new shareholders come in now.
My lord, 6 new shareholders came in.
The previous 2 go.
2 previous go.
The only 2 shareholders go.
Earlier were 6. I stand corrected, my lord. Earlier there were 6 shareholders.
All of them go.
They go, 2 come in with 50% shareholding, my lord. But the allegation is, my lord,
Bhattacharya holds true, but Mr. Bagh, under certain circumstances, I mean, if there are only 2 shareholders and between themselves they can choose the director, elect the director, whatever. They can elect the director, they can whatever they have control.
My lord, I think I'm getting wrong instructions. My lord, kindly give me 1 minute. Plus 2 originally, Ahana 1, Ahana 2.
Anyway,
they come in, my lord, as a change in the shareholding. Now we have 2 shareholders. Initiating officer only I want to indicate, my lord, 219 because of the fact that they are all officers of the Income Tax Act, under the Income Tax Act, my lord. Now, my lord, rest 24 is important because that's the notice provision, my lord, how the notice is to be issued. 1 is important because the notice has been issued on a 24-1, where the initiating officer, on the basis of material in his possession, has reasons to believe that the person is benamidar in respect of a property, he may, after recording reasons in writing, issue a notice to show cause within such time as may be specified why the property should not be treated as benami property. Then adjudication.
The company is a benamidar.
Their allegation is company is a benamidar.
Company is a benamidar. So under any circumstance, even if all the shareholders change,
company remains the same, my lord.
I mean, the relationship vis-a-vis the shareholders and the company remain the same.
Remains the same.
Whoever are the shareholders.
My lord. That's my argument. And that is why, my lord, I submit that the nature of the transaction can't really take me out of the ambit and within, my lord, the domain of this act.
No, they're
and
trying
out
to
from
make a very subtle argument probably that if the entire shareholding pattern changes, the control goes over to the new shareholders. So the company is only a facade.
Now there comes the interesting part, my lord, because that they have not been able to indicate also that the money has come in from there. Because, my lord, my case, had it been all through my own funds, which is infused in the company through the shareholding change, my lord, then it's a different issue.
No, apart from the yardsticks not being satisfied, that would lead to probably an absurdity. Because then, if the company is a facade cannot be the benamidar. Benamidar has to be a particular entity, as per this act. So if it's a facade, then it's a set of shareholders, they are purchasing in the benami of some other shareholders.
So the difficulty, the practical...
That cannot be. That's an absurdity because of Bhattacharya.
Because of Bhattacharya. Also, my lord, if this is taken at the, my lord, if it is taken to be true and correct, the practical difficulty which will come is any company which invests and thereafter same logic will apply. And also here we have a better case because, my lord, we have indicated that the flow of funds is not through change of shareholding pattern. It is through RIMJIM. And there is nothing against RIMJIM. And there is also no connection between these shareholders and RIMJIM. So that's not there. That is, my lord, my case.
Right.
And the rest of the provisions, my lord, I am not indicating 26(1), that is a statement, it's the adjudication proceeding. And, my lord, also for companies, 2 provisions, because I do not know whether my learned friend will perhaps indicate this. Section 45, there's a bar of jurisdiction of civil courts, but this, my lord, will not apply. And 46, my lord, is the appellate proceeding, which is only after 26(3). There is no 26(3) in the proceeding.
To 46.
46, my lord. Any person who is against the order passed by the adjudicating authority under 26(3). 26(3) is the order that has not been, my lord, passed yet. In the affidavit in opposition, they have indicated 26(1) notice. That's all. And thereafter, my lord, there is one provision which is offences by companies, section 62. But that does not bring us, my lord, in any way, my lord, related to this matter, the facts of the case. These are my respectful submissions, my lord. This is why they do not satisfy the ingredients. There is no jurisdictional fact for them to assume jurisdiction in the matter. They can't, my lord, proceed with this proceeding. This is my respectful submission.
Arguments of the petitioners is concluded. Full stop. For further hearing in the matter, let the matter stand over till tomorrow.
I'm led by Mr. Kundalia.
When should I keep it?
After 7, my lord, can it be
After?
7?
No, that would be too long. We are in the midst of the matter. Why keep it? Achha, anyway, you'll file your written notes also.
But we will.
Very well. For further hearing, the matter stands adjourned till December 8, 2023.
I'm clear.
That's what it is.
I'm very deeply obliged, my lord, for the
Thank
patient
you.
hearing.
Are you enjoying any interim order? Is there any scope of?
We are, my lord. Further, till further orders, my lord. Very deeply obliged.
একটু বলে দিও।
You come prepared with Achana, they have to argue first.
But the written notes, after we hear them, my lord, will. But I'll start preparing it, my lord.
Yes.
I'll just amend it till the end. It'll be very short, my lord. I'll keep it very crisp.
Thank you.
Deeply obliged, my lord.
What did you say?
Original side matters.
Lordship, this matter was
To be mentioned, item number 1, Mrs. Kedia Finfreight Private Limited and another.
this matter was mentioned.
Yes.
No.
You are appearing in this matter?
Yes. This matter
The
was.
file to the What is the relief sought?
My lord, this matter relates to ED.
ED. What is the relief sought? Let me check up.
Short, my lord, respondent number 2 herein freeze the bank accounts of the 6 petitioners herein, and in order dated 9th October 2023, they continued that freeze impugned order. That impugned order.
Yes. Since the matter pertains to reliefs sought against the Enforcement Directorate, comma, which is a central agency, comma, this court does not have determination to hear the matter as per the roster. Accordingly, comma, due to lack of determination, the matter stands released from my list with liberty to the parties to mention for enlistment before the appropriate bench having a determination. Thank you.
Item number 2, for extension of interim order, OTB Industries Company Limited.
When does it expire, Mr. Bardhan?
30th minute.
Interim order granted earlier is extended till disposal of the writ petition. Affidavits were directed previously?
Yes, but they have not as yet filed.
Let the matter be listed for hearing in the monthly list of February or March. It's running in the list.
Liberty Lordship. There are Liberty Lordship.
Let the matter be listed for hearing in the monthly list of January 2024.
I'm grateful.
Thank you.
Item number 3, court application under Article 226.
Yes.
Is appearing. It's only before short pass over.
Very short pass.
Great.
Other side to pass over. Item number 4, for hearing, Lord's Blue Tech.
But also Mr. Mukherjee is appearing.
No. My lord, in that, this is that matter relating to that OTS proposal. My lord, we are for the auction purchaser.
Oh, yes.
My lord, the bank and the.
So Nagos vehemently.
Yes, your lordship. My lord,
I am appearing on behalf of the bank, my lord.
He had paid 18 lakhs upfront in 2020. Thereafter, the petitioner had filed an application before the DRT and obtained a stay on the premise that they will get a purchaser at a higher price. And from then on, our monies are stuck. The bank is not being able to. And secondly, your lordship, in the meantime, they submitted an OTS proposal at 2 crore 10 lakhs. The OTS proposal was not initially accepted by the bank. Then they filed this writ petition. In this writ petition, they prayed for a direction on the bank to accept the OTS. The OTS proposal was again not initially accepted by the bank, and thereafter, well, on the basis of the orders passed, the bank had accepted the OTS at 2 crores 10 lakhs. Now 2 crores 10 lakhs, they were unable to pay. So what they suggested to the bank by way of a letter is that I have paid 5 lakhs. You have already getting 1.81 crores from
Yes.
the auction purchaser, and the balance 24 lakhs I'll pay. Now we are there in the picture. It is not that our interests are not involved. We are there in the picture. On that basis, the bank had accepted their OTS, and they were supposed to come back with a suggested order. My lord, I'm being led by Mr. Nag.
My lord, I'm sorry for being late, my lord.
My lord, I am appearing for the bank, my lord. I am appearing virtually, my lord.
The bank agrees to that.
No, I'll indicate, my lord. Lordship remembers, rightly pointed out by my learned friend, it was, my lord, 2.10 lakhs, which was fixed for the, my lord, sale of the property.
110 crore.
2.10 crores.
Yes.
Out of which, my lord, we had got it corrected, my lord, in the second order. 1.81 was, my lord, decided. 1.81 was, my lord, to be paid by the auction purchaser. Out of which 10% was, my lord, paid. This was corrected by your lordship in the second order. So initially, my lord, we had proposed that we'll come, after hearing lordship said that please come with a suggested scheme of order. And we proposed that we would pay the balance. Out of 1.81, whatever is remaining, we'll pay minus 5 lakhs, which was deposited by us. Now, we had handed over this, my lord, suggested order. There was, my lord, another understanding between the, I must be very candid before your lordship. 2.60 was the price at which the property was agreed to be sold to the auction purchaser. 2.10 to the bank, 50 lakhs, my lord, to come back to me. I have to, my lord, indicate this. This was the, my lord, understanding.
Understanding between whom?
Because I brought the, my lord, auction purchaser.
Oh, yes.
I brought the auction. I'll show, my lord, from.
You did not bring them?
Yes, of course. They are denying, my lord. Now, my lord, we are, my lord, poles apart. My client and his client.
No, then 2.10 remains. I mean, 2.6 we cannot.
So I'll pay that. My lord, I am only required to satisfy your lordship that in terms of that OTS, bank needs 2.10.
Why isn't the settlement coming through?
Because they are not, my lord, willing now to pay that extra 50 lakhs.
Why should I?
Where does the question of extra 50 lakh come?
So, my lord, the understanding between the auction purchaser
What
and
you
my
submitted,
client.
Mr. Dotto, was on the, if I remember, 2.10 crore was the total sum, the purchase
Yes,
price.
yes.
So out of that 2.10, they'll pay 1.81.
Yes. To the bank.
To the bank.
1.81 to the bank. They also had an obligation to pay the differential amount to my client, which they did not, my lord, it was not required. This was the, my lord, understanding. My lord, there are, my lord.
Don't honor it, then.
If they don't honor it, my lord,
it cannot be.
It cannot happen. At least to this auction purchaser, possibly I am not interested. I am, my lord, I have a buyer who is willing to pay, my lord, 2.10 to the bank.
Now we cannot reopen that now.
No. We are not
Lordship,
doing that.
I am only inviting your lordship to decide whether, my lord, the repudiation, the rejection was correct or not. And in this scheme, lordship felt that.
So we'll have to hear the matter on merits then.
No, I am only saying today, my lord, instead of, my lord, the bank only needs the money. I have a purchaser. My lord, I was required to bring in the purchaser. Even in DRT, I had brought him.
But Mr. Dotto, you cannot ventilate your own stand, I mean, against them.
I am not trying to do that. I am only.
50,000, we cannot go into that even. 50 lakh or 50 what?
I am not inviting your lordship to go into that. My lord, today I can, my lord, succeed only if I demonstrate that the bank in terms of the OTS receives the money.
No, then there is no settlement.
No settlement.
No agreement.
No.
So we'll hear the matter.
Lordship will hear it, my lord.
Yes. Okay.
My lord, I'm for the bank, my lord. I'm appearing virtually, my lord. I'm very sorry, my lord. I couldn't appear this moment, my lord.
Yes, very well. So there is no.
My lord, if the bank is otherwise ready and willing to accept 2.10, and there is, my lord, from my client, then, my lord, this can go through. If bank is ready and willing to accept, my lord, 2.10, kindly seize the suggested order which I had proposed.
No, the bank has a copy of this.
Yes. He had corrected it, my lord. I will give both.
My lord, give a copy to Mr. Nag also.
Yes, I will.
Because they have to.
My lord, kindly seize. First, there is, my lord, the one with the underlines. Lordship may look at it, my lord, after I show my suggested order, the one which I had proposed.
No, if you agree to the second suggested order, then we can.
No, first suggested order, kindly seize once. Only what
that
I
is
want.
Not the suggested order, agreed suggested order. That's not an agreed
So
order.
the second one is also not what is agreed, but I want to show my bona fide what I, my lord, suggested to the bank. Kindly seize
What
that.
is questioning a bona fide on the settlement?
Because I propose that I will pay either through myself or through my nominee the 2.10 crores. 5 lakhs bank has, I will pay
Doctor,
the balance.
either there is unqualified agreement between you and the bank,
My lord, on
which
two,
will not affect them in any
yes,
manner.
on two
They'll pay only 1.81.
No,
Then they cannot say that they have.
My lord, they are today not in the picture anymore.
Right. If
They are today not
if
in
the
the picture.
settlement is that they have to pay only 1.81 crore, then there cannot be any affectation of their right.
No, they don't. My lord, I am not concerned with the auction purchaser today. I am not concerned with the auction purchaser. I say on 2 points, date of payment and amount that the bank requires. There is bank and my client is ad idem on that. Bank says that this is the time within which you have to pay and this is the amount that you have to pay. I agree to that. Now, how I am going to pay that? This is upon me. Either I pay it myself or I pay it by my nominee. Yes. My nominee can be any other third party. Yes. And bank will only convey the property.
If the bank agrees.
If the bank agrees. This is what I had proposed. My lord, bank says no.
Bank is not agreeing.
No, bank says, my lord, kindly sees the stand of the bank now. And it's, I don't know why bank is doing this. Bank says, no, you have to sell it to this person.
This person?
Yes. At 1.81 only, you have to sell it to
they
this
have
person.
entered into the sale has gone through up to a particular stage.
No. The sale, my lord, kindly sees the order, my lord.
There was an agreement between this.
There was no agreement. There was an order. Kindly takes the writ petition once, my lord. Kindly comes to 2 orders.
Page 32, my lord.
দেখাবো আমি Page 32, my lord.
Yes.
My lord, kindly sees the 3rd paragraph. Counsel for the SARFAESI applicant submits that the present valuation of the property is more than 8 crores as per their valuation. In fact, this was my principal bone of contention before the DRT. As per their valuation, whereas bank's valuation is much lesser than the valuation, there is a wide variation of about...
applicant means the
your client. Client. Much lesser than their valuation, there is a wide variation of about 7 crores. If the tribunal permits, he can also bring a buyer who will purchase the property at a better price than the reserve price of the bank. Heard counsel for the parties. On hearing submissions, tribunal granted 10 days time to the SARFAESI applicant to bring a prospective buyer who can purchase the property at a better price. So this was, my lord, liberty was granted to me. And this is, my lord, when, my lord, I entered with him, my lord, my lord, we, my lord, discussed and agreed.
You got him within 10 days.
My lord, I kindly sees the next order, my lord. They were represented through an advocate. That was the understanding, my lord. Now, my lord, they are not honoring the understanding, and that is why, my lord, this is failing.
Next order is after...
At page 34.
That is after 9 months.
Yes.
Because of COVID. Not
my lord, it's March 2020, COVID. The first order is March 2020. The second order, lordship, looking at page 34, 8th of December 2020. Kindly sees the second paragraph, my lord. Advocate Mr. So-and-so appears for the respondent bank and submits that rupees 1 crore 81 lakhs has been received from the purchaser. My lord, it should be, my lord, lordship had corrected it. It's 10% of 1 crore 81 lakhs. Advocate Mr. So-and-so appears for purchaser pressing IA, praying for vacating of the order dated so-and-so passed by this tribunal. Advocate Mr. So-and-so submitted that the status quo order may be continued till the next date of hearing. Status quo passed earlier stands extended till the next day. So I was given the liberty to bring in the purchaser. I, my lord...
That liberty cannot be reopened now.
No.
What you are saying, you want to bring a new purchaser, new nominee, whatever name you give it.
No, I am not on that today. I am only saying...
Position cannot be reopened.
No, so I had brought him initially...
They remain. They have to remain now.
My lord, they don't have a right. Because otherwise also, if I... Lordship visualizes it in this manner. If I fail in this writ petition today, what is the effect? Effect is the DRT proceeding is still pending. There is a stay on the sale. Status quo order, the one which I am showing, my lord, that is still continuing.
What you are saying, Mr. Dutt, that could only be done by the DRT itself. If this position, because they have already paid a particular amount.
Unless bank says that bank is only willing to accept the money, bank is not concerned who is paying
bank
the money.
Has a point there. Bank is not wanting to result from that understanding with them.
Why, my lord, if I may ask this question to myself, there must be some reason why bank is insisting that this purchaser has to be conveyed the property. It's my property, my lord. The more the value I realize from this property.
It cannot be an open-ended thing. You cannot be given time till infinity to do.
No, I said, my lord.
This exercise was complete in 2020.
Yes, but
now in 2023 you cannot reopen. Then whenever it happens,
my lord, I am not
you shall bring another purchaser.
No, I am before this court, my lord. Whatever happens will happen before this court. If it is to happen.
Not in the writ jurisdiction, Mr. Dutt. If it was a suit, I could have understood. If it was a question of a company sale, yes, auction sale of a company, yes, I could understand. Because the price fetched would have some bearing on the workers also and on the other creditors. But this is not such a scenario. This is a private debt. you are to repay that. You are given an opportunity to bring within 10 days. You took some time during the COVID period. Somebody was brought and an agreement, an understanding was reached. They paid a particular sum of money. So for the sake of propriety, it cannot be kept open-ended forever. 23 today, suppose it happens, again the same exercise will be repeated, and in 2026 probably you will come up again and say
My
that
lord,
no.
keeps it pending 2 weeks time, I'll pay entirety to the bank. Lordship can record my submission. 2 weeks, Lordship gives me, I pay entire money to the bank. And if I don't pay, Lordship dismisses my writ petition. Yes. Bank is only concerned with the money.
Bank is ready.
And bank was, my lord, ready, my lord, when I initially proposed.
Entire means what amount?
My lord, it be 2.10 minus 5 lakhs. 5 lakhs, my lord, I have, minus 5 lakhs, my lord, it would be 2.05 crores, my lord. 2 weeks time,
Then
Lordship
it has
gives
to be more than the price being, I mean, more than 2 point.
No, it was always 2.1. My lord, they had suggested 1.81, but the amount, OTS amount was 2.10. So, my lord, 2.10 I have to pay. 5 lakhs I had paid. 2.05, my lord, is remaining. My lord, they will get back their 10%. I will pay 2.05. My lord, how can the bank today stand in the way if, my lord, I can demonstrate that the OTS should not fail?
And bank is agreeable to that.
Bank was agreeable to that in the sense, my lord.
Mr. Dato, OTS is being extended courtesy the bank.
Yes,
OTS
absolutely.
was 2.10 was to be paid. You have failed that.
Yes,
Now,
timelines I had failed.
Timelines you had failed.
I had
so
failed.
OTS you
But
cannot insist on the OTS.
Lordship remembers my principle. What was my challenge? My lord, I had come at a stage, or I had approached the bank at a stage when bank was not willing to accept the modality of payment. I had suggested that, look here, I am not in a position to pay this 2.10 out of my own source of fund. I proposed that please allow me to sell the property, any balance or any shortfall amount, I'll pay out of my own source. Bank said, no, you cannot do this. Either you do it by paying it from your own source, or you adopt the sale mechanism prescribed in the SARFAESI Act. Now, I challenged this decision, and Lordship felt initially that banks should only be concerned with the money. And I did this not after, my lord, the time period had expired. I proposed this when I had sufficient time. Within that OTS time, 20 days time was given. My lord, on the 14th day, my lord, I had proposed this. And bank gave a reply after 1.5 months and then said, no, your time had expired. Then prima facie, Lordship felt, yes, banks should only be concerned with the money. Lordship gave us this option that you please try and work it out. Now, this is the situation. Man, I have been very candid to your Lordship why, my lord, this is failing. Now, Lordship, today, if the bank is getting the money within the time Lordship directs, my lord, I don't see why bank should refuse.
Bank is ready with the time also 15 days.
Kindly, my lord, ask the bank's advocate whether he is ready. His
No,
client
their
is
interest will be affected because they were under an order of the tribunal. They have deposited a particular sum. After that, it should not be
My lord, that
judicial
was
propriety.
the
My
order.
lord, may I make some
Order does
submissions,
not
my
say
lord?
that it was.
Let us hear the bank on this. Yes. Yes, what do you
My
say?
lord, my contention is, my lord, today, my lord, the purchaser has already paid me 10% of the value, my lord, that is 18 lakhs or 18 lakhs rupees, my lord. My lord, today, my lord, the petitioners are coming with a new proposal of making a payment of 2.10 from whatever sources they have. Tomorrow, my lord, if the proposed auction purchaser comes and files a case against me, because, my lord, that amount which is with the bank of 10% is not getting any interest from that. It's just kept, my lord, in terms of the court's order. Now, my lord, the respondent number 2 tomorrow will come and file a case against the bank saying that you have kept my money and you have not given it to me. Then, my lord, the petitioner will be not there to, my lord, protect the rights of the bank. Now, my lord, in this process of the petitioner, my lord, the bank is in a suit that and bank.
If your only concern is the interest of that on that amount, then probably Mr. Dattu will be agreeing to paying that interest also. Well, I mean, don't be
My
so.
lord, if my lord, in any case, my lord, the bank was not.
Don't worry. Yes. Yes, Mr. Vasu.
My lord, in any case, my lord, the bank was not agreeable to take a 2.10, my lord. It's only with my lord order, my lord, I have compelled them, my lord. In such a situation, in a dicey situation like this, my lord, the bank is also in a position, my lord, where, my lord, the bank also does not have any other alternative to just abide by my lord's order. Whatever my lord thinks, my lord. I can't, my lord, the bank sitting here today is losing from this way, from the interest also, and also from, my lord, the principal amount.
Let us hear the.
One of the petitioner has been playing like this, my lord, for a long time.
Right. Mr. Nag, satisfy the court that a right has been created in your favor.
Not only that,
my lord, there was a, this is not he who bought me. There was an application for auction.
So we are not going on that.
I'm now, my lord, page 32 order was passed ex parte.
Hmm.
Now, my lord, I have filed an application for vacating of that order before the court, that is pending before DRT. Now, my lord, Supreme Court in a judgment clearly said, my lord, the right of an auction purchaser, that has to be decided by the Debts Recovery Tribunal. So, my lord, my application is pending. I'm going to cite the judgment. So the lease is now before DRT. And my lord,
So now do you fall within the purview of auction purchaser?
Yes, yes, I am. Yes, I am. I am the successful auction purchaser. I was supposed to pay when, my lord, an ex parte order was passed on page 32 without hearing me.
A formal auction purchase was, auction sale was held and you...
In my favor. Now I pay 10%.
So where was the question of auction purchase? It was an understanding. You came up with the money.
No, lordship sees.
You say, they say they have brought you.
No. Auction is going on next day. He will provide details of sale. It is under a surface sale. It's a surface sale, my lord. Whatever he has portrayed, I don't know. It was, my lord, under Surface Act, there was a sale advertisement. I, my lord, participated that I was the, my lord, H1, my lord, the highest bidder. And, my lord, I paid 10%. I was supposed to pay amount at that juncture, and ex parte interim order he got. My lord, auction notice also I have. I can hand it over. My lord, it is a Surface Act. Then, my lord, what happens? When, my lord, I went there, and, my lord, next page 32, when the first occasion I went there, I made a prayer for vacating. And such prayer of vacating on that day was not acceded to by the Debts Recovery Tribunal. Now the question is, my application for vacating is pending before the Debts Recovery Tribunal. Now, my lord, whether I have a right, my lord, there are few issues that is to be decided. Whether, my lord, the sale was perfect under the Surface Act or not, that has to be decided by the tribunal. Whether I have a right or not, that has to be also decided by the Debts Recovery Tribunal. And that is the judgment of, my lord, Agarwal Trade Corp. Here, my lord, clearly the Supreme Court says, my lord, kindly have a look at, my lord, the judgment reported in 2018-1, Supreme Court cases 626. Page 30, 33 and 34 paragraph.
Page 30?
Paragraph 30.
Paragraph 30.
30, 33 and 34 I am going to rely. The auction purchaser, may I place it, my lord?
Yes, yes.
The auction purchaser, appellant herein, is one such person who is aggrieved by the action of secured creditor in forfeiting the money. Here the question was forfeiture of my money in sale. The appellant therefore falls within the expression any person as specified under the section 17(1), and hence is entitled to challenge the action of the secured creditor before the DRT by filing application under section 7 of the 17(1) of the Surface Act. Now kindly come, my lord, 33. In the light of the foregoing discussion, we are of the considered opinion that the writ court as well as also the appellate court were justified in dismissing the appellant's writ petition on the ground of availability of alternative remedy of filing application under 71 of Surface Act before the tribunal. The tribunal concerned to challenge the action of PNB forfeiting the appellant's deposit under such, we found no ground of interference in such and such, is granted liberty to file an application. So that is the realm of the DRT. And, my lord, my right whatsoever, my lord, it may be, my lord, I have a right or whether I don't have a right.
Can you give me the date of the auction sale?
Yes, my lord. I can hand over, my lord. It was publication made on January 22, 2020, on the basis of that, my lord, I applied, my lord, in the auction process.
When did you apply? Do you have the date? Or what was the date of the auction sale?
Date of the auction sale was, well, kindly grant me a moment, March 3, 2020. And EMD was, well, 18.15 lakhs, which was deposited. May I hand over just that to the auction sale and public.
This is there, my lord, at page 31, lordship will find it's actually possibly, my lord, not legible. Enlarged version, lordship may look at it. Page 31, I have annexed it, my lord.
Now, my lord, the second point of law which I want to urge before your lordship
Now, my lord, whether bank accept, not accepts, my lord, if there is concluded contract, concluded OTS, of course, my lord, the writ court has the right. My lord, if not, my lord, in two recent judgment of the Supreme Court has very clearly and categorically said, my lord, in case of OTS, my lord, the writ court should not interfere when there is, my lord, there is no addendum between the parties. Now, my lord, here, not only me and bank, but also there is, my lord, there are three parties who are fighting amongst themselves. 2022 target. Now, the first judgment which I want to rely on this issue. First judgment is State Bank and of Arvind Electronics.
So, Mr. Nag, on 3rd March 3rd of March 2020, when the page 32 order was being passed, you were already, that was the date of the sale also?
Yes, I have.
You had put in the AMD and you had certain accrued rights.
Right, I have.
One. Secondly, they were given an opportunity to bring a purchaser within 10 days, which they did not.
I say that order is illegal order because that was passed without hearing me.
Illegal, they did not do that. They could not do that.
Could not do
that. The next stage is page 34, where also it is recorded that you have deposited a part of the amount, but they never brought any other purchaser at any point of time.
No. And as a matter of fact, to add to your lordship's malady, under SABYASACHI Act, their right is only the right of redemption, which now, my lord, ceases when, my lord, a sale notice is issued. So they cannot claim any right in respect of the property after the sale notice
Have
is
you got that Supreme Court judgment?
Yes, I have in my tab, my lord, but...
No, just give the citation.
My lord, may I interject once, my lord, before lordship proceeds? My lord, since this is troubling your lordship, I think, my lord, I must disclose one document before your lordship proceeds further. Without that, because apropos lordship's query, that document would be very relevant. Because lordship wanted to know whether I could bring a purchaser in terms of that order or not.
Nothing is recorded in the order.
No, it's not recorded. But one document, I'll give them a copy. Kindly, my lord, keeps it.
If it was not given the seal of the tribunal's order, then I won't look into that.
My lord, it was, my lord.
Whether you could bring a purchaser or
no,
not.
It was between my client and his client.
No, not only that.
My lord, it was an understanding between my client and his client post that order. That document would be necessary, my lord. Gives
that
me one
would not
opportunity.
be a subject matter of this DRT proceeding.
No, why I could not or I did not bring, my lord, a purchaser?
Not on that even. I mean, there's nothing on record to show that you brought any, because they had an... Anyway, let us hear them, complete hearing.
Now, my lord, here lordship was, which my lord lordship was, my lord, wearing, my lord lordship.
What is the citation?
Judgment, my lord, I have the download copy.
What is the name of the parties?
Oh, my lord, kindly, may I hand it over? It would be better for your lordship, my lord. This is the judgment.
Citation.
Wait, purchase online. আমার কাছে ডাউনলোড করে কপি কোনটা কোনটা বেরিয়েছে না Yes, that is reported in, I got that. 2023 SCC online, SC 1209. So, they cannot have any right over the property as of today. Their right gone, when the sale notice was issued. So, this is the second part. And third, I want to submit the whether there is settlement. Court, now it is well settled. The court cannot, read court cannot, enforce settlement. Now, on that regard, my first judgment is, State Bank of India, Arvindra Electronics, reported in 2023, 1 SCC 4540. Relevant paragraph is 19 to 25. Whether it was bona fide on their part. No, 19 to 25. I am going to rely. Lordship is 19. In the present case, in the sanction letter, such and such, it was specifically provided that the entire payment to be made by such and such. The schedule to make payment under the installment was also mentioned. It is an admitted position that the borrower did not make payment. due and payable under the OTA scheme on or before the date mentioned in the sanction letter. The prayer of the borrower for extension of 9 months came to be rejected as far as back on such and such, and the borrower is directed to make such and such payment. The borrower failed to make payment. At this stage, it is required to be noted that during the pendency of a writ petition, that where there were as many as 3 different OTS floated by the bank, and the bank offered the respondent borrower to settle the outstanding payment under OTA scheme. However, borrower did not opt for any of the scheme. By the impugned judgment and order, the High Court was granted further such and such time, which was beyond even the time prayed for such and such. As observed above earlier period of 8 to 9 months was short in the year such and such. Even otherwise, the right, as rightly submitted on behalf of the bank, directing the bank to reschedule the payment of OTS would tantamount to modification of the contract, which can be done by mutual consent under Section 62 of the Contract Act. By the impugned judgment and order rescheduling the payment under OTA scheme and granting extension of time would tantamount to rewriting the contract, which is not permissible while exercising the powers under Article 226 of the Constitution of India. Then, my lord, kindly skip 33. Then, my lord, 24. The submission on behalf of the borrower that in case some other borrowers the time was extended is concerned, the same is neither here nor there. The bank mutually can agree to extend the time, which is permissible under Section 62 of the Contract Act. The borrower, as a matter of right, cannot claim that though it has not made the payment as per sanctioned OTA scheme, till it be granted further extension. As a matter of fact, there cannot be any negative discrimination claim. The borrower has to establish any right in their favor to claim extension as a matter of right. In view of the paragraph 26, for the reason about the impugned judgment order is set aside. Now, my lord, kindly also another judgment following this was also, my lord, passed by the Honorable Supreme Court, reported in 2023, Volume 2, SCC 805. My lord, kindly takes paragraph 4, 7, and 14. The issue was, my lord, paragraph 4. Mrs. Such and such, learned senior advocate appearing on behalf of the appellant herein, has vehemently submitted that the High Court has materially erred in issuing a writ of mandamus directing the bank to positively consider the application of the original writ petitioner for grant of OTS, which according to the learned counsel appearing on behalf of the bank could not have been passed in exercise of power under Article 226 of the Constitution of India. Then, my lord, kindly skip these paragraphs and come to, my lord, paragraph 7, my lord. Paragraph 7. Yes. Paragraph 7, my lord. Here, my lord, the OTS scheme was stated. Then,
Paragraph 14 with surprise.
yes. Paragraph 40, my lord. The sum and substance of the aforesaid discussion would be that no writ of mandamus can be issued by the High Court in excess of power under Article 226 of the Constitution of India, directing the financial institution bank to positively grant OTS to a borrower. The grant of benefit under OTS is always subject to eligibility criteria mentioned under the OTS scheme and the guidelines issued from time to time. If the financial institution is of the opinion that loanee has the capacity to make payment, and the bank is able to recover entire loan, the bank would be justified in refusing to grant benefit. Ultimately, such direction should be left to the commercial wisdom of the bank whose amount is involved, and it is always be presumed. This is my, so, my lord, this is my submission. Now, today, my lord, at present, my lord, Lordship sees, my lord, here, now the claim and counterclaim are pending before TRT for adjudication. Whether either sale was correct or incorrect, whether sale, my right is established or not, my lord, everything is now to be adjudicated before that. Now here, my lord, what he is praying that I am nobody and a writ court can pass order, my lord, in pendency of all the application. I think, my lord, this legal argument is not tenable in law. This is my submission, my lord. Kindly dismiss this
Yes. Reply, Mr. Datta.
My lord, on the judgments, my lord, none of these judgments, my lord, on facts of this case would be applicable. My lord, these judgments say that the writ court in exercise of power under 226 will not issue a mandamus directing bank or compelling the bank to enter into a notice. That is one. Second, extending the time for, my lord, payment. My lord, what is my challenge here? My lord, kindly comes back to one document once in the writ petition. Page 53.
Yes.
Second paragraph. Well, they are writing this letter, kindly marks the date 30th of January. Please note that in accordance with terms and conditions specified in the letter, OTS sanctioned by Exim Bank has expired on so and so and is yet to receive the settlement amount. Kindly turns the page, comes to para 4, page 54. It may be noted that the auction.
Yes.
I'm sorry, my lord.
No.
It may be noted that the auction of the land located at so-and-so was conducted by Exim Bank as part of recovery action under SARFAESI. Since action under SARFAESI is legal in nature and OTS is a mutual agreement between Exim Bank and LBCPL, that is my client, combining two actions for settlement of account cannot be considered under the current regulatory guideline. This is, my lord, under challenge before your lordship. I am today not seeking, my lord, the prayer for, my lord, directing the bank is not my primary prayer. My lord, my prayer is maybe a consequential relief here. I am challenging this document on the ground that bank cannot propose or cannot suggest that this modality of repayment will not be accepted. I write to the bank, my lord, proposing this when it was, my lord, within the validity period. Lordship will find that at page 50. I had written it on 6th of January. My time was to expire, that 20-day period which was granted. Lordship may first take note of page 50, my letter, 6th of January. And the 20-day period which I was granted under the OTS at page 46 was to expire on or before January 16, 2023. So I did not have any malafide intention. I proposed that this is the mechanism or this is the modality in which I am going to pay the 2.10 crore. Bank refused it on 30th, beyond 16th of January. I am challenging that document here. So the principles which have been discussed in these judgments, well, writ court cannot extend timeline, writ court cannot direct or compel bank to enter into OTS. We have crossed that stage, my lord. If I succeed in my challenge to this document, my lord, and if lordship feels, yes, modalities can be, my lordship can direct in what way, my lord, the bank is to be paid. Kindly visualize this situation from another angle. My lord, SARFAESI Act section 1313 contains a self-injunction, my lord. This is in the nature of a self. The moment, my lord, 13.2 is being issued, there is an injunction on the property. Even if I bring a buyer, even if I have a purchaser who is willing to buy the property, my lord, I still have to approach the bank. I have to propose that this is the mechanism. Please give me that liberty to do it. Either there will be a court injunction or there will be, my lord, under 1313 statutory, my lord, the restriction is there. My lord, I only propose that.
Mr. Datta, what remains of your application before the DRT after the sale notice was issued as per the latest judgment cited by Mr. Nag? I mean, you don't have a right of redemption.
There will be a question of valuation of the property. My lord, my principal challenge was undervaluation. I had, lordship, I read that order, my lord, 8 crores or 7 crores is what, my lord,
yes,
we said, my lord, is the value of the property. My lord, today I am a borrower who is saying that I will pay the bank. I only propose a mechanism to pay the bank. Bank is saying no because of this, or my lord, auction purchaser says I have a right. My lord, the other judgment which which my learned friend is, my lord, relying upon, kindly just take a look at that judgment factually. What was the stage at which the, my lord, auction purchaser's right was recognized? Kindly comes to, my lord, the second judgment 2023, third judgment 2023, 1 SCC 540. My lord, kindly takes paragraph 2, my lord. State Bank sanctioned cash credit in favor of respondent so-and-so. In 2012, account of borrower was classified NPA. Bank came out with a OTS dated so-and-so. OTS specifically provided for making payment as settled under OTS scheme within 6 months from the date of sanction. Bank sent OTS offer to borrower for OTS and ledger outstanding as on so-and-so was rupees so-and-so. Amount payable under OTS was so-and-so. Borrower accepted the OTS offer and deposited amount of so and so with the bank. Bank sanctioned OTS and confirmed receipt of 1.40 crores. Under the sanctioned OTS, borrower was required to deposit 25% of the OTS amount by so and balance amount to be deposited within 6 months from the date of letter up to 21st May with interest. Borrower was informed that on non-payment of the amount within the time stipulated under OTS, OTS will be rendered infructuous. Borrower deposited amount of 4 crore 51 lakhs 45,000 on 31st December 2017. That is beyond the timeline. And then again on another, my lord, tranche on 21st May 2018. Time was, my lord, till 21st December 2017. Borrower deposited these amounts. Borrower agreed to or committed to pay 3.50 crores on so and requested extension of 8 to 9 months for repayment. I am not here, my lord, with this kind of prayer. I had, my lord, approached the bank within the validity period. Here, my lord, the borrower defaulted the OTS terms itself. Then, my lord, paid beyond the terms.
So let us come back to page 46, the terms of the OTS.
Yes, my lord.
Because you say you came within 20 days. Let us see whether you came within the fold of this OTS within 20 days.
Very well, ma'am.
We have to see page 46, page 50 for that.
Yes, madam.
46 says that within 20 days, you have to pay the entire settlement amount, which was to the tune of 2.10 crore. Within 20 days, you came. Let us see what you had to pay that amount.
Madam, that is at page 46 itself.
46 itself.
Yes.
Now let us come to page 50 is probably your
my letter.
Within 20 days reply to that.
Yes, yes.
So what change did you suggest?
My lord, kindly sees second paragraph.
Second paragraph.
As you are aware, company is facing extreme financial difficulty and has no source of income at present. We would like to suggest that agreed OTS amount, that is so and so, be realized by approving sale conducted by bank in favor of successful auction purchaser.
So the moment you say that, don't you deviate from page 46 because you had to pay the amount by 20 days.
I am still, my lord, in
you
page
are seeking
50.
a modification of that.
I am still, my lord. This is what I am on.
It's not payment, because if it's through a sale, it's not a payment by
That
you.
is what, my lord, the bank has also said. And if lordship feels
I'm
that,
putting that question
yes,
to you.
if
I'm
lordship
not
feels
feeling anything right now.
no, then, my lord, I understand.
I become inert during argument. But
No,
this is
yeah.
a question which is valid.
Yes,
I mean, they have raised a valid question.
Kindly sees
How
the
do you
next.
answer this?
Kindly sees the next paragraph. Bank will receive a total amount of 1 crore 81 from the said auction purchaser towards the sale amount, and remaining amount of 24
That is
lakhs
not important, Mr.
will
Dutta.
be
What is
paid.
important is you
Payment.
have to pay. You have
My
to
lord, now
pay.
when your lordship is
To
considering,
pay a settlement amount and to suggest that let it come through a sale are
well,
different.
at the end of the day, it is payment to be made to the bank.
So then you are seeking a modification in the OTS terms. OTS is a contract, then the judgment becomes germ in the Supreme Court judgment.
My lord, OTS is a contract.
Yes.
And OTS said payment has to be made within such and such date, and this is the amount. I only propose that I will make this payment, but this is the manner in which I am making payment. Now, manner of making payment, whether it is, my lord, really altering the OTS terms, because I am not saying I will not pay 2.10. I still say I will pay 2.10. I only propose a mechanism, and I inform the bank that I am out of source of fund, my own source of fund. Therefore, I am proposing this. Now, this is my submission, my lord. Lordship may not, my lord, be.
Would that be done within 20 days? A sale to be conducted?
My lord, just one
My lord,
submission.
if this was agreed upon, it could have been done. My lord, it's my client's bad luck that it was not done, and therefore I am before your lordship.
My lord, just one submission, my lord, before my lord, Mr.
My lord, these are my submissions, my lord. If I, my lord, this is the manner in which I proposed. It can be still worked out, my lord. I leave it to your lordship. If lordship feels 15th
I'll put
of
that
December.
in my final order. I'll put that in my final. I'll decide the writ petition. If I decide against you, there is no question
But
of
my
that
submission, my lordship will kindly take record of this.
Yes.
15th of December is my on instruction I am submitting, by which I can pay this entire 2.05 crores.
So whenever I pass my final order, you are willing to bring a fresh purchaser within 2 weeks from that.
No, my lord. This is
You'll
my
pay off the amount.
2.05 within 15th of December is what I can pay to the bank.
That's a down payment.
No, entirety.
That's a payment.
Yes, payment.
Payment through some sale. Like page 50.
My lord, through nominee.
Through nominee.
My lord, bank is only my lord, bank is only, my lord, interested in the money.
By check or
I can pay the money.
Bank has been interested since 2020, Mr. Dutta.
My lord, what lordship is possibly feeling is that I have to have the money in my account. I have to, my lord, issue the draft.
Now, yes.
I have
in
to
2020, I would not have said.
My lord, my lord, if lordship is, my lord, insisting on that, I can, my lord, insist that insist my client to do that also, my lord, so that, my lord, I can save my property. Lordship gives me 2 days time to take this instruction. Kindly don't reserve it today. Gives to be mentioned Friday.
No.
I will take only this instruction. Lordship wants payment to be made. I'll try and, my lord, persuade my client that this is the arrangement.
How can my right, my lord,
There is a
be
difference.
override? My lord,
Irrespective of his rights, whatever, Lordship.
I
because
don't
he-
understand.
Yes, you are going to say something, Mr. Basu, the last.
Yes, my lord, I will just, my lord, just show my lord 2 pages of the writ
What do you
petition.
want to say? Tell me, Mr. Basu. Give me the page
My lord,
number.
page number 46, as my learned friend has pointed out, my lord, there was a 20 days payment validity, my lord. Kindly, my lord, sees the next clause of that in that page, my lord.
Yes.
Clause number 4A, my lord. They were, my lord, supposed to write to us within 7 days or for non-acceptance or anything of the OTS, my lord.
They were.
Which they have done on 6/1, my lord, which is after at least, my lord, just before the end of the 20 days, my lord. So, my lord, in any case, my lord, the bank has no liability to, my lord, answer the letter once he has rejected the proposal of the OTS. And, my lord, there is one more submission, my lord. This property is mortgaged to us, my lord. And now, my lord, today, if they say that they want to sell it to someone else, my lord, then it's a huge procedure that the bank has to release the mortgage, even if, my lord, there is, my lord, orders for release of the matter. And then, my lord, again, my lord, it's a whole procedure, my lord, which the bank has to go through. So, my lord, just leaving the, my lord, we have to just release the mortgage and then again reassign it to someone else, my lord, is a tedious process to do.
to sell to this party also, he has to release the mortgage. So that should not be.
No, we have to just issue the sell notice to a confirmation of the sale to him.
There is
a new process.
There is a status quo order, my lord. He cannot.
That is a different thing.
No, that is a different issue.
Hard-learned counsel for the parties. Hearing is concluded. Full stop. Before parting, comma, it is recorded that learned counsel for the petitioner, comma, on instruction, comma, submits that the petitioner is agreeable to arrange for nominating a third party for payment of the entire amount of rupees 2.10 crore. Full stop. That's this.
Ready to pay.
Thank
Ready to pay. My lord, one correction, my lord. Lordship had recorded nominee. My instructions are ready to pay.
Yes.
Ready to pay, because I am not getting the chance of coming back on Friday because Lordship is reserving it. So I asked him to take instructions. Lordship, on instructions, my lord, I am submitting this. Ready to pay.
Yes.
And then Lordship decide whatever.
Ready to pay 2.10.
Yes. To bank.
Yes.
That is what my instructions are.
2.05, my lord, not 10.
2.05 because 5 bank.
Last sentence কি বললাম? এই অ্যারেঞ্জ ফর তারপর কেটে দিয়ে অ্যারেঞ্জ ফর থেকে কেটে দিয়ে অন্য জিনিস অ্যাড হবে। অ্যারেঞ্জ ফর বাকিটা কেটে দিয়ে অ্যারেঞ্জ ফর পেমেন্ট অফ দি এন্টায়ার ব্যালেন্স অ্যামাউন্ট অফ রুপিস 2.05 crore in terms 05 crore in terms of the OTS, comma, to the bank.
Grateful, man.
Thank you.
My AOR is insisting that I should record objection to this submission.
Comma the extra to which you have been added as a party.
Yes, yes, yes.
I have added it previously, or I'll add it by the previous line.
Yeah, I have added.
Comma the to which an objection is raised by the
It's you to the respondent number 2 option. No, no.
very good. Respondent number 2 stroke auction purchase.
Prospective option.
Purchaser stroke surface applicant.
No, no, not. They are not such.
Oh, no,
We are the
they are the
surface
respondent.
I'm
Thank you.
grateful.
Yes. Pass on.
না 2 না 3 সেটা
Paswa matter, item number 3. Dilip Singh Mehta.
My lord, we've served, my lord.
Yes.
We've maybe filed the affidavit of such. Can you do
ওটা নতুন ম্যাটার? Yes.
Yes, my lord, may I file the affidavit of service, my lord? It's been served.
Yes.
My lord, the petitioners numbers 1 to 4, my lord, are trustees of a charitable trust, my lord. The charitable trust, my lord, runs educational institutions. My lord, there is, my lord, a technical education, nursing, my lord, masters in business administration, hotel management and engineering. It has, my lord, recognition, my lord, granted recognition by the All India Council for Technical Education, National, the Nursing Council of India. And my lord, all this, my lord, education is, my lord, conducted, my lord, in, my lord, an institution set up in Durgapur. My lord, there are, my lord, it's set up, my lord, on 25 acres of land. My lord, there are 3,000 students, of whom 2,500 are day boarders and 500 day scholars, and 500, my lord, are, my lord, boarders, my lord, and they have close to about 200 staff, my lord, who are also, my lord, engaged. My lord, it conducts both undergraduate and postgraduate, my lord, courses. My lord, it's fairly reputable. It started, my lord, several years ago. And, my lord, the immediate urgency, my lord, why we have come now, my lord, before your lordship is, my lord, the 8th of December, my lord, 2023, my lord, are the semester examinations. And, my lord, salaries, my lord, provident fund dues, electricity, third-party vendor, statutory dues, insurance dues, my lord, all have to be paid, my lord, to, my lord, the relevant persons. Because, my lord, this is, my lord, really a challenge, my lord, to, my lord, an action, my lord, of Yes Bank, my lord, which is, my lord, in effect, my lord, not only wrongful, but, my lord, has held, my lord, the educational institution, my lord, to ransom. My lord, we had, my lord, taken a loan facility, my lord, from Yes Bank on.
The degree of service you have filed.
Yes, that's what I filed, my lord.
Yes,
Sorry,
right.
My lord, service, my lord.
Yes, let us go.
My lord, 19th of April, my lord, 2013, my lord, where, my lord, there were, my lord, 2 term loans. My lord, we have never defaulted, my lord, in making payment, my lord, within, my lord, due time, except one occasion when there was a 9 days delay. But, my lord, it was, my lord, cured, my lord, and, my lord, there, my lord, was, my lord, an overdraft facility also for 5 crores, which has never been overdrawn. My lord, your lordship's familiar now, my lord, we've done a few matters on, my lord, master circular,
Yes.
my lord. So, my lord, it's never, my lord, been an NPA. Now, my lord, in fact, during COVID, my lord, there was a general, my lord, restructuring done in case of, my lord, several, my lord, similarly situated, my lord, institutions. There was a revised payment schedule. So, my lord, what was initially a 125 crore loan, my lord, has, my lord, today, my lord, come down to 60 crores. 14 ton, my lord, and, my lord, after the last payment which we have done, my lord, of 14 crores in terms of, my lord, a consent granted by them, it's come down to approximately 45 crores. And time to make the payment, my lord, is till 2030. My lord, it has, my lord, not, my lord, expired, and I am, my lord, on schedule. My lord, there has been no problem. Now, my lord, the hostel, my lord, which we, my lord, owned, my lord, the property, my lord, had been mortgaged to the bank. Now, my lord, a decision was taken, my lord, because during COVID, my lord, where, my lord, our revenues, my lord, were, my lord, about 3.3 crores, etc., my lord, from, my lord, hostel, my lord, had fallen drastically. And it was difficult, my lord, to maintain. Now, there are several operators, my lord, of, my lord, hostel facilities. So, my lord, we spoke to one of them, who, my lord, were willing to manage the hostel, but buy it off us, so they would own it. And, my lord, we would, my lord, give them, my lord, an assured, my lord, income by, my lord, having our boarders, our students, my lord, stay there and nowhere else on an exclusive basis. My lord, this was the arrangement. So, my lord, since it was mortgaged, we needed the consent of the bank. My lord, we went to the bank, and, my lord, a no objection, my lord, was given. My lord, my lord, we applied on 11th of September, and, my lord, the conditional no objection was given on 29th. My lord, what it said, my lord, was that, my lord, out of the, my lord, proceeds that we received, my lord, 14 crores would go and be adjusted towards, my lord, their dues, their outstanding, my lord, on account of principal, and, my lord, there would, my lord, be, my lord, permission then granted. So, my lord, we accepted that position. My lord, we, my lord, sold the property. My lord, property, my lord, was sold, and my lord, 14 crores, my lord, was also adjusted. All this happened, my lord, in October 2023. My lord,
What was the condition of the no objection?
yes, my lord, may I just show that, my lord, because that is, my lord, the most important document. My lord, page 198. My lord, kindly take page 198 on volume 2.
Yes.
My lord, my lord, kindly have a look at clause 3. My lord, minimum of INR 14 crores to be paid for reduction of facilities from the total sale consideration. And my lord, 4 is very important. There are no overdues in the account of NSHM. That is, my lord, the petitioner. So, my lord, there was no overdues.
This was a condition. There were actually no
overdues. My lord, recorded. Then, my lord, kindly take 5. Balance amount post reduction of facilities. So, my lord, 14 crores we pay them. Must be routed through account bearing so and shall be utilized for upgradation and renovation of the campus facilities, statutory compliances, and any other expenses for educational institution as per the details submitted by NSHM to YBL. Any amount of money from balance amount of the above required would be directly released from the account of so to the vendor's account on submission. So, my lord,
it had to be channelized through Yes Bank.
My lord, all
and
through.
for these purposes.
Yes, my lord. And my lord, we have never had control, my lord, of the funds. There is an escrow account. My lord, whatever we earn goes in there. My lord, from there, my lord, what happens, my lord, is, my lord, what we need to run, my lord, goes to an expense account, also maintained with Yes Bank. My lord, we give, my lord, the details where salaries have to be paid, bank pays out. My lord, we don't get to, my lord, collect the money and then pay. It's all done, my lord, on our, my lord, requisitions, but directly, my lord, by the bank. Similarly, insurance premium, everything. And, my lord, a particular part of it, my lord, is also adjusted towards repayment, my lord, of the loan, which includes interest as well for servicing, my lord, of the loan account. My lord, this is how it's done. I, my lord, really have, my lord, even no checks are issued by me. My lord, it is all digital and, my lord, directly, my lord, given to the concerned beneficiary. On us, my lord, giving, my lord, the requisitions. These are the bills raised. And, my lord, it's consistent. The same heads of expenditure month by month, my lord, is going on. So, my lord, this is, my lord, the picture. So, they gave this. Now, my lord, not only that, my lord, the sale which I was to have, my lord, required, my lord, me, my lord, to give, my lord, a, my lord, guarantee. That minimum guarantee, my lord, is what I'm going to provide to the hostel. My lord, a particular number of students, my lord, would be boarders there. So, my lord, now, my lord, that guarantee also, and this is very important, my lord, your lordship kindly sees page 204. On 16th October, my lord, we write, my lord, at the bottom, my lord, 204, the last mail, my lord, the last line. 16th October, kindly turn over, my lord, the page at 205. You are requested to kindly confirm the format of the bank guarantee to be issued to, my lord, CLSPL is the person buying, my lord, the hostel, as discussed in our last meeting. They were made aware that we had to give a guarantee, my lord. It's like a minimum guarantee, my lord, income to, my lord, the hostel owner, my lord, when they operate, my lord, and the hostel can be used by others as well.
No, bank guarantee was to be issued. BG.
Yes, my lord, I had to give a bank guarantee in favor of the purchaser.
Right.
Because, my lord, if I didn't fulfill
that,
my lord, he could, my lord, recover it. My lord, to secure, my lord, my minimum guarantee. Now, my lord, kindly see what the bank writes. Again, kindly come back to page 204. My lord, 18th of middle, my lord, in the middle, my lord, the date is there, 18th October. This is the bank, my lord, which is, my lord, sending this out. And it says, dear sir, please find attached the vetted text. So, my lord, they vet the text and kindly come to the track changes they make, 206.
Yes.
Now, whereas an amount of rupees 3,82,68,000 equivalent to 100% of the minimum guaranteed revenue for the academic year 2023-24 as per the revenue agreement dated blank entered into between NSHM and beneficiary required to be paid to the beneficiary by NSH as per clause 4.1 of revenue agreement. So, my lord, it refers to a revenue agreement which I am entering into, my lord, with my lord the beneficiary, which is my lord CL, and my lord 4.1 is a clause. Now, kindly come to, my lord, thereafter, therefore, my lord, whereas, and then therefore we, yes, bank, so and so, so and so, so and so, which expression shall, unless repugnant, assigns hereby affirm that we are guarantors and responsible to you. And kindly see who it is being addressed to. Curated Living Solution, CL, my lord. On behalf of NSM, and we hereby irrevocably and unconditionally and absolutely undertake to pay you upon your first written demand declaring NSHM Academy to be in default under clause 4.2 and without cavil any sum within the limit of without your needing to prove. So, my lord, this was the unconditional bank guarantee, my lord, which had to be issued by Yes. Again, it's from Yes Bank account, my lord. This is, my lord, the guarantee, my lord, which is given. And, my lord, your lordship will find 207 further, my lord, details, my lord, are, my lord, that further track changes, etc. Now, my lord, the revenue underwriting agreement, I just want to show your lordship 4.1 and 4.2, my lord, which is referred to. My lord, it's, my lord, the agreement starts, my lord, your lordship will find at page 208, 19th October, my lord, after having obtained, my lord, all these, my lord, now kindly have a look at E, a master agreement, my lord, page 212, recital E, my lord, page 212.
Yes.
A master agreement dated 19th October has been executed between the trust and the proprietary company, my lord, property company, that's, my lord, CL, pursuant to which it was agreed inter alia that property company would purchase the student housing assets and provide housing facilities as per its commitment as contained therein. And the trust agreed upon the express condition that the trust shall offer students of NSHM Academy on an exclusive basis to reside at and utilize the student housing assets, and B, trust shall ensure that hostel fees payable by students studying or seeking admission into so and so and availing so and so to reside and availing housing facilities entirely, and if any amount is inadvertently paid to the trust, then the trust to deposit the same to the account, and C, to underwrite for an agreed period on annual accounting basis the revenue of so and so in a manner wherein if the annual cumulative revenue of the student housing is other than due to justified reasons below minimum guarantee revenue for the concerned year, trust shall service the shortfall by infusing funds from so and so. So, my lord, this was the security which the trust had to provide. Now, kindly come to 4.1, my lord. My lord, 218. Offer and minimum guaranteed revenue. That's the heading, my lord. Your lordships kindly have a look at it. The trust shall offer students of NSA to use the student housing assets as a hostel to ensure that the property company receives the minimum guarantee revenue from student exclusive. Trust shall start offering students and ensure that property company starts receiving along with so and so in respect of student. Then 4.2. If property company does not receive minimum guaranteed revenue in respect of any calendar year for any reason other than justified, trust shall contribute funds to meet the shortfall of minimum guarantee from academic revenue of NSHM. Kindly mark the words or from any other sources. The account shall be reconciled within 31st and the payment shall be made. Now, my lord, 4.4, my lord, is, my lord, the annual guaranteed revenue shall be and escalate as per table below. So 2023-24, the guarantee which was being given was 3.83 crores. My lord, it's mentioned and it goes this way. Now, my lord, what happens? My lord, after all this is done, my lord, we ask them for funds and then we have, my lord, a situation, my lord, where, my lord, a request for payment is made by us, which is at page 313, on 2nd of November. because, my lord, we write to them. My lord, the bills I'm not troubling your lordship with. There's no dispute with regard to the quantum of the bills. My lord, 313, my lord, volume, my lord, the next volume, volume 3. My lord, we write to them, 2nd of November. That's page 313. Kindly see, as you're aware, the hostel deal went through on 19th and our account was duly credited by a sum of 24.75 crores. As per usual practice, we had sent a requisition for disbursement of expenses of so-and-so on 20th by mail as also hard copy along with so. Admittedly, the banks were closed from so-and-so. Since 25th till date, banks have been operational on working days. Then 5, despite the above, the extremely critical payments listed out in our mail dated so-and-so, while having sufficient funds in our account, have not been released, causing extreme distress and prejudice. For ready reference, following payments were covered in our statutory payments, TDS, Provident Fund, gratuity coverage, premium, including death benefit claim, inclusion for which so-and-so was 31st, electricity bill, critical payment to vendors, employees of their respective and legitimate dues, and, my lord, then we, my lord, 314, second line, they tried calling, nobody picked up. Then subsequent to prepayment of, we have a clear balance of more than 10.85 crores dispatched to bank has failed to process. Then note that even after having sufficient, having informed to deduct interest, the banks have not yet done the same. Regretfully, this is not the first experience and the past such incident where we had to escalate a grievance on a number of issues, etc. Then, my lord, we gave also, my lord, an advocate's letter, my lord, which is at page 315. My lord, your lordship will find, my lord, that kindly come to 318, my lord, penultimate paragraph, that apart as per usual practice, another letter was addressed to the bank with supporting documents seeking release. In order to meet such letter was neither responded to nor acted upon. Another requisition for disbursement of staff salaries to the extent of so-and-so was made on 3rd, which has not met with the same fate. So, my lord, bank now, my lord, decides, my lord, to sit quiet. We, my lord, also make a representation to, my lord, the Reserve Bank of India, my lord, apropos this, my lord, which is at page 31. My lord, I should have shown that. 316 is to, my lord, the Reserve Bank of India, and 315, my lord, I'm sorry, this similar letter, my lord, which was issued to, my lord, the institute. That you are silent, you please release all this money.
What
now,
is the plea of the bank? The
yes, now, my lord, kindly have a look.
Yes.
The bank, my lord, then writes, my lord, volume 3, page 326. 325.
Yes.
My lord, they took, my lord, 4 clauses, my lord, 4 points, which I may just paraphrase and I'll show your lordship. My lord, first is, look, when you entered into this revenue guarantee agreement, you did not disclose clause 4.2. You suppress 4.2. Second, you are an NPA. Third, hostel MGR is too high. So what have we done now? We have now adjusted the entire sale proceeds, which is, my lord, 24 crores, 12,99,000. Instead of 14, which was, my lord, the conditional no objection, this is what they've done. My lord, your lordship will find that, page 325. My lord, we had given them the sale agreement, revenue underwriting agreement, everything. Then, my lord, they write in this connection, my lord, this was dated 19th October. We invite your so-and-so. Then NSA never disclosed that providing such an assurance and commitment about so-and-so. My lord, I've shown the bank guarantee where they, my lord, look, my lord, included clause 4.1. My lord, saw, my lord, 4.2. They're fully aware. Thus, it is evident you have suppressed material while persuading the bank, equally that you would contractually agreeing and undertaking to service minimum guarantee from academic revenue. And, my lord, they are in control of the funds. My lord, I am not for a moment, my lord, impinging, my lord, on any right of theirs, because if they decide not to, the clause says, or any other source. Now, my lord, kindly have a look at the next page. And the same person, my lord, this is very important, as my learned junior points out, my lord, the person who corrected it in track mode is the author of this letter. Same person, my lord Ankit Tulsian. And all the emails your lordships will find is exchanged with Ankit Tulsian for vetting. Now, my lord, they said you did not obtain prior approval in writing, etc. So, my lord, first is because you have suppressed, my lord, this clause is prejudicial to bank because our rights are being affected. And second, my lord, you have concealed, my lord, this fact, my lord, from the bank, you should have had a consent. Then, my lord, kindly come to page, my lord, NPA, which is, my lord, mentioned here, my lord, at 326, third line, and taken its prior approval before making such contractual commitment in favor of property company, the bank is not in a position to dilute its exclusive right over receivable as the account of NSHM is already classified as non-performing asset in terms of so-and-so.
You deny this?
Absolutely, my lord. The master circular says, my lord, for a term loan, we are concerned here only with a term loan. My lord, there has to be, my lord, where your lordships corrected my argument, my lord, in the latest judgment, OTB. My lord, I had calculated 90 days.
Oh,
your lordship said it has to, my lord, even if my argument was right, it had to be in excess of 90 days. Because that's the language, my lord, of the circular. My lord, I've annexed, my lord, a copy of that circular also.
What sort of an interim relief are you?
My lord, because, my lord, the institute is now finished. So, my lord, first is, my lord, a stay, my lord, on this, my lord, letter. I wrote back. I've written back as well, my lord, at page 328, 27th of November. My lord, there has to be, my lord, a stay on this, and they have to, my lord, release funds for the purposes of, my lord, all, my lord, which are mentioned, my lord, in my letter of, my lord, 15th of November. My lord, then, my lord, there'll be no examination, there'll be no intake of students, my lord, and my lord, salaries of staff will not be paid, my lord, health insurance, my lord, won't be, my lord, premium won't be serviced, my lord, staff is suffering, my lord, I don't want anything in my hand. As per usual, my lord, practice, my lord, whatever I have requisition for, my lord, they should, my lord, release. And my lord, now, my lord, fees, my lord, are also going to be deposited. I've said that. In fact, my lord.
So, Mukherjee, as per the agreement with the bank,
yes,
the bank was to go on disbursing regarding the hostel.
No.
The entire thing.
Yes, entire thing. My lord, I had, my lord, since I had to give a guarantee to make the shortfall, my lord, I had requested, my lord, for this bank guarantee. And now they say, no. You have suppressed 4.1, 4.2. Now we are realizing it. When, my lord, the track changes are by them, my lord, in the guarantee.
Extraordinary.
And, my lord, your lordship struck down, my lord, declaration of NPA if it's not in terms of the master circular. My lord, my lord, OTB, then there's another judgment as well of our High Court. Yes, in February.
The petitioner has made out a strong prima facie case for the writ petition to be heard on merits. First up, it is argued by learned senior counsel appearing for the petitioner that the petitioner took 2 term loans from the respondent bank within bracket Yes Bank bracket closed in the year 2013, which were being regularly serviced. First up, subsequently, since the petitioner was under financial duress during the pandemic period, the petitioner entered into an agreement for transfer of the hostel of the institution in favor of third parties, with a prior conditional no objection certificate being obtained from the bank for release of security interest over the boys and girls hostel concerned. First up, next para. Several conditions were stipulated in the said no objection certificate, all of which have been complied with duly by the petitioner at all points of time. First up, subsequently, the petitioner also furnished a bank guarantee through the Yes Bank itself, where all the relevant clauses of the agreement with the third party were disclosed to the bank. First up, in fact, the relevant clauses of the revenue underwriting agreement were clearly indicated in the bank guarantee provided by the bank, comma, which was also corrected from the end of the bank. Subsequently, comma, by doing a volte-face in that regard, comma, the bank issued a letter dated November 22, 2023, vindicating its withholding of the money which the bank was required to clear for all the expenses of the petitioner on certain grounds which are apparently not tenable in the eye of law. As for example, comma, it was alleged in the said letter that the account of the petitioner is a non-performing asset, comma, which is in contradiction with the relevant master circular of the RBI on income recognition and asset classification. Income recognition, caps diye diye, income recognition and asset classification. Full stop. Next para. Secondly, comma, the bank alleged that clause 4.2 of the concerned agreement was suppressed, comma, which is contrary to the materials disclosed in the writ petition itself. Full stop. Next para. Thus, comma, it prima facie appears that the withholding, that the refusal of the bank to honor its commitment to the petitioner by withholding the concerned amounts for the expenses of the petitioner is contrary to the agreement between the bank and the petitioner, as well as dehors the law. Full stop. Accordingly, the writ petition shall be placed for hearing in the monthly list of January 2024. Full stop. Next para, the respondents shall file their affidavits in opposition by 3 weeks from date. Full stop. Reply, if any, shall be filed by the petitioner on the next returnable date. Full stop. There shall be during pendency of the writ petition, comma, there shall be stay of operation of the note of the communication dated November 22, 2023, within bracket annexure P16 at page 325 of the writ petition, and the respondent bank shall remain restrained from acting in terms of the same. Full stop. Further, comma, the respondent bank shall continue to disburse as before, comma, all expenses of the petitioner in terms of the agreement between the petitioner and the bank, comma, also during pendency of the writ petition. Full stop. Next para. However, comma, it is made clear that the said disbursals made by the respondent bank shall be subject to the outcome of the writ petition.
My lord, only one thing. My lord, your lordship said that they have issued the bank guarantee. My lord, in fact, my lord, I have a better case. My lord, after seeing this, suggesting the track changes, my lord, they have not undertaken that liability yet done this. The bank guarantee finally has not yet been issued. So I can't even ask Yes Bank to pay. So none of their rights, my lord, are being affected.
So they agreed to issue or what?
They agreed to.
একটা জায়গায় ব্যাংক গ্যারান্টি ওয়াজ ইস্যুড বলেছি, আপনি একটু দেখে নেবেন। ব্যাংক গ্যারান্টি ওয়াজ ইস্যুড, was agreed to be issued by the Yes Bank। এই নাম্বারটা দিয়ে দেবেন, আমি পরে দেখে।
I'm grateful.
Affidavit service shall to be kept under.
Yes, my lord.
Yes. Petitioners.
Yes, my
plural
lord.
হবে ওটা।
5.
Great.
Review application. Item number 5. Swapun Kumar Dotto versus State Bank of India and others.
My lord, I appear on behalf of the petitioner.
Yes.
My lord, learned counsel Mr. Jishnu Chaudhary is appearing in the matter. My lord, he is unavailable. Your lordship will kindly take up the matter tomorrow.
5, 6 and 7.
No, your lordship.
One submission.
Yes, sir.
4 and 5. Well, there were a series of applications, writ petitions before your lordship challenging declaration.
5, 6 and 7.
5, I'm so sorry.
Yes, yes.
5, 6 and 7, challenging declaration of willful default.
Right.
Now, my lord,
By a common order, my lord, these were all disposed of. My lord, there were about 4 or 5 writ petitions, all disposed of, my lord, and writ petitions were dismissed, interim orders were vacated. Against that, my friends preferred an appeal. In the appeal court, my lord, they have from time to time gone and said that we want to go back and file a review petition, and my lord, that liberty was granted. So, my lord, these leave to withdraw, so to speak, and file the review were taken at different points in time. So, my lord, item number 5, my lord, was taken first. So, in item number 5, the pleadings are complete. My lord, I cannot tell your lordship that, my lord, the issues are
complete in where?
Item number 5. Before your lordship.
In the review. Where?
In the review. But, my lord, 6 and 7, my lord, are appearing for the first time today. I was wondering, my lord, and I don't know, my lord, I don't think Mr. Chaudhary is asking for any interim order because, my lord, in review.
My lord, we are already enjoying an interim order.
My lord, as far as
Yeah.
I am led by
My lord.
not.
I am here, my lord.
It's only not.
Who is?
6 and 7, I'm led by Mr. Bose. Mr. Bose is appearing virtually.
Well, I am here, my lord.
Mr. Bose is appearing. He's appearing
Well,
virtually.
I am.
For an interim order, then I'll oppose, my lord. And otherwise, my lord, I was saying that the affidavits could be complete and I can file, my lord, within the next, my lord, 7 days, and it could be taken up together, all of them.
Mr. Bose, are you insisting upon an interim order?
Well, Lord, I am, my lord, because your lordship is seen. Your lordship has already been told in
You are
item
asking
number
for that
5.
then?
Lordship.
Mr. Bose, then let us come back tomorrow.
Very well.
Mr. Chaudhary is asking for
Very
time. 5. There will be a conflict of decisions.
Very well.
Let us come back
No,
tomorrow.
I'll tell. Well, there will be. May I just say this, sir? In item number 5,
Yes.
well, Lord, there were total 5 writ petitions. Well, Lord, 3 writ petitions were placed in was 7, 5.
The line is getting disrupted. We cannot decipher what you are saying because of the
Well, this is.
electronic disturbance.
Well, I am told that there is some. Yes, there's some jammer in the High Court area, so none of the network in the High Court area is working.
This sentence could be heard in its
There's
end.
some because of some.
Only your legal arguments we are not getting. The last sentence.
Perhaps that's his best
Well,
point. He's not heard because, my lord, I will be praying for dismissal, but.
Mr. Bose, let us come back tomorrow.
So the dismissal. Well,
Very
very well. I'll come back tomorrow. I'll come back.
An adjournment is sought on behalf of learned counsel appearing for the petitioner in RVWO 33 of 2023. Push-up. Since the said matter is connected with RVWO 48 of 2023 and RVWO 49 of 2023 and the connected applications, comma, let all the matters stand adjourned for the day and be taken up tomorrow under the same heading. Please come back tomorrow.
Well, may I just seek one indulgence?
Yes, Mr. Bose.
Since item number 5 is a hearing matter, could it be placed after item number 6 and 7? Because I will be praying for an interim order, which is already there in item number 5.
Record in item number 5.
But subject matter of challenge are the same orders, but my lord, I stand Same on- order.
Mr. Bose, let us come back tomorrow. We'll decide there.
Very well.
Thank you. If Mr. Chaudhary is not prepared tomorrow, you come prepared.
I'll argue.
We'll have to. Yes. Thank you. Very good.
Item number 8 with item number 9.
Probir Mojumdar, Justice Probir Mojumdar, your lordship recollects.
Yes.
It was always his practice, my lord, to make sure the senior will sit, the junior will argue.
Yes, Mr.
Always his practice.
Absolutely.
Being completely unaware of this practice, I came, my lord, the first day, my lord, holding Mr. Pratap Chatterjee's coattails to be told that please start. and as usual, Mr. Chatterjee was, my lord, even worse prepared than I was. I was prepared, but I was nervous. Mr. Chatterjee was no question of ever being prepared in any matter, my lord. So, my lord, and he was very angry that you don't.
Because
know the
neither
practice of
nervous
this.
nor prepared.
Neither nervous nor prepared.
Right.
Mother, item number 8 and 9, mother, I will be praying for not this week, mother. Because, mother, in this matter, mother, I am being led by Mr. Bachawat, mother, in this matter, mother.
I'll be for the bank, my lord.
A similar matter, your lordship
I
has
would.
already disposed of.
I am not standing in the way quite naturally, but I beseech your lordship to record an order to that effect. My lordship keeps it.
On the prayer of learned counsel for
Yeah,
the petitioner, the matter is adjourned till December 4, 2023. এই সেম অর্ডার আলাদা করে দুটো ম্যাটারে
Deeply applied.
two orders, Mr. Naik. Separate orders.
I could possibly use this later. They'll be coming to extend the interim whatever.
Oh.
Not necessarily just.
Right.
Item number 10.
Yes,
I
Mr.
got the petitioner, my lord, in this item 10. My lord, this is application for restoration of my lord petition. My lord, there is a delay of 49 days, your lordship. I'm applying for condonation of that delay. And my learned friend has no objection, but he's standing.
He's apparently, his body language says he's objecting.
My lord, he's a friend of mine.
Why it should be allowed?
My lord, there's my reason is quoted at my lord, page number 3, your lordship. Page number 4, my lord, paragraph 3, your lordship.
In view of sufficient grounds having been made out in the restoration application, comma, GA1 of 2023 is allowed, thereby recalling the order dated June 26, 2023 and restoring WPO 139 of 2021 to its original file and number. Full stop. Let the I have determination regarding the main writ petition also.
My lord, this is of. At that time, your lordship, that I think my lord determination, certain cases were transferred there, my lord, to his lordship.
Petition be listed in due course next week.
Grateful. My lord, I'm grateful, your lordship. I'm grateful. My lord, sorry, I'm appearing online, my lord, due to that. My lord.
If you appear physically, you should be sorry now.
My lord, I'm grateful.
Norms, yes.
Appearance need.
Item number 11.
Not
Jagadish Prasad Kanu.
Not today.
Item number 12.
Yeah, I appear for the petitioner, my lord.
Yes, Mr. Ali.
Here, Lordship, I have challenged a demand notice by the IRCTC. I do not find anybody on the other side.
Have you served notice on the other side?
Lordship, they were appearing. Previously, this was called also. They were appearing. Lordship, I would recall I mentioned this for an early hearing, Lordship. Today also, we received a demand notice from IRCTC.
What is your case? I'm just open your case.
The case is, Lordship, I have been awarded contracts with respect to 5 trains for running catering services in those trains. Lordship, as per the catering policy 2010, during the regime of catering policy 2010, I was awarded the contract. Thereafter, the new catering policy came and they had revised, Lordship, the tariff of the menu. Lordship, there are 2 revisions. One is the license fee. Another is the tariff for the food. The tariff for the food is fixed by the railway board. The railway board has got exclusive authority to fix the tariff of every tea and etc. I cannot charge.
This is the 2023 tariff.
The tariff is as per I think 2016 CC60.
The catering policies of
2019. No, Lordship, 2019 the fees the tariff was revised.
All right.
Actually, thereafter nothing happened. 2023 they said that in view of the revision of tariff in 2019, the license fee has to be correspondingly, it has to be increased, and giving a retrospective effect from 2019. A huge demand of 4.8 crores had been levied on us. 60 lakhs had already been deducted from my other account, which was running. Lordship, that is why, Lordship, the urgency. Lordship takes it up. I shall give them a notice today. Lordship, Mr. Bachawat, I understand, is for IRCTC.
Well, I'm appearing on behalf of IRCTC.
Why retrospective effect?
Well, Mr. Bachawat sir will be appearing in this matter, my lord. He was online, my lord.
Come back tomorrow, sir.
Tomorrow, if can some precedence be given.
কালকে কিছু fixed আছে কি? একটা fixed আছে. One matter is probably fixed.
After the fixed matter, মানে?
তাহলে fixed matter বলতে second item করে। Although the একটা order record করেন. Although the matter is taken up for hearing, comma, due to paucity of time, the same cannot be concluded today. So moreover, comma, an adjournment is sought on behalf of the IRCTC. Let the matter stand adjourned till adjourned for the day and be listed fairly at the top of the list tomorrow. Fairly at the top bolte after the previously fixed matters. Probably second or third item. Please inform Mr. Bachawat that also.
Grateful.
I'm grateful. Thank you. Okay.